everybody. Hi, everyone. Sam, can you please turn off your video feed? Good to see you. Great to see you. But right now, the audience is looking at you. Okay, thanks so much, Sam. Hi, everyone. So good to see everybody. Could you please turn off your videos and please remember to turn on your mic and video when we get started with your panel. Otherwise, the audience is looking at you right now. Thanks so much. Hi, everyone. So good to see
Good morning, everyone, and welcome. It's with great excitement, gratitude that I'm honored as the Interim Dean of the University of Kentucky, J. David Rosenberg College of Law, to welcome you to today's important event, Say Her Name, Breonna Taylor, a day-long symposium. This extraordinary event, led by Professor Blanche Cook, is a credit to the work, compassion, passion, dedication, and experience of so many of our panelists, our moderators, and others behind the scenes. But first of all, I have to begin by commenting on the vision, the passion, the intellect, and the dedication of Blanche Cook. Professor Cook has created an extraordinary program. All of you who are participants and those of you who are viewing the program have much to look forward to today. Professor Cook's dedication to the issues of criminal and racial justice raised by the killing of Breonna Taylor are instrumental in instructing us and leading us and informing us about how we can move forward together. Important events today, important programs today for all of us. I'd like first to thank all of our panelists. We have wonderful colleagues from the University of Louisville, from Northern Kentucky University, and all across the country. Some of the University of Kentucky faculty are here. We welcome you. We thank you for your dedication and your experience in sharing that with us today. All of our moderators are students of Professor Cook, and thank you for your energy and your dedication to these events today as well. We know that events like this take a number of people to create, to implement, and to provide for you. We have wonderful professionals here at the University of Kentucky Rosenberg College of Law, and I need to thank a number of them. I may not get everyone, but I do need to thank in particular Angelica Procopa, our Director of Philanthropy, who helped facilitate use of this webinar system. Our IT department, Derek Rockhill, Adam Davis, and Nick McKinley. Our Central Campus IT professionals helped us as well, including Franklin Johnson and Lisa Bramall. We also have a wonderful events manager, Alyssa Thornton, wonderful communications director, Shantae Hopkins, and our senior assistant dean for community engagement, operations, and diversity, Danny Murphy. All of these folks and others I'd like to thank for their participation in helping Professor Cook create this wonderful program for today. There's so many things to learn, so many comprehensive ways in which we can understand the circumstances of the incident involving Breonna Taylor. And I simply want to say again, thank you to all of you. Welcome to all of you. This is going to be a comprehensive, important, sometimes difficult day. And I hope that you take away from it all the important lessons that Professor Cook is providing for us. And I thank you again, and I welcome you to Say Her Name, Breonna Taylor, a day-long symposium.
Good morning, everyone. My name is Ashley McPherson, and I'm a 1L student here at the university. And I'm here to lead our moment of silence before our day-long symposium begins. And as we continue to grapple with the legal issues that surround the needless death of a young woman, we here at the University of Kentucky J. David Rosenberg College of Law must take a moment to recognize the humanity of Breonna Taylor. In too many instances, she has been placed on trial. The intimate details of her life have been paraded. And most importantly, she has been denied full recognition as a human being entitled to all the rights and privileges of every human. Please join me in a moment of silence to recognize the humanity of Breonna Taylor. Thank you. Up next, I would like to introduce my esteemed colleague, a fellow 1L for the first panel. Her name is Shabri Woods, and I hope you all enjoy the day-long symposium.
Hello, ladies and gentlemen. On behalf of the University of Kentucky J. David Rosenberg College of Law, I want to welcome you to our day-long symposium, Say Her Name, devoted to Miss Breonna Taylor. We have the honor and privilege of hosting some of the best legal scholars in the nation. Miss Taylor's family's attorneys, Representative Attica Scott, legal experts and practitioners, activists, and law school students. We are a public institution dedicated to serving the public. My name, once again, is Shabri Woods, and I am a 1L here at University of Kentucky. Please join me in welcoming our esteemed panel. Panel 1 will be focused on the substantive issues. We have attorney Sam Aguiar. He's the attorney for Breonna Taylor's family. We also have Professor Michael Mannheimer from Northern Kentucky University, Chase College of Law. We have Professor Sam Markison from University of Louisville, Brandeis School of Law. We also have Professor Leslie Scott from Detroit Mercy School of Law, Professor Mitchell Crusoe, the Henry F. Benora Jr. Professor from Loyola New Orleans College of Law. For more information about our panels, we have their bios on our registration site, or you can go to law.uky.edu/BTbio. We want this to be as interactive as possible, so we welcome questions from the audience. We do have a Q&A feature, and we will save about 10 minutes at the end to get to those questions. I will now turn it over to Professor Leslie Scott, and she will start off the panel by providing a broad overview of the law.
Hi, everybody. Thank you. It's so very good to be here. And I just want to kind of start by thanking Professor Blanche Cook, who's a good friend of mine, for pulling this all together. It's such an important symposium. I want to thank the students who have volunteered to be moderators and the University of Kentucky College of Law for hosting the symposium. And finally, my fellow panelists. I really look forward to engaging with everyone and having a good conversation. So I'm going to start out, as Ms. Woods said, by talking about some of the substantive statutes, the homicide statutes, and just briefly touching on justification. I think my co-panelists are going to talk more about justification, but I'm just going to give an overview of the law. And to help to do that, technology is not always my friend, but I'm going to attempt to share my screen here. And if it doesn't work, that's okay. I'll just talk. I'm getting a message that it says host has disabled participant screen sharing. So I'm going to just talk for right now.
Hi, Leslie.
Yeah.
So good to see you, Professor Scott. I am going to share my screen and run your PowerPoint, okay?
Perfect, perfect. It is a little easier to have the PowerPoint because I'm going to be going through some sort of technical, in true law professor fashion, right? I did a PowerPoint and I'm going to be going through technical aspects of the law.
Is the PowerPoint viewable now?
No, I don't see it.
Okay.
I see the YouTube screen.
Okay. Well, if you bear with me 1 second, we will attempt to. Leslie, Professor Scott, if you want to proceed, and I will work back here trying to figure out how to get this PowerPoint to work. Is that okay?
Absolutely, not a problem.
Thank you so much, Professor Scott.
Sure, not a problem. Okay, so I'm going to start off by talking about the murder statute in Kentucky, and I'll do this with the caveat that I am actually not an expert in criminal law in Kentucky per se. I've never practiced there, but my background is in criminal, federal criminal defense, and I'm a criminal law professor, so I have some authority, I guess, for what I'm saying, and certainly my co-panelists can correct me if they think I've misstated anything. So the murder statute in Kentucky is found at 507.020. And there are two separate subsections there that I think are potentially relevant to this case. We're talking about sort of what these three officers, and let me just make sure I get all the names correctly. I think it's Detective Hankinson, former Detective Hankinson, Detective Cosgrove, and Sergeant Mattingly, what we sort of think they perhaps could have been charged with, or perhaps down the line maybe will be charged with. So there are two subsections to the murder statute. The first is intentional murder. So a person, this is what would be on the slide if you were viewing it, a person is guilty of murder when, with the intent to cause the death of another person, he causes such death of such person or of a third person. And I haven't really heard many people talk about the potential for intentional murder charges in the context of this case based on these three officers who, I think I'm getting a message. Oh, okay. So let me try. I think I'm being told to try sharing my screen again. Let's see if it works. Okay, I think I can share my screen now. So I'm going to go ahead and try that. Can folks see my screen? I don't see it, so I don't think that you can, but maybe somebody can let me know.
I can see it.
You can, okay. I don't see it for some reason, but other people do. So I don't need to see it, so that's fine. Okay, so everybody can see the statute on the screen now?
Yes.
Perfect, thank you. So I'm talking about subsection 1A right now, which is intentional murder. And what I was saying was that, I haven't heard a lot of people talk about the possibility of these type of, intentional murder charges. But when thinking about what happened here, right, you've got three officers who are storming into this apartment and essentially shooting blindly, right? I believe I've heard different numbers, but somewhere in the neighborhood of 20 or 30 bullets were fired into the apartment. And so as I was thinking about it, it at least seems plausible here that there was an intent to kill. So I think the argument is that when Miss Taylor's boyfriend, Kenneth Walker, fired one warning shot in the direction of the officers, because of course he, believed them to be intruders and he had a permit and was licensed to carry this gun. So it was perfectly legal, under the stand your ground laws for him to do what he did. But he believed them to be intruders. So he fires this warning shot that ends up hitting one of the officers in the leg. At that point, I think it's at least arguable that the officers formed the intent to kill. I have law enforcement in my family, and what I've always heard, whether it's true or not, what I've always heard is that, you're trained as a law enforcement officer to shoot to kill if you are being shot at, or if you're otherwise if your life or your bodily, if you're facing bodily harm from somebody else. You're not taught to, try to shoot them in the hand, for instance, or in the, in the leg to disarm. So, I think there's at least something worth thinking about, right, with respect to intentional murder. And although Walker was the one who shot at the police, and presumably he was the one that the police were aiming at when they started firing in response, Kentucky's intentional murder statute incorporates the common law doctrine of transferred intent. And that's illustrated by the language that I have underlined on the slide in subpart A. So in other words, the officer's intent to kill Walker, the intended victim, is effectively transferred to the actual victim, which is, of course, Breonna Taylor in this case. The other provision on your slide is subsection B, and that refers to wanton murder. So in Kentucky, a person is guilty, excuse me, of wanton murder. I'm going to take a sip of water. Of wanton murder when they, under circumstances manifesting extreme indifference to human life, they wantonly engage in conduct that creates a grave risk of death to another person and thereby cause the death. And so wantonness is an important concept in Kentucky. It's this older common law term that can mean different things depending on the jurisdiction. But in Kentucky, it refers to an awareness and a conscious disregard of a substantial and unjustifiable risk that particular conduct will cause a particular result, in this case, the result being death. And so that's kind of a standard that most jurisdictions probably would refer to as recklessness, and Kentucky refers to it as wantonness. Kentucky also recognizes the doctrine of transferred intent with respect to wanton murders. So it's not specifically spelled out here, but there's another subsection, another section of the statute that talks about transferred wantonness, meaning that if the officers acted wantonly towards Mr. Walker, but Ms. Taylor was the one killed, that wantonness mindset transfers over to the death of Ms. Taylor. So with respect to wanton murder, I think the question is simply, did the officers consciously disregard a risk that, what they did, right, would lead to the deaths of either Mr. Walker or Ms. Taylor? And did they do so under circumstances manifesting an extreme indifference to human life? I think that there's certainly an argument to be made there as well. Again, 30 bullets fired into this apartment. The bullets hit 8 different rooms and 2 different apartments. Ms. Taylor was shot, I believe, 6 times. The officers couldn't see into the apartment. They couldn't see their target, right? And that's evidenced by the fact that Ms. Taylor was shot, but Mr. Walker was not shot at all. Former Detective Hankinson wasn't even in the building, right? When he was shooting from the parking lot. He shot through a glass patio door that was concealed. So he really had no idea, right, where he was shooting. He had no idea who else might have been inside of that apartment, who might have been hit. And Hankinson was actually charged, right, by the grand jury with acting, recklessly and endangering the lives of others under circumstances manifesting an extreme indifference to human life. So those charges certainly support the similar type of standard here for murder. And then arguably, I think other panelists are going to get into this more, right? But arguably they didn't knock and announce their presence, and they did all of this at 1 o'clock in the morning, right? So 1 o'clock in the morning, you've got Ms. Taylor and Mr. Walker who are asleep. And so this all sort of increases the risk, right, and the chance that they would be scared, startled, and thinking that there are intruders trying to break into the home and responding to all of that in kind. Now, whether these officers would ever be convicted of murder is, I think at least debatable, right? Because the officers may have the strongest justification defense to the murder charges, but I think it's at least worth mentioning and sort of thinking about in the context of this case. So the next statute on your screen is second-degree manslaughter in Kentucky, and this is the wanton manslaughter statute. And so what distinguishes this charge from subsection B of the murder statute is that with wanton manslaughter, there need not be any sort of circumstances manifesting an extreme indifference to human life. So the mens rea here is lower and would be a little bit easier for prosecutors to prove with second-degree manslaughter as opposed to murder. And really we're talking about the same factors that could potentially support a murder charge would support a manslaughter charge in this case. Kentucky's reckless homicide statute is the least serious form of homicide. So defendant commits a reckless homicide when he should have been aware of a substantial and unjustifiable risk that his conduct would cause a death, even if he was not subjectively aware of that risk. And then the concept of transferred recklessness also applies to this statute under a different subdivision. So in most jurisdictions and under the model penal code, what this reckless homicide statute describes is really a negligence standard, right? It's a should have been aware of, even if they weren't aware of a risk of significant risk, I should say, of death. So again, we're talking about the same arguments that would support a reckless homicide charge. So the next statute I have on the screen, and I'm coming to an end here so we can hear from some other folks about these issues. But the next statute is the complicity charge under 507.050. And this statute codifies the doctrine of accomplice liability in Kentucky. So the argument is essentially that all 3 of these officers were acting in concert together to aid each other in bringing about the death of Breonna Taylor through intentional, wanton, or reckless conduct. So what I think this charge does, and I'm sure that Professor Mannheimer will correct me if I'm wrong, but what I think this charge does is that it can potentially get around some of the ballistics and causation issues surrounding which of the particular officer's bullet or bullets actually caused Miss Taylor's death. So the theory being that if they were all acting together in concert to assist each other in their conduct, they're all equally responsible for the death, even if there's no evidence, for instance, that former Detective Hankinson actually shot Ms. Taylor. So I'm going to wrap up my portion by just briefly talking about probably the two most important aspects of this case and the two most important statutes here, and that's self-protection, which is on the screen now, and then I'll touch on the general justification law. So as we all know by now, Attorney General Cameron has said that these officers were acting in self-defense or self-protection, as it's referred to in Kentucky. And they were therefore justified, he says, in shooting Miss Taylor 6 times. So this self-defense justification really is, very important and is at the heart of this potential case against these officers. So here's the statute. The defendant has to believe that the force used is necessary for self-protection. And Kentucky has a similarly worded statute for protection of another person against imminent death or serious injury. So the two officers who were not, hit in the leg could potentially argue that they were acting to protect Sergeant Mattingly, who was. So, I think my co-panelists are going to talk more about this. I think the biggest issue for me, one of the biggest issues, there are many issues with what happened here. One of them, is sort of a procedural issue with the way that the Attorney General handled, I should say, this case in the grand jury. So, I'm a former criminal defense attorney, and so I'm, familiar with how grand juries operate, right? And we know now from the grand juror who has recently spoken up, right, that homicide and justification instructions were just never given to the grand jury. They were really only instructed on the reckless or wanton endangerment charge. So they were simply not told, by the prosecutor that the government was going to be seeking any sort of homicide indictments here. And that's really, in my view, at least, contrary to the way that the grand jury is supposed to operate. The prosecutor is really supposed to present all of the evidence that they have, right, that support any and all charges, and then act as a legal advisor to the grand jury. The grand jury is the one with the power, though. The grand jury is the one that makes the decision. The prosecutor can say, this is what I recommend here. This is what I think based on my reading of the law. But again, it's the grand jury that's the ultimate decision maker. So by not presenting any evidence at all on homicide and on justification to the grand jury, the prosecutors here were essentially, depriving, I think, both the grand jury and the trial jury of considering this issue. So that's a little beyond the scope, but worth mentioning, I think. So this is the last slide. So while self-protection is potentially a reasonable theory of defense to the murder charges, Kentucky also has a separate justification provision that I think really calls into question the legitimacy of any sort of self-protection argument as it relates, at least as it relates, my reading of it, at least as it relates to the potential manslaughter and reckless homicide charges, and that's on your screen. So under subsection 1, where the defendant's belief in the need to use the degree of force that's used, because again, the focus on self-protection is, did the defendant believe that he needed to use, force for self-protection? And of course, they're going to argue that they did, right? Because there was one shot fired that hit one of the officers in the leg. But where that belief is mistaken, essentially, and I focus on the degree of force used, because you can argue that there's no need to fire 30 shots in response to one shot, right, being fired at an officer. So where the degree of force, the belief about the degree of force is mistaken, and that mistake is wanton or reckless, the defendant is not entitled to a justification defense for the crimes of wantonness, and recklessness. So that's important here, right? Why was the grand jury not told about this particular aspect of the justification law? So this would potentially apply, of course, to wanton manslaughter and to the recklessness charges. Perhaps even more importantly, though, is that subsection 2 that you see on your screen. So even if the officers were justified, both in using force to respond to Kenneth Walker's one shot, and even if they were justified in the degree of force, which is highly, questionable, but if they were somehow justified in shooting 30 times, the problem here for them is that they, that force should have been used, arguably, I guess that they're going to argue, against Mr. Walker and not against Ms. Taylor. Breonna Taylor was an innocent bystander and did not pose a threat to the officers herself. We all know by now she's not the one who fired at them. She didn't even have a weapon, yet she was the one who was hit by the officers' sort of barrage of bullets that they let loose. So under subsection 2 on your screen, and in particular, the section that's in bold there, the defense of self-protection is arguably really not available to these officers for the manslaughter and reckless homicide charges. But I'm going to stop there because I know that my other co-panelists have more to say about these issues.
Thank you, Professor Scott. We will now go to Professor Crusoe. Would you like to share your insights as to why the police are getting away with these shootings?
Yes, good morning, everyone. And unfortunately, millions of Americans wake up every morning fearful of their safety because of the color of their skin. This is an unfortunate incident for Kentucky. I thank Professor Cook and the staff and the students at the University of Kentucky and Dean Davis for putting together this very important panel. And thank you for my fellow panelists. Professor Scott, thank you for your introduction. A few years ago, we had in the city of New Orleans, everyone knows about Hurricane Katrina, but few people know that immediately after the hurricane, a number of police officers murdered 2 individuals and shot about 6 others, and then effectively planted a gun on the scene of the crime, lied about the fact that they were returning enemy fire. Eventually, the federal government got involved. There was a trial, and unfortunately, these individual police officers were able to get away with murder. So often we see this constantly in TV. It's sad for the victims, it's sad for our society, and certainly, unfortunately, for Black people who are living in fear in this country of police brutality. I want to talk a little bit today about how police get away with murder. Thank you, Professor Scott, for giving us some insight into it.
I got kicked off the internet, so I think I want to do it from down here.
But we have a person who's not muting there. Okay, so how do police get away with murder? I want to touch on 3 points. One is what constitutes equal justice. Number 2, what is considered systemic racism? And then number 3, the Black Lives Matter movement. What does it mean relative to these police murders? And I use the word murder in a generic term, not in a technical term, and I'll explain a little bit how I think police get away with murder. So this is not specific to Kentucky law. This is specific to constitutional law, U.S. constitutional law. Equal justice does not apply when a white police officer kills a Black person. That's the conclusion of my research of a number of cases like this and a number of law review articles that I've written. How do police officers get away with killing a black person? And I say white police officers because we have a case in Minnesota where a black police officer killed a white woman and is serving time. So it's kind of unusual that some of these protections, which are meant to protect police officers, don't necessarily work when it's a black police officer. So there's two reasons why police officers, white police officers, can kill a black person. One is because state and local laws authorize police to kill people. Whether they're black or white, police officers can kill people. Those state laws and local laws, in my opinion, are unconstitutional. We'll talk about that in a second. Number two, the Supreme Court condones police killings without accountability. And this is a result of three doctrines that the Supreme Court has adopted: the intent requirement in the Skews case, qualified immunity, and objective reasonableness in the Graham decision. Let me talk about the last one for a second. So the Supreme Court ruled in the Graham case that police use of force must be objectively reasonable. Now, that's a very unusual term because the word objective gives the impression that it is fair. But in fact, what it means is that an officer's actions are reasonable in light of the facts and circumstances confronting that officer, without regard to intent or motive. What that means is that a police officer can go in with a racist intent and a motive to kill, but it doesn't really matter if that police officer believes, in light of the circumstances, that they were acting reasonable. You know, recently, one of the police officers in the Breonna Taylor case was interviewed on TV, and it was interesting how smart this officer was. You know, he seemed very confident that there was no way that he was going to basically be prosecuted for the crime that he committed. And quite frankly, he's right. You know, the thousands of police shootings that result in the death of individuals every year do not result in prosecutions, whether those victims are black or white, because of these Supreme Court decisions. And because the police officers know that the Graham decision protects them, because all they have to do is say, I felt threatened in light of the circumstances that I was in. And that's basically a broad-based defense. That, along with qualified immunity and the intent requirement in the Skews case, means that it's very unlikely that a police officer will be prosecuted no matter what state law says relative to murder. That's point number one. So there's not equal justice in this country relative to when police shoot people or kill people, chokehold people. Unequal justice exists because the Supreme Court says it exists. Number two, systemic racism is state-sponsored intimidation of blacks to promote white supremacy. This is not new. Okay, we've had lynchings for years. Police killing of black people, which are publicized on TV, is another form of intimidation of black people. Okay, we should make sure the criminal justice system is not rigged against blacks, such as the grand jury system. Professor Scott mentioned some insights into the grand jury. The grand jury, the only reason why we even know it went on in the grand jury in this instance is because the judge basically allowed us to know what was going on. Normally, as you know, grand jury proceedings are secret. So half the times we don't even know what's going on behind the secret veil, okay? And so when there's injustice in the process, we're not able to even address those issues. So fortunately, in this instance, we were able to get some insight into what's going on in the grand jury. Second point, it's wrong to demonize blacks who want to live life free of fear of police brutality. You know, the pushback against Breonna Taylor and her boyfriend, Kenneth Walker, and other blacks is, well, gee, you know, while Black lives matter, what about blue lives? Well, this is not about police officers who have the authority to kill people, okay? I mean, they have the authority. Why should we have to think about protecting blue lives, which are very important? Why is it that when we have a protest to protect Black lives, there's a blue out where police officers decide, well, we're going to punish you. We're not going to, you know, show up to patrol your community. I mean, that's crazy. Why would you want to demonize Black people when the system is rigged against us? Point number three, Black Lives Matter mean that the constitutional protection of the sanctity of life applies to everyone, and particularly to the most vulnerable in our society, Black people. There was no reason why the police officers, knowing in believing that Kenneth Walker was a felon. They knew where he was. There was no reason for them to go in and shoot him out. Okay, I mean, they could have waited for him to come out. Okay, there was no need. There was no immediate need to go in, break the door down. There was no lack of evidence if they had evidence against him in the first place. Okay, there's just a disregard for the sanctity of life in this country, and that sanctity of life results from our ability to allow authority to allow police officers to use lethal force when they don't have to use lethal force. Okay. In fact, I would say that the state and local policies and practices that permit police officers to use lethal force is an unconstitutional execution. Police officers have killed more people in 1 year than we have legally executed people on death row over the last 50 years. We're allowing the state to execute people. We're allowing police officers to act as judge, juries, and executioners of Black people. And that is unconstitutional. Okay. So my resulting suggestion and solution is ban the use of lethal force. Police should not be allowed to. They're not allowed to in England. They're not allowed to in so many parts of the country. And as a result, these type of misfortunes, which are misfortunes not only for the victims, their families, and for the Black communities, okay, they're also unfortunate incidents for the police officers. They're going to lose their careers. Some of them are, being threatened for their lives. It puts a stench on police enforcement in general, which really is, leads to lack of community policing because of the distrust of police. These laws should be banned. No police use of lethal force. Thanks very much. I hope that's a good introduction to the question. I look forward to the other presenters as well. Thank you.
Thank you, Professor Crusoe, for that detailed analysis there. Going through each of the Kentucky murder statutes, what are the arguments for and against charges? And we will go to Professor Mannheimer for this one.
Okay, thank you. Sorry, I got disconnected for a few minutes back there, so I switched locations. Hopefully, I will. Hopefully, this will work. So, are you seeing my PowerPoint? Yeah. Okay. Good. Let me put on the slideshow if I can. So let me just start off by saying this. We can see this in one of three different ways: a failure of criminal justice, a failure of criminal law, or a failure of criminal procedure. I know, we know the problem with criminal justice, the war on drugs, and I won't be talking about that today. Maybe other people will. The next panel is going to talk about the criminal procedure issue, the execution of the search warrant, and we're here to talk about the criminal law issue. So let's do that. And the focus is really going to be on the juncture between criminal law and criminal procedure. So let's just go through how the criminal liability plays out here. As Professor Scott said, when the officers broke into the apartment to execute the search warrant, Kenneth Walker used force, deadly force, and that was most likely justified both as self-defense and as what I call defensive habitation, although Kentucky calls it defense of property. So let's turn now to what happened, what the police officers did, and I've used sort of a flow chart here. When I look at self-defense law, I think it's very complicated. There's a lot of moving parts, and it's always helpful for me to kind of map things out in a flow chart. So, and another important thing to remember here is the question for us, the question for the grand jury is, what could a petit jury find beyond a reasonable doubt? Which is why I phrased the questions like this, which is why at times it becomes a sort of a double negative, but it's of necessity. So first question, could a jury find beyond a reasonable doubt that the police officers did not believe that deadly force was necessary to protect themselves against death or serious bodily injury? If a jury could find beyond a reasonable doubt that they didn't believe that, then yes, it goes to trial. Yes, they're potentially liable. But I think based on the facts that we know, and I guess one caveat here is I'm basing my presentation on the facts that I know, which are generally those that were revealed by Attorney General Cameron in his press conference. To the extent that those facts are incorrect or incomplete, that's going to affect the legal analysis, obviously. So then we go down to the next question. Could a jury find beyond a reasonable doubt that the police officers, with the intention of causing death or serious injury to another person, provoked the use of force by Walker? I don't think there's a reasonable view of the evidence that they did. So I think the answer to that is no. So then we have to go down to the next question. Could a jury find beyond a reasonable doubt that the police officers were the initial aggressors? That relates to whether there was a Fourth Amendment violation. I'll talk about that in more detail, I think, in a few minutes. Then we go down to the two issues that Professor Scott pointed out. Could a jury find beyond a reasonable doubt that the police officers were wanton or reckless in believing the degree of force used was necessary? If yes, then they're potentially liable. If no, then we go down to the last question, which is the one I really want to focus on. Could a jury find beyond a reasonable doubt that the police officers wantonly or recklessly injured or created a risk of injury to innocent persons? That is to Ms. Taylor. So those are the sort of the three big issues that I think are involved in this case. And let me go down to that last one just to save some time. And I think we can come back to the first two if we have the time. This last one, that they wantonly or recklessly injured or caused injury, created a risk of injury to Breonna Taylor in what was otherwise a justified action, that's probably the most plausible basis for criminal liability here. Ms. Taylor was certainly an innocent third party. And just to go back to what Professor Scott said, to remind you, wantonly, if you studied the MPC, the Model Penal Code, which probably everybody here did, if you're a lawyer, what Kentucky calls wantonly, the rest of us call recklessly. And what Kentucky calls recklessly, the rest of us call negligently. So it's a little confusing, but we'll use the Kentucky terminology, obviously. So there's three potential problems with this theory, finding them liable on that theory. The first one is that you'd have to say that the officers were either wanton or reckless in not realizing that Ms. Taylor was an innocent third party. If we look at it from their perspective, and again, given the facts that we know that were revealed by Attorney General Cameron, the police saw two figures coming down the hallway or at the end of the hallway, and a shot was fired. At that point, the police don't know which one of the two is the person firing the shots, or if they're both acting in concert with each other. So from their perspective, I think it's a little bit difficult to say they were wanton or reckless in not realizing that Ms. Taylor was an innocent third party. Second issue is the causation issue. Even if they were wanton or reckless in shooting, only Detective Cosgrove, or Sergeant Cosgrove, could be charged with Ms. Taylor's death because, again, based on the facts that we know, only one of the shots was fatal, and one of the tests traced that bullet to Cosgrove. The other test was inconclusive. So the only person a jury could find beyond a reasonable doubt caused Ms. Taylor's death was Cosgrove. So if anything, only he could be charged with this, I would think. So then the third issue, I think, is the most challenging here, or the third problem, I should say, the third problem with this theory of liability is that even if the officers knew that it was Walker and not Taylor firing on them, and even if we're constrained to prosecute only Cosgrove because of the causation issue, the question is, was he wanton or reckless? as to Ms. Taylor in shooting at Mr. Walker. So the commentary to the Kentucky statutes gives this very interesting, but ultimately unhelpful analogy. The commentary gives this example. D sees X committing an offense that would justify the use of deadly force for its prevention. D fires several shots at X while X is in a large crowd. Along with X, 2 innocent persons are killed. While justified in killing X to prevent the dangerous felony, D can be convicted of homicide for the other deaths if shown to have acted wantonly or recklessly. Okay, facially, that seems relevant to our case, but upon closer inspection, it's really pretty unhelpful, and for 2 reasons. First, that proviso at the end, if shown to have acted wantonly or recklessly, renders this example utterly useless. The illustration is supposed to help us understand what the provision means by wantonly or recklessly in circumstances presenting risks to innocent third parties. But instead, it simply tells us that the defendant is liable if the defendant acted wantonly or recklessly in those circumstances. So the commentary tells us nothing beyond the obvious that the defendant acted wantonly or recklessly if the defendant acted wantonly or recklessly. Suffice it to say, I've had answers on exams that are similar to that, and those students did not end up doing well. The second reason that that example doesn't help much relates to the type of justification offered in the example, the use of deadly force in effecting an arrest. And the Kentucky statute involved there would be 503.090 sub 2, use of deadly force in effecting an arrest for, quote, a felony involving the use or threatened use of deadly physical force where the defendant believes that the arrestee is likely to endanger human life unless apprehended without delay. The justification for using deadly force in those circumstances is much weaker than in the circumstances of self-protection. Part of the calculus in determining whether someone acted wantonly or recklessly is the degree of justifiability of the conduct. That is to say, what's the alternative to undertaking the purportedly justificatory conduct? And the alternative to using deadly force around third parties in order to effect an arrest, which is what the example is about, is simply to allow the felon to escape momentarily and arrest at a more opportune time rather than endanger those around the felon. The alternative to using deadly force in self-protection, on the other hand, which is what is involved in this case, is that the police officers would have to sacrifice their own lives, something that the law really, I think, should never demand, although it does on some occasions. So at common law, and I'll try to sum up quickly because I know we're running out of time. At common law, the black letter rule was that one is not responsible for inadvertently or accidentally shooting a bystander when one is justified in shooting an aggressor. Kentucky provides that wantonness or recklessness does make one liable. So the common law cases are not that helpful because of their imprecision in lumping all unintentional injuries as accidental or inadvertent. There's a few cases on point, which are, or arguably on point, which end up being not all that helpful, including one from the Kentucky Supreme Court, which I can talk about in the Q&A if people want. But let me just kind of go down to, the question here is whether the police officers in shooting Ms. Walker consciously disregarded a substantial and unjustifiable risk that they would kill Ms. Taylor. I meant to say shooting at Mr. Walker, disregarded a substantial and unjustifiable risk that they would shoot Ms. Taylor. Of course they did. Of course there was a substantial risk of killing her. But the question is whether it was justifiable. And there's 2 ways of looking at this. One is that the justifiability of shooting at Mr. Walker has to be divorced from the justifiability of shooting at Ms. Taylor. So even though they were justified at shooting at him, we have to look at the risk they created with regard to her in a vacuum. On that view, of course they were wanted. Had they not been justified in shooting at Mr. Walker, then they would have been wanton in shooting. But another way, and I think probably the better way of looking at this, is that you can't look at it in a vacuum. That you have to say that the risk of death to bystanders, that's inherent in otherwise justifiable use of deadly force, such as where the innocent bystander is standing side by side next to the attacker, that the risk of death to the innocent bystander has to be ignored if it's inherent in the otherwise justifiable use of force against the attacker. That is to say, if the actor cannot defend himself without creating a substantial and unjustifiable risk to bystanders, we cannot base criminal liability on that risk. The officer's actions with regard to Ms. Taylor didn't take place in a vacuum. They took place in defending themselves from Mr. Walker. And it's only when an actor undertakes otherwise justifiable actions and does so that creates a risk to other people outside of what we call the zone of justifiability, can we say that he acted wantonly or recklessly, which explains why Hankerson was charged for crimes based on the shots fired into other apartments. It's not entirely clear, but I think the better view is the latter view, that we have to look at, that we have to kind of subtract out from the risk calculus the risk that is inherent in the officers using their justifiable use of force against Mr. Walker. At the end of the day, I think charges could have been brought against the officers. I think it really would have been an uphill climb to have a jury find them guilty and to have it held up on appeal. But it's by no means clear. And I'll stop there and perhaps give some more details and get into a little bit more as we go. Thanks.
Thank you. Does anyone else want to comment on this issue?
Yeah, I actually would like to, if you don't mind.
Go ahead.
And just very briefly, because I do want to get to some of the other questions that we have on the table and that are there for discussion. But the basic question here is, would charges have been justified? What are the pros and cons and the likelihood? And I basically, by way of response really to Professor Mannheimer, I want to say first that I agree with part of what he said, and that is that it would be very difficult for the prosecution, had charges been filed against the police officers for the homicide, whether it be murder, wanton manslaughter, reckless homicide, etc. Simply because we know from history, we know from the cases that have been brought, that it is very difficult to prosecute and convict police officers for actions they take in the line of duty. Often the very best you get is a hung jury, because there are simply jurors who will not convict, and we can talk about that in the Q&A. Where I disagree with Professor Mannheimer pretty strongly is in his reading of the statute, and this idea that if we did get a conviction, if the charges had been brought, this is sort of in a whole other universe, if charges had been brought and a conviction was obtained, that it couldn't stand up on appeal. I think there's a pretty fundamental difference between us in how we read 503.120 subsection 2. This notion that you factor in the justifiability of the action towards the aggressor, in this case Kenneth Walker, and therefore it would not be wanton or reckless with respect to the bystander, pretty much reads 503.120 subsection 2 out of the statute. Because that section calls upon us to do a separate inquiry. It presupposes that some actions that are justified towards somebody who uses force, that would be Kenneth Walker, are not justified when it comes to creating a risk to an innocent bystander. So we have to look at whether the officer or whoever we would be talking about using deadly force, whether they were wanton or reckless, not just in creating a risk to the person against whom they're using self-defense, that is the initial aggressor, but whether they separately created such a risk as to innocent bystanders. So I think if you somehow brought these charges and were able to get a conviction based on wantonness or recklessness, I do think there would be a real problem doing it with regard to intent. That when we're talking about Breonna Taylor and her being an innocent bystander, that would be a powerful argument for the prosecution and to defend any conviction on appeal. That is why, and this is the last thing I'll say before I wrap up, that is why it seems to me it has been so important for those defending the police officers, for the Attorney General, and those who support him to demonize Breonna Taylor. I think the idea here is to not let her be perceived as innocent, not let her be perceived as somebody who deserves the protection of that statute. And I think that is, we've seen that before in cases in which the victims of excessive police force, often deadly force, their background is demonized. They are called, portrayed in a way that makes them less worthy. And that is, I think, the subtext of what is going on to justify both the Attorney General's decision and to justify not seeing Breonna Taylor as somebody who was truly innocent and therefore entitled to the protection of the innocent bystander provision.
Thank you. We will now move to.
Can I just briefly?
Can you hear me? Can I jump in here real quick?
Yep, I was just going right to you. Go ahead.
Okay, thanks. First of all, thanks for having me. Really esteemed colleagues right here, and really amazing that you guys are setting aside a day to go through these issues. For those of you that don't know me, I'm a pretty blunt guy and I have a strong personality, so don't take offense here, and I'll try to be quick. But as I sit here and listen to this, I get a little frustrated because I hear things like Kenneth Walker was the initial aggressor. The officers acted only in response to Mr. Walker. No, Kenneth Walker acted only in response to the officers. We're not talking here about, and we should be, about the castle doctrine. You know, there's a presumption under KRS 503.055 that anyone who enters a residence unlawfully and by force does so with an intent to commit an unlawful act or involving force or violence. Under the castle doctrine, Kenneth Walker, Breonna Taylor, anybody else, they have a right to use force to defend their castle at that point. There is the exception for the police officers, but only if they act in accordance with the law and announce themselves. And what's not being acknowledged here is that this search warrant had been converted to a knock and announce search warrant. They were required to knock and announce. And what we're dealing with is a situation here where we've got literally every single apartment around Breonna's place. Everybody says they did not hear announcing. So help me out here, and I'm trying to challenge my colleagues to a certain extent. Explain to me why Kenneth Walker is the initial aggressor if under the law, somebody who enters that house forcibly, and unlawfully is deemed to do so with an intent to commit an unlawful act. How is Kenneth Walker treated as the initial aggressor? How is he the one that is acting in response to, how are the officers acting in response to him as opposed to he acting in response to the officers? So that's what I would want to pose here and stir up some debate. I'd like to hear where I'm wrong.
Well, I'll just chime in here and say I don't think you are wrong. My remarks were sort of proceeding from the baseline, even if we assume that the officers were acting in self-defense, which would require, as you rightly point out, Sam, that Kenneth Walker was the initial aggressor. Even if you assume that, which I absolutely agree with you, we shouldn't. that under those circumstances, you still have to ask, were they acting wantonly or recklessly, which would include inquiry into whether they announced and then how much force they used and the risk they created to Breonna Taylor. So I thank you for making that point, because it allows us to really make explicit that only on the assumption that Kenneth Walker was the initial aggressor do you even have to talk about those issues. And that's a huge assumption. It's a huge leap that I think was sort of assumed in the conversation that we absolutely should bring to the surface.
Let me jump in, because I think maybe this is misunderstanding what I've said, but I never said Walker was the initial aggressor. Walker was definitely not the initial aggressor. The question is, were the police the initial aggressor, or was there no initial aggressor? There are cases where there just is no initial aggressor. Walker was not the initial aggressor. He was entirely justified. That's how I began my talk. Walker was entirely justified, or at least excused. The difference doesn't really matter here in firing at the police. But that doesn't mean that the police were not also justified in firing back. You can have a situation where two parties firing at each other, one is mistaken or both are mistaken about what's going on, and both are justified or excused, or one is justified and one is excused. It doesn't really matter. Neither one is culpable. The police could be deemed the initial aggressors if the Fourth Amendment violation could be deemed the initial aggression. And I think we're going to get into that issue in a few minutes, so I won't say any more about that now. I'll leave it at that.
I'm going to butcher Sam's last name. It's Aguilar. I want to jump in for a second and agree with you, Sam, if you don't mind me calling you this. You know, part of the frustration that the Black community and other people of goodwill are seeing in these cases is a lack of a trial, a lack of even a charge. In any instance where a person is killed, I mean, the typical process is the perpetrator is being charged. You know, these police officers, except for the one minor exception, has not been charged. You know, they've been precluded. They've been immune from being charged. I mean, it's a job of the jury, and I agree with the other Sam that even when we have a jury, it's unlikely that police officers will serve time because of the pro-white police juries that we typically impanel and some of the other rules of defense. But the bottom line is, we have to at least have charges. Okay, we have to have a grand jury system that basically fairly evaluates the opportunity for justice to be served, and not have this kind of cloud of protection, this immunity against charges. And so, Sam, you're absolutely right. I mean, we're prejudging. We're giving the police the benefit of the doubt in this situation. We're demonizing Breonna Taylor and Mr. Walker. I think that the system is meant to have juries and judges establish facts. Right now, we're just kind of surmising what the facts are. So let's have a trial. Let's have charges, and let's have a trial, and let's have facts come out in the usual fashion in which facts are to be determined by a jury of their peers.
Yeah, and I'll just quickly piggyback off of what Professor Christo is saying. My big issue with this case, I mean, just the fact that we can have this dialogue and back and forth and debate says to me that there are genuine issues of fact here. There's issues of fact about about justification, whether they're even entitled to justification if they are the initial aggressors. Certainly with respect, maybe not so much with the murder charges, but certainly with respect to the wanton, manslaughter charges and the reckless homicide charges, there are real issues of fact that are meant to go to the grand jury. And so again, I keep going back to the procedural issue. Why was the grand jury not ever provided any of this information, the facts, the law? We know now that didn't happen. Somebody mentioned in the chat, I think it was Professor Beatty, that we're not talking about a beyond a reasonable doubt standard at the grand jury level, right? At the grand jury level, we're talking about probable cause. And that's a really low bar. I mean, every criminal defense, and prosecutor and criminal law person knows that it's pretty easy. You could probably indict me on something, right? It's pretty easy to get an indictment because the probable cause standard is such a low bar. It's much lower than beyond a reasonable doubt. Is there, sufficient evidence to, charge these guys so at least a jury can, hear the facts and the evidence and make a determination on that higher beyond the reasonable doubt standard. So I think the real issue here is that the grand jury was deprived of this information and of the opportunity to decide, is there at least probable cause to bring these types of charges?
Okay, does anyone else weigh in before we go to the next question?
No, I can chime in some more. Why not? So the other thing I would bring up, and I appreciate all the commentary there. That was good. That's what I like. We're lawyers. Let's start debating some things a little bit. We're also not talking enough about Miles Cosgrove right now. So again, even if we get to a point where a jury were to somehow, deduce that it was justifiable for them to make entry, and then they were confronted with a shot, and then they were justified to return fire, we still have to talk about how long that justification lasts for and the extent to which it can last. Because with Miles Cosgrove in particular, he needs to, like somebody else said, you need to be able to reasonably articulate your fear and the threat and what's posed. Well, the grand jury, just to be clear, did get a lot of facts. They just didn't get the opportunity to deliberate on them. And Miles Cosgrove's description of what happened was, as he walks in, he sees some darkness. He sees some flashes of lights, and he sees a shadowy mass. And by the time all is said and done, he leaves. He couldn't hear. He couldn't feel his hands. He doesn't know what happened, but he thinks he fired maybe 4 shots. Well, he fired 16. And ballistics experts, which the grand jury didn't hear, but which, we'll be raising in our application for a new prosecutor, confirmed that, number one, Miles Cosgrove shots came after Breonna had already been shot. John Mattingly, FBI matched a bullet of John Mattingly's to Breonna that was a through and through shot. So that obviously either disabled her, she's screaming, she's crying, it's clear as day that she's not a male, she's not armed, things along those lines. He retreats from the residence, then Miles Cosgrove steps in, and all of his shots directed to her were 3 feet or lower to the ground, most of them obviously while she was on the ground. Again, I'm challenging my colleagues right here. These are the facts. They've been presented to a grand jury to a certain extent. We've got a delay. We've got a guy who can't articulate the threat. He shoots at a shadowy mass, doesn't even know how many times he shoots, and she's down on the ground, and he kills her. What's the argument there against criminal charges? I love a good debate. To me, it seems pretty obvious that we've gone through some statutes that, there's certainly probable cause there to indict. Convince me otherwise.
Sam, just for a minute to jump in, you're kind of, again, buying into what their investigation has said. From my experience and in the studies that I've done, not experience in practicing in this area, is that you cannot trust the police investigations. Clearly the testimony that we're getting are self-serving testimony on national TV, saying I saw the barrel of the gun, and then I shot. I mean, give me a break. Okay. In other instances, we know that that police are lying in the investigation, that Internal Affairs is there to protect. The police unions are there to protect. There's a lot of, and again, this is not, meant to be personal against the police officers. They're in a very difficult position. We give them the authority to do something which is unconstitutional. And then we don't want to hold them responsible because we don't want to hold society responsible for giving them the authority. Okay. But we have to have an independent investigation. If that requires a federal investigation, then so be it. In the case in Louisiana, it took 11 years to figure out what was really going on, and that the police were basically lying throughout the whole process and planting guns on people. It's a very common practice, for police to defend themselves and for other police to lie and cover their ground through the blue code.
I hate to say what I'm about to say, but this is the weirdest pushback maybe I've ever offered to you or anyone else, Sam, and that is, Your question assumes that facts matter. Your question assumes that the reality of even a biased investigation, but let's assume it's true, that it ultimately matters. But when you're dealing with a system that is built specifically to protect police from responsibility for their actions, that doesn't value Black lives, facts don't matter. So, I hope that's not ducking the question, but I think it's the reality of the true answer to the question about, well, what about what we know about Cosgrove's shots, where they were directed, how many, when they occurred? The sad truth is it probably doesn't matter. And we shouldn't ever probably have expected it to matter.
Isn't that a damn shame? It's the truth, but isn't that a damn shame?
Let me jump in. It's hard to follow that because I'm going to be relying on facts or the facts that we know. But so I think it's important to distinguish this case from some of the other cases that we know about. In this case, a police officer was actually shot. So unless the police shot first and then Walker shot in response to that, and I don't know anyone is contending that happened. Assuming Walker shot first, and again, he was most likely justified in doing so. The police were justified in returning fire, and I think we have to really focus on some of the issues, some of the sort of the nitty-gritty issues. One of which Mr. Aguiar just pointed out, which is how long does the justification last? That's a legitimate issue here. I think we're all assuming, or at least I'm assuming, that the shots, the 32 shots, are sort of all instantaneous. If there is a time lag, then yes, that opens up the door to liability for whomever fired shots after the justification ended. There is a causation issue, though. I think again, you'd have to show, a jury would have to find beyond a reasonable doubt. And by the way, it's not that the grand jury has to find beyond a reasonable doubt. Everyone is correct about that. But probable cause means there's probable cause for a rational jury to find beyond a reasonable doubt. And that's a fairly low standard, but it is a standard. The jury would have to be able to, a rational jury would have to find beyond a reasonable doubt that Ms. Taylor was killed by a shot that came after the justification period ended. I'm not sure that that's possible. That's not something I really looked into, but I think that is a question that we have to ask. This it kind of goes back to what Professor Scott said about 503.120 sub 1, which is the reckless or wanton use of excessive force. So if they could have defended themselves by firing 5 shots or 8 shots or 10 shots and instead fired 32 shots, that's a potential area for liability as well, if we can say that they did that wantonly or recklessly. Now, I tend to read that provision as saying that you can't use deadly force in response to non-deadly force. I'm not sure there are different degrees of deadly force, but I guess you could imagine a situation where there is. So if someone is facing me on the street with a gun and there are bystanders all around, it's a crowded city street, and in one hand I have a handgun and in the other hand I have a hand grenade, I would be justified in using my handgun against the person who's threatening me. I would probably not be justified in using the hand grenade because I have the handgun available. So the the wanton or reckless use of excessive force is a potential area for liability here. But again, I think that's an uphill climb.
But why are we assuming that there's not a double standard? I think Professor Marconson basically pointed out. I mean, these rules apply to citizens. They don't apply to police. Okay, I mean, we know that. I mean, and not because they don't apply as a matter of process. They don't apply as a matter of law. They don't apply as a matter of U.S. constitutional law. So we can talk about all the details of why they should be prosecuted if they were normal citizens. They're not normal citizens. They're police officers who are charged to do their jobs to protect human life and safety. We give them a pass. We give them a pass with sovereign immunity. We give them a pass relative to their intent. We give them a pass relative to their actions. And so, I mean, that's just the reality. I mean, the constitutional law supersedes the specifics, and that's why people are so upset, because they don't understand. They think it's the attorney general who's kind of like giving these police officers a pass. The attorney general is not giving them a pass. The Constitution, as interpreted by the Supreme Court, gives police officers a pass, makes them less accountable. And the police officers know it. They're trained to know it. They're allowed to do what they do, and they know they can get away with it. Okay, and they do it recklessly. And to think that we're going to hold them by the standards that we would hold normal citizens is a fantasy.
Okay, I'll repeat what I said at the outset. We have to separate the criminal law issues from the criminal procedure issues. The Constitution has nothing to do with the substantive law, or I should say it has very little to do with the substantive law issues. There is a slight area of overlap. The area of overlap is in violating the Fourth Amendment by executing the search warrant in the way that they did they then become the initial aggressors? That's really the only way that the Constitution is even relevant here. This is not about Graham versus Connor. This is not about the Fourth Amendment. This is not about qualified immunity, all of which I agree with you are messed up. This is about the substantive criminal law. It's a big problem that the police executed this warrant in the middle of the night. That should never happen. That should never be allowed. It's a big problem that if they didn't knock and announce, and I know there's a factual dispute there. If they didn't knock and announce, and because they executed in the middle of the night, that might have made them the initial aggressors, although I'm a little skeptical of that too. But we have to be careful that, so that's one thing. The second thing is, we're not talking about statutes that apply only to the police. These are the basic self-protection, self-defense statutes. I think you're absolutely right that we treat the police far better than we treat most people in the criminal justice system. You don't have to tell me. I represented indigent defendants for 5 years, almost all of whom were people of color. The question is, are we going to level up or are we going to level down? That is to say, are we going to apply the same crappy criminal justice standards to the police? Or are we going to try to raise the standards for everybody? And I prefer that we do the latter.
Yeah, Professor, I don't want you to take it as anything other than an analysis. I mean, I understand your phenomenal contribution. The fact is that the law needs to be changed. We need to basically take away from police the authority to use lethal force, to use chokeholds, all the things that they're allowed to do and trained to do. Their first defense is, we were just following procedure. I mean, so were the troops in Nazi Germany. It's no excuse for them to break the law, but on the one hand, no moral excuse, but it's a legal excuse. We were following orders. We were doing what society, what the state and local authorities authorized us to do, trained us to do, and protects us when we do it. And so I just want people to understand that their frustration, which is very well placed, that we need to have changes, but we need to have changes at the legislative level and at the police authority level to basically, and this has been done in some other jurisdictions and it's been done in other countries. In England, the sanctity of life comes first. Okay, and police are trained not to have weapons in the first place, as you know, and not to use their weapons except in acute situations. Okay, we have this kind of cowboy, shoot them until they're dead, and then try to figure out what happened. And it's too late at that point in time. It's too late for everyone, and it creates distrust in our communities where we need the police in our communities, and we need to trust the police in our communities, and they need to feel that they're being trusted.
Okay, great. Thanks. I want to jump in here since we're on the topic of self-defense. Now, do you have to be on the premises lawfully in order to use self-defense?
I can jump in here. Thank you so much for asking that, because literally I've been waiting to fire off the question to my colleagues as to why we can claim justification for these police officers if they're the initial aggressors. Because my understanding always was, and again, that's why I like being around the scholars here, because they know the law a lot better than I do in certain situations. But my understanding was always that if I'm the initial aggressor, I beat down a door when I'm not allowed to do so. Somebody isn't, justified to use deadly force against me, and I got to get the hell out of there. I got to retreat, was always my understanding. That I can't just, because I'm confronted with lawful use of deadly force against me, I can't just assume that I can shoot back because I was the initial aggressor. So I'm glad you asked that. My understanding is that if a jury were to, interpret these facts, determine that these officers were the initial aggressors, that then all of a sudden, we're talking a whole different ball game when we look at these murder statutes and these homicide statutes, because they would have had a duty to retreat. But at that point, I'd love to hear what somebody else has to say.
So, that's the question I've been alluding to, whether the Fourth Amendment violation, assuming there was one, and I think there was, I think that's the big problem here. Does that, for purposes of substantive criminal law, make the police the initial aggressors? Initial aggressor is a notoriously slippery concept. I think those of us who've taught criminal law know that it's exceedingly hard to nail down what initial aggressor means. Given that, as Professor Scott said, since these questions are sort of all up in the air, maybe that should go to a jury. I think there's a few ways of looking at it. Some courts say that if you act wrongfully, that makes you the initial aggressor. I think maybe that's far too broad. On the other hand,
no, don't forget. Don't forget. I did read you the statute earlier. So it's not a Fourth Amendment issue. It's Kentucky law that literally defines a person who unlawfully by force enters, does so, is presumed to do so with intent to commit an unlawful act involving force or violence.
Right. As far as Walker is concerned, when we're talking about Walker's justification, yeah, the person who enters by force is presumed to be threatening deadly physical force. As far as Walker is concerned, so that gives him his justification. I don't think it affects whether the police were the initial aggressors. As far as their justification is concerned, you have to separate the two out. As far as their justification is concerned, the statute says, the most relevant part of the statute says that the person can't use deadly force if they're the initial aggressor. That's all it says. So we have to know what initial aggressor means. If it means committing a criminal act, then no, they weren't the initial aggressor because they didn't commit a trespass. Even if they did commit a trespass, they were justified under execution of public duty, even if the warrant was defective. Because the execution of public duty justification kicks in as long as they reasonably believe they were authorized to be there, and they most likely did. So I guess the question really comes down to can a constitutional violation be the initial aggression for purposes of the statute? I'd be interested to hear what other people say about that. I've talked too much already.
I think you're kind of assuming, that there's a constitutional violation. I think the Supreme Court, has basically virtually so diminished the Castle Rule, not the Castle Rule as it relates to normal instances of individual versus individual. Police officers, these police officers didn't act without authority. They had a court order as far as I understand it, right? They were authorized to do what they did. Now, whether they did it the right way, whether they did it at the right time, the unfortunate thing, and I think you will appreciate this from from your studies of drug law. Our war on drugs have basically greatly diminished our privacy rights. So police are basically allowed to, by constitutional law, to do all kind of horrible things without much regard for privacy or the castle doctrine.
I think there's a whole separate issue here that beyond initial aggressor or Fourth Amendment, and that is that you're only allowed to use force in self-defense in response to an unlawful use of force. If the use of force against that you are responding to is itself lawful, then you can't use your self-defense claim loses. So we have to, I think, retreat and back up to the question of whether Kenneth Walker's use of force was lawful, because that in turn has important implications for whether the police officers, whoever was the initial aggressor. Now, of course, if Kenneth Walker was not justified in using force, I think the only way you get there is if they did announce, if he did know it was police officers who had the right to enter, which there's at least an issue of fact on at the very best for the police officers. So if his use of force was lawful, then their use of force in response to him, as I read the law, does not give them the right to act in self-defense because he was lawfully using force.
No, I disagree with that. It depends on what they reasonably believed was an unlawful use of force. If they reasonably believed that Walker was acting unlawfully, then their justification kicks in. Again, two people shooting at each other can both be justified. As strange as that.
Now, aren't you bringing in Graham v. Connor there and going to the Constitution as it relates to civil cases? I thought you said it doesn't really apply when we're talking about the criminal analysis. So when we talk about that reasonable assessment, we're getting more into the Constitution.
No, I'm talking about black letter self-defense law. That it all depends on what the actor reasonably believes, even if the actor is incorrect.
I'm glad you added the word reasonably there, because as we've discussed, just because they believe it doesn't mean it's a reasonable belief, and they can still be charged with any crime where the mens rea is wanton or reckless. So I agree with you that we do have to inquire into whether they believe the use of force was lawful, that Kenneth Walker's use of force was lawful. But there are clear issues there about what, in my mind at least, about what they could have reasonably believed.
Yeah, I mean, the only thing that this has been very fascinating to me, because I'll be completely transparent. I hadn't thought about this notion, right, that the police maybe are the initial aggressors here. Because I think, Sam, you're right. If the police are initial aggressors, black letter law is that they can't, use self-protection or justification to support their actions. So I don't know. I mean, that's fascinating. It's something I'd have to think more about. I certainly didn't, research that legal issue before today. One thing I just wanted to quickly say, though, that I keep going back to is we keep focusing on sort of this short snippet of time, right? The snippet where the officers bust in and shots are fired, and that's a pretty short snippet of time. I'm having trouble, I guess, divorcing that from what some of you on the panel are referring to as the procedural issues that have nothing to do with the substantive issues. I keep going back to all of the things that were done wrong here prior to that busting through the door, right? Just even going back to the search warrant, right? The fact that the search warrant lied, there were so many lies on that application for the search warrant. For example, the post office thing that Breonna Taylor was getting drugs and that it was, cleared through the postal inspector, whereas the postal inspector came back and said, no, that didn't happen. The fact that all of this relates back to this third party, I can't remember his last name, but his first name was Jamarcus, right, who didn't even live at that apartment, who, was in custody, is my understanding, at the time that this warrant was executed. The fact, again, I keep going back to the fact that they didn't announce their presence. They're entering an apartment where there's no real, reason for them to believe that their lives were in danger, right? Because they know Miss Taylor lives there. She's not a bad person. She doesn't have, a record or anything like that. So, they're not announcing, they're entering at 1 o'clock in the morning. Why the need to enter at 1 o'clock in the morning? I guess I'm having trouble divorcing all of those facts from this question of recklessness and wantonness. Yes, they're procedural to an extent. Yes, perhaps they had a search warrant that they thought they could rely on. Although, again, why is it that we have a different team executing the search warrant than the team that applied for the search warrant, right? That presumably had those facts. So I do think that some of those issues relate to the substantive criminal law question as to whether or not they were reckless or wanton in their conduct, right? Knowing what they knew, firing the 30 shots in all kinds of different rooms in different apartments, knowing that Breonna Taylor lived there and they had no evidence that she herself, carried a gun or was a violent person. And again, I'll admit I haven't fully thought through these things, but to me, they matter. And to me, they speak volumes to the level of recklessness and wantonness that occurred here.
Professor Scott, I think you make a very important point. And clearly on the civil side, I think the jurisdictions recognize that this was a botched search. As a result, I mean, they've agreed to a fairly substantial, there's nothing that's going to replace Breonna's life, no matter how much money, but a fairly substantial civil settlement in this case. But when we go, so that's very true. I mean, so there's definitely civil liability, and it goes a long way. When we talk about holding the police officers criminally liable, we value life and we value, even the lives of our police officers. And when they're doing a job, I mean, should they be held criminally liable for doing their job when it results in killing someone? And I think we all believe that there should be a fair process by which we assess that question. But unfortunately, that question is already kind of weighed in favor of the police authorities. I mean, I don't think that any, hopefully there aren't any police officers. I can't say there aren't any. Hopefully these police officers did not wake up that morning and say, well, my mission in life today is to kill someone. Okay, I don't think that they have that kind of depravity of heart. They basically were assigned to do a job, and they botched the job under the circumstances that we're in. Should we hold them criminally liable? It's not for me to decide, but I think that it's to use the self-defense statutes without considering that the persons who are being potentially charged are basically government officials doing a job, and that the Supreme Court, in a number of instances, civil and criminal, have basically said we are going to protect individuals in the course of doing their jobs when they cause harm. Okay, that's what qualified immunity does on the civil side. That's what the these other Graham case says on the criminal side. And that's where we are. And if we don't like that, then we change the law, and then we basically tell police officers they're going to be criminally liable, personally liable for killing people, whether they do it intentionally or unintentionally.
Okay, thank you. Thank you. That was a very good discussion. We do want to get to some of the questions that we have coming in from the audience, but I do want to switch to body cameras really quickly. Does someone want to jump in and explain the discrepancies surrounding the police cameras? And then we will take about 5 extra minutes just to let you guys know in the audience. I know we're kind of hitting that time here.
I can handle that one. So in terms of the discrepancy of the body cameras, I'm assuming the question is essentially, why did we hear early on that these officers didn't have cameras, and then we heard after that they had cameras but they weren't on, and then later on we see a bunch of body cameras rolling? Is that essentially what the question is?
I'm sorry, can you repeat that?
No, that's okay. So I guess I'm trying to understand the body camera question, the discrepancy in them. Is it basically that first we were told there were no body cameras, then we were told that they were issued body cameras, they didn't have them on, and then at the end of the day, we start seeing all these body cameras that are recording things and don't know where all that came from? Is that what the question is basically?
Yes.
Okay. So we'll always have issues going on with this body camera situation. What we've learned is that at least LMPD And in particular, the chief, when they came out initially and said that these officers weren't issued body cameras, that was false. So out of the 7 officers that have been identified, we've got confirmation that 6, and this is from the city now, as part of our civil litigation, we were told that 6 did have body cameras. We were told that none of them had body camera footage of the incident. But then we were oddly given like 4 out of the 6 where they were able to time and date stamp some camera footage that they apparently identified on March 13th. We never got an explanation for that. It's very confusing. And we told the Attorney General and they did nothing about it. The body camera footage that was produced were from responding patrol officers primarily. There's some decent things in there. The fact that the grand jury only got to see 3 of them out of like 57 isn't as big a deal as people want to make it, because a lot of redundancy was in there. But the fact that the prosecutors didn't take the time to combine all the relevant footage from all the cameras into one was frustrating. They also didn't get to see the body camera footage from Elliott Avenue, which is where the warrant was being served over at Jamarcus Glover's place, the ex-boyfriend. And it'd be really interesting to see and learn why LMPD fought so hard to not interview any of those other narcotics or criminal interdiction detectives that were over across town, because that body camera, it'd be really nice to see what their reactions were to the shooting. You know, what SWAT's reaction was over there when they found out that a warrant was being executed that they didn't even know was being set for that night. So there is a lot of body camera footage that seems like didn't get produced. And we'll always have a question as to whether or not there was some footage from those officers on scene. We obviously see one of them that does have a camera on. John Mattingly, within some body camera footage of another officer, has a device under him, which our experts have said 50-50. It's either a body microphone or a body camera. So you know, and then Brett Hankerson and some of these officers disappear too. So there's a lot of discrepancies, and unfortunately, the Attorney General could have done some things through forensics to figure out what existed, and they didn't do it.
Okay, thank you. So really quickly, while we're on discrepancies, there were discrepancies between the officers and the witnesses regarding whether the officers announced. Is there enough evidence on the announced issue to present to a grand jury? And would that evidence support reckless murder or any lower level of homicide charges? So in other words, if the officers did not announce, would that support homicide charges?
Yeah, I think clearly the law is meant to protect police officers when they're acting in their policing function. They should be following procedures. If they're not following procedures, I think that would lead to greater criminal liability against the individual officers.
Yeah, I think the question of whether they announced is not in isolation determinative of anything, but it feeds into a whole lot of other issues that, when you look at them sort of globally, would be determinative of whether charges could be supported, whether they could be proved at trial beyond a reasonable doubt, et cetera. Just to give one example of that, if first of all, I think there is a clear dispute about whether they announced, with most of the evidence seeming to suggest that they did not, or at the very least that none or nearly none of the witnesses heard them announce. So announcing in a whisper may as well not be announcing, I guess. But if they didn't announce, then it affects Kenneth Walker, how we would view and how a jury would almost certainly view Kenneth Walker, or should view at least, Kenneth Walker's actions. Because if he did not know they were police officers for their failure to announce, then he has, under the Castle Doctrine, every right to respond to intruders who pose that threat. And that sets a whole chain in motion in terms of how the law would then treat everything that happened. So the fact of announcing or not, but more importantly, whether Kenneth Walker heard them announce is critical. I do think that the testimony that would, if there were a criminal trial on these issues, had there been a homicide indictment, that the police obviously would all, to a one, say that they announced, say that they did so multiple times, that they did so in a way that should have been heard, et cetera, and that would create, at least very possibly in the minds of some jurors, reasonable doubt on that question.
Yeah, I think that the failure to announce speaks to the level of the risk that's created. It's not just any risks that we care about when we're talking about the reckless or the wanton standard, but is it a substantial risk that death will occur? So the failure to announce, to me, suggests that that they consciously disregarded, or should have been aware at least, of this higher level of risk that something bad's going to happen, right, from them failing to announce. Because we can all presume, if they had announced themselves, and if presumably if they announced the way they should have, then Kenneth Walker would have known that there were police coming into the apartment and would have never shot. So I think at least the argument is that by failing to announce, you're increasing the risk that you're going to have this, exactly what happened, right? This deadly shootout, or I shouldn't call it a shootout, because really it's just Kenneth firing one shot and then they, did the shootout part of it, right? But they're increasing the risk that happens. So I do think, I agree with, with Sam, though, we can't consider that one piece in a vacuum. It's everything that sort of went wrong in this case, combined, that, at least in my view, supports probable cause for some sort of reckless or wanton, type of charges in this case.
Yeah, we've been through this before, but I think the announce issue really, to me, goes to whether they were the initial aggressors. I take what Professor Scott says to heart, and I hadn't thought about it that way, that maybe that makes them reckless overall. I think we have to, the initial aggressor question is, who precipitated the need for deadly force? So I think when we talk about wantonness or recklessness, we're talking about wantonness or recklessness in the use of deadly force, the substantial risk that someone is going to be killed. I think we do have to divorce that from the initial question of who precipitated the need for the use of deadly force. I'd have to think about that some more, though. I think that raises an interesting point. But I don't think we can say that at the moment the police broke through the door, they displayed a substantial and unjustifiable risk of death to someone. And by the way, this gets into the Fourth Amendment issue, which is going to be on in a few minutes, but the knock and announce issue is important. I think even more important, though, is the fact that they executed this warrant at 12:40 in the morning. That is clearly unconstitutional to me. And the reason the Supreme Court has never said that is because it's never had to. Everybody agrees you're not supposed to execute search warrants at 12:40 in the morning. If they hadn't done that, Breonna Taylor would be alive today.
Thank you. Well, we want to thank all of our panelists today. It's a very great discussion. If we want to give a virtual round of applause for all of them, we really, really appreciate you being here today. And we hope you guys will tune in to the other panels today. We haven't forgot about your questions, but they will be answered, I'm sure, in another panel. Thank you.
Thank you.
Hello, everyone. My name is Kirsten Hanshoe. I'm a third-year law student at the University of Kentucky, J. David Rosenberg College of Law. I will be the moderator of this panel. This is the second panel of our symposium and focuses on procedural problems related to the search warrant and the grand jury proceeding. Thank you to our panelists for being here today, and thank you to everyone joining us in the audience. Our panel today includes Courtney E. Lawler, James and Mary Lassiter, Associate Professor, University of Kentucky, J. David Rosenberg College of Law, Najiri Mathis Rutledge, Professor of Law, South Texas College of Law, Houston, Leslie W. Abramson, Frost Brown Todd, Professor of Law, University of Louisville, Brandeis School of Law, Jonathan P. Rittmer Rich, Associate Dean for Academic Enrichment, Cleveland Marshall College of Law, and Raleigh Dixon, a third-year student at the University of Kentucky, J. David Rosenberg College of Law. For more information about any of these panelists, please see their biographies on our panel list, available on the UK Law website, which I have put a link to in the chat. We will reserve time at the end of this panel for questions from the audience. Please post your questions in the Q&A. To begin, I wanted to ask our panelists, what were the problems with the search warrant? Were there lies in the affidavit? And if so, what impact did those lies have on the entire case? Professor Rutledge, would you like to start our discussion? Professor Rutledge, we are having trouble hearing you.
Can you hear me now?
Yes, we can.
Thank you. I'm sorry about that. My name is Najri Rutledge, and I've been in a unique position not only to serve as a professor, but as an associate judge. So I've actually signed hundreds of search warrants in my career. So just a little bit of background, a search warrant is what gave the officers the lawful authority to be there if the facts are as they have been presented. And of course, this case has been just very confusing, and trying to get to the truth of everything has been challenging. But a search warrant has to be based on probable cause and an affidavit. So number one, we know that it was a different officer who swore out the affidavit than the officers who executed the search. When I look at the affidavit, and the search warrant affidavit is on the internet, by the way, it's about 8 pages long. And anytime you challenge a warrant, you've got to look at the probable cause statement in that affidavit. And I found about 5 or 6 things that concern me. The first thing I want to talk about is the whole notion of it was a no-knock warrant. Most warrants are in fact knock and announce, and that's done under the law to prevent violence, to protect the resident's privacy, to protect from property damage, unless they apply for a no knock. And in this case, the officer did apply for a no knock, seemingly because he was concerned about safety or fleeing or surveillance cameras. The problem is Breonna Taylor did not have a criminal record. There were no surveillance cameras. And it was at night. So the officers also claimed that they did in fact knock. I would actually say that whether or not they knocked, or is a knock and announce or not, in some senses, that part is almost meaningless because of the Supreme Court, right? The Supreme Court has, in my mind, made the distinction between knock and announce and no knock meaningless. They only require that you have a reasonable amount of time. Some courts have said 20 to 30 seconds is enough. If you could imagine being in a dead of sleep and someone banging on your door in the middle of the night, could you get dressed and get to the door and answer it within 20 to 30 seconds? Probably not. And there have been studies of officers who have admitted that they tend to announce the same time they're breaching the door. So that's a big problem in the law we really need to try to consider. Other procedural issues in the warrant I would start with Judge Shaw. When she was presented Breonna Taylor's search warrant, she was given a stack of 5 warrants. And I think it's very possible that the probable cause for the target, Jamarcus Glover, was kind of bootstrapping the search into Breonna Taylor's home, and that's a problem. There has been some discussion about how long it took her to review those warrants. That may be a problem as well. But besides that, if we look at the facts that set out the probable cause, they only have 3 that they listed. One was they observed her vehicle. 2, there was a package, and 3, the postmaster. And the postmaster is the potential fabrication. So let's talk about observing her vehicle. According to the affidavit, they observed her vehicle in front of a trap house or drug house on different occasions. Now, you don't have to go to law school to know that different occasions is a very vague term. We have no idea if that was 5 years ago or last week. That's a problem because a search warrant cannot be stale, right? The judge has to have probable cause or reasonable basis to believe that at the time they're signing it, that there's going to be evidence of a crime present at that location. So that was one of the problems. The other problem with observing her vehicle, there's nothing in that affidavit that they ever observed Breonna Taylor in that vehicle. They just said her vehicle was observed on different occasions in front of the house. We don't have that she was inside the vehicle. We don't have that she was exiting the vehicle. We don't have that she ever engaged in any kind of hand-to-hand drug transaction. None of that was present. And without that, how can you get into her home? The second fact that they let out for probable cause was the package. They said that on January 16th, the main target, Jamarcus Glover, was seen going into her home for a short period of time and left with a package. And then at some point, he went to a known drug house. So there are a lot of problems with that statement. We don't have x-ray vision. We have no idea what was in the package, neither did the police. They just thought it was suspicious. Also, the observation that was made in January, that's about 2 months before the warrant was signed. And that package was seen leaving the home, not entering the home. So was there a reasonable basis to believe that there was going to be packages or suspicious packages or drugs in Breonna Taylor's house when that's all that they have? There was no mention of any additional investigation, no mention of packages being intercepted to actually find out what was inside. And then we get to the third, more controversial fact, which is the postal inspector, which now seems false. The whole thing about the package that the officer did witness 2 months ago, he bolstered that statement by saying, and I'm going to quote it, it's in paragraph 9 of the affidavit, "Affiant verified through a U.S. postal inspector that Jamarcus Glover has been receiving packages at Taylor's address." He also stated through his training experience, "It is not uncommon for drug traffickers to receive packages at different locations to avoid detection. Glover may be keeping narcotics and or proceeds at the apartments for safekeeping." May be, and that's the big definitive word. Even if that statement were true, holding suspicious packages should result in further investigation, a discussion, or maybe a warrant execution in the daytime instead of the middle of the night. Now, the affiant went ahead and said that he did not actually confirm that with the postal inspector. So that statement is false. What we now know is that he called an officer friend, potentially Officer Mattingly, who called another friend at another police department, who called someone who actually said, well, maybe just some Amazon boxes. Another person said, nope, no packages. And we know that the postal inspector in Kentucky said no suspicious packages. And that's certainly a big problem. So I think to your last question, does that call the whole warrant into question and invalidate it? I would love to hear what the other panelists think about that. I think probably not invalidated. I think if we were dealing with a motion to suppress, we would have a special Franks hearing and the evidence, if there was evidence, would be suppressed. The whole language about verified through a U.S. postal inspector, you can include things in an affidavit that are the product of hearsay. So was it the officer's intent to mislead? Was it sloppy police work? Or was he intentionally trying to do this? It can be construed different ways. I don't know if that particular lie or fabrication nullifies whether or not the officers, if they were there in good faith, does that automatically nullify that they were acting in self-defense? And I would say probably not, but I'd love to hear what others think.
So I'm actually curious because Detective Mattingly, like you said, was the one who actually interacted with the post office, and he's the one who is helping execute this warrant. So I'm wondering how his attorneys or how anyone can argue that he is acting in good faith when he in fact knows there are no suspicious packages there, because through the grapevine, he's heard that from the post office and through his friends at the Shively Police Department. So I think that directly goes to the good faith execution if you have one of the parties involved, which Attorney General Cameron actually said they were two separate parties. That's not the case. So I think that really takes away from the good faith argument.
I agree. The packages, I think it didn't actually even say suspicious packages. They said packages. So it was very vague in the search warrant. But that is definitely a red flag that Mattingly was involved in the execution and has some involvement with verifying this information. There was also another Detective Kuzma of Shively PD who said there were no packages sent. So like I said, this case is such a cluster, and I think it's really eroded our trust and integrity. So we don't really know what all the facts are. That's part of the problem.
Also related to the warrant, what were some problems with the execution of the warrant?
Hi guys, thank you for being here. We really appreciate the interest in this subject because obviously, as Professor Rutledge just indicated, from our perspective, this really, the lack of information and clarity about what's gone on in this case has contributed to a real lack of distrust in the system, some of which obviously has been there far preceding this case, right? So I want to talk a little bit, just jumping off on all the fantastic things Professor Rutledge just said, because I think all of that is absolutely right on, about what then happened in terms of the execution, right? And there's multiple things that happened in terms of the execution that I could point out. And again, I suspect that even though I have tried to be very thorough in my knowledge about this case, things seem to always pop up that I have not seen. So please, if any of my co-panelists know other information than I know about the execution, please feel free to jump in. But from the very beginning, one of the things when you execute a warrant, if you're law enforcement, just again, from your own protection, self-protection standpoint, you want to have as clear a picture as you can about what's going on in the location that you're going to execute the warrant at. And what we know is that they did not have a clear picture of what the story was at Breonna Taylor's apartment, right? They thought she lived there by herself. They had no information about the fact that her sister lives there, that her goddaughter normally lives there. Frankly, again, it's in many ways by a stroke of luck that we were not also home at the time that this happened, right? So they didn't have that kind of information, which you would normally hope and expect, and they would hope and expect to have, again, as accurate information about who's in the house as possible. Likewise, that evening, they didn't know that Kenneth Walker was there with her, right? So they started looking at the apartment, but again, because of this decision to execute it in the middle of the night, even though the two of them didn't get home until I think it was around 10 o'clock, or maybe the execution, maybe the observation started around 10 o'clock, but either way, they didn't realize there was another person inside the house, right? They only knew about Breonna Taylor. So that's another problem with what happened in terms of the execution, in terms of them having full knowledge of what was going on inside the apartment. The other thing is, along the lines of officer safety, because officers don't know what's going on inside an apartment, the standard operating procedure is to have an ambulance on standby. To have an ambulance on standby that knows the route to, and has been mapped out, a route to a Route 1 trauma, a route to a Trauma 1 center, right? In case anything does go wrong, right? In case something goes wrong, you have the ambulance there, easily accessible to take the person that might get injured to a hospital, right? Putting aside any questions we raised that is the norm, right? And the problems that presents, that is the norm. And in this case, they sent the ambulance away before executing the search warrant. Unclear why that happened, but that in and of itself created many of the issues that arose later on, including probably contributing to Breonna Taylor's death. So then, we know that Walker shot when he first observed someone come in because, again, of the issues that Professor Rutledge talked about in terms of knock and announce, and whether they knocked and whether they announced. And it seems clear, obviously, that the people inside didn't know who was coming in, right? Didn't know who was coming in. So after Kenneth Walker shot the one shot that he shot, law enforcement is trained to eliminate a threat. Basically, if you're getting shot at, you shoot until the threat is gone. The thing that we don't know, again, back to information we don't know, Cosgrove shot 16 times. So one thing that raises is the possibility that he emptied a clip and then put a new one in, which would then suggest that there should have been a point at which he stopped shooting to make sure that there was to do a threat assessment, right? And the fact that there were 16 bullets shot from his gun suggests that there was no there may have been a change in clips and that there was no stop to make sure there was no longer a threat assessment. And we know from the FBI that it was one of Cosgrove's bullets that for sure hit Breonna Taylor. That's one thing that, again, Daniel Cameron said it wasn't clear from the KSP report, but we know that he mentioned that the FBI had determined that that Cosgrove's bullet hit. So, obviously we also know that Officer Hankerson went rogue. We've heard about some of the ways in which he kind of went rogue, but there are some other ways in which he went rogue that directly impacted what happened, right? So in addition to the fact that he started shooting from the parking lot and that we're sort of unclear where his bullets went, right? Obviously we know that some of them went into the apartment behind Breonna Taylor's. What Cameron said was that there was nothing conclusive about whether his bullets hit Taylor. But we also know that contrary to General Cameron's assertion, some questions remain as to whether the bullet that shot Mattingly actually came from Hankerson's bullet or not. There's just a lot of uncertainty there. But what happens is that once Mattingly is shot, all the attention turns to Mattingly. And because of this, getting back to the issue of the ambulance, because the ambulance is not nearby, they're then calling the ambulance. They're trying to get the ambulance through. The ambulance is trying to ram a gate, can't get through the gate, gets stuck at the gate. And so all attention turns on trying to get Mattingly to the ambulance by putting him on top of a car, driving him to the ambulance. But the fact is the ambulance can't get in. Around this same time, probably before this, Kenneth Walker has called 911 because Breonna Taylor has been shot. So at that point, law enforcement should have been on notice that someone in the apartment has been shot, right? And so there should be an attempt to get at least another ambulance there, right? Even if you're concerned about Mattingly, there should be something going on when you have heard that there is someone else shot in an apartment and perhaps not doing very well, right? I'm barely breathing from what you can tell. But at this point, and this is where, again, Hankerson going rogue kind of comes back in, is that he's heard on the radio as the ambulance for Mattingly is trying to get through, telling responders that a shooter is barricaded inside the apartment with an AR-15 rifle. That information is patently false, right? And there's no basis for that information. But him telling information affects then what happens subsequently in terms of the response. If you've been told as law enforcement that there's an AR-15 and somebody barricaded inside, you're going to respond differently, right? And so, as Officer Mattingly is being lifted onto the trunk of this car to try and get him over to the ambulance, other officers from this SWAT team, right, that has been executing the warrant down the road that had no idea that these guys were going to try and execute at this particular location at this particular time, are coming over to try to help figure out what's going on, right? And it's not until those SWAT team officers enter the apartment after Walker's been taken away that anybody finds Breonna Taylor, right? And that period of time of 20 minutes or so is critical, right? I mean, obviously, if an ambulance had gotten there sooner, that could have made a difference. We don't know the answer to that, right? So I think those are sort of the key issues in terms of the execution of the search warrant. Obviously, some of the things that get raised by the execution are things that are not legally problematic, but that implicate the entire system, right? So things like the fact of executing the warrant in the middle of the night, right? Which, technically speaking, it's permitted, right? I mean, there is case law out there that says that's permissible, right? And I know that was discussed obviously in the previous panel. The issue of the knock and announce issues that Professor Rutledge has raised, right? That all has to do with how the warrant is executed as well. And the fact that you can, even if you are knocking and announcing, it can be as few as a few seconds, right? When you say, I'm here, and then you barge in, right? Again, if we're really concerned about everyone's safety and trying to make sure that things are happening in a way that keeps people safe, that shouldn't be the case, right? And so even though legally there is not necessarily a problem with that on its face, I mean, again, other than obviously the issues that Professor Rutledge has pointed out, the fact that knock and announce is what it is problematic in and of itself, right? And so I think those are the main issues. There may be other things that other panelists are aware of that I'm unaware of, but those are at least some of the ones that caught my eye.
So if I could jump in and maybe follow up on a few of the points that Professor Rutledge and Professor Lawler both raised. And I want to, I think that the knock and announce principle and the daytime entry principle are both really, really critical here. And I want to just, I agree with them that the courts in recent decades, I think, have done a terrible job of articulating what those rules are and how they need to be followed. And so I'm going to read just a few snippets of some really old cases, right? And so here's a case from 1757, a British case, right, before the American Revolution. What are we trying to accomplish? What's the requirement for why we're knocking and announcing here? And the court says, well, no precise form of words is required. We don't have a particular thing you have to read. But the key here is that so long as, quote, the party hath notice that the officer cometh not as a mere trespasser, but claiming to act under a proper authority. The question being articulated there is, are the police doing something to adequately convey to the people inside that they are coming with proper legal authority and they are not mere trespassers? That's the purpose of why police need to knock and announce. A separate case from 1819, and this, when I read it, is just a description of Kenneth Walker and what he experienced that night. Without an adequate announcement of proper legal authority that the person inside can understand, quote, how is it possible for a party to know what the object of the person breaking open the door may be? He, the person inside, Kenneth Walker, has a right to consider it as an aggression on his private property, which he will be justified in resisting to the utmost. Those are the principles announced in these early cases about what knock and announce is about. And I think that the idea of pound on the door a little bit, yell police warrant once or twice, and then break in, the idea that that is accomplishing those purposes, I think, is completely, missing the point. It needs to be combined then also with the daytime entry rule that's been discussed briefly, but the Supreme Court has never told us yet, the US Supreme Court, whether the daytime entry rule, like the knock and announce rule, is also part of the Fourth Amendment. But I would say there's a very strong case to be made that absolutely it is. The common law authorities in the 18th century made it very clear that the presumption is that warrants need to be executed during the daytime. There are some exceptions for when you can do it at night, but the presumption is daytime entry. If you look at how the Supreme Court decided Wilson versus Arkansas, the knock and announce case, it should be a very similar analysis. Was this a common search protection at the time of the founding? Yes, it was. Therefore, it's part of the Fourth Amendment. So I'm going to say, yes, absolutely, daytime entry is part of the Fourth Amendment. And when you put these two together, as others have said, when police officers show up in the middle of the night and are trying to knock and announce, Professor Rutledge, I think, put it exactly right. Have you ever been woken in the middle of the night by someone pounding on your door? How long is it going to take you to wake up, to understand what's going on, to understand that it's a law enforcement officer outside? The police should not be doing an entry like this at nighttime, but if they are, the time that they're going to need to wait to be able to be satisfied that the people inside have woken up and they understand that we are law enforcement officers here trying to execute a warrant and not somebody raiding your house in the middle of the night. That's a fundamental principle, I think, that's being lost. So I think that daytime entry and knock and announce, the courts really need to take those seriously and revive what are really substantive, serious protections that existed hundreds of years ago. And I think the courts have really just diluted down to almost nothing today.
I completely agree. I think it's also complicated by the war on drugs. And there's so many exceptions that the court has allowed for knock and announce: concern about destruction of evidence, fear of escape, exigency. So even if, they need to do both, because every time there's a drug case, they just assume, oh, it must be a violent crime. So just playing devil's advocate from the law enforcement perspective, that also gives people who are suspected of crimes the opportunity to destroy evidence, to arm up, and to potentially cause harm to our officers. So we need to look back at the laws and consider all of that.
I think too, we need to look at the factual context, because it may be that the people inside the apartment are being considerate of their neighbors. And these days, not that I'm saying that Professor Rutledge is the only person who's going to wear a McDonald's drive-by headset, but people, if they're watching something or listening to music, they're going to have a headset on, which makes it even less likely that they're going to hear anybody banging down the door. Sorry, Professor Rutledge.
Returning to an issue that I think was in panel 1 and that we've briefly touched on here, should there be a requirement that officers must be on the premises lawfully in order to claim self-defense?
So I'm going to take the first crack at this one. And as Ms. Hanshaw points out, this was discussed extensively in the first panel, right? And so I'll make a few comments on that, although I want to make some broader comments first, which is that the panelists, I think the first panelist correctly identified one of the key issues here is the initial aggressor rule, that for any of us to claim that we're acting in self-defense, there's a limitation that we cannot have been the aggressor who created the situation. And often the word unlawful is thrown in there as well, that if I'm lawfully using force, I'm not the initial aggressor, but if I'm unlawfully being an aggressor, then I cannot lawfully use self-defense when I'm confronted with force. And there was an extensive discussion, which I followed carefully and which was really interesting, about the intricacies of the initial aggressor rule. And I guess what I would say is, to step back a bit, is there's a puzzle here, which is that law enforcement, there's a lacuna, there's a lack of law, right, that as directly applied to law enforcement officers in terms of their criminal liability for these types of things. If you look ostensibly under the Kentucky statutes and in most jurisdictions, the law of self-defense, the limitations on self-defense are the same for police officers and for the rest of us. The self-defense statutes that were being discussed, the homicide statutes that were being discussed, they're not distinctively written for police officers. They are uniform. They apply to all of us equally. In practice, however, of course, it is the case that, first of all, there's very, very, very little case law explaining exactly what those principles mean as applied to law enforcement officers carrying out their duties, because there have been very few prosecutions historically. And so we have a lot of case law talking about when individuals act in self-defense, what are the exact rules, the complicated rules about initial aggressor and who's the initial aggressor. We have very little talking about that for law enforcement officers specifically. And I think when you do see courts talking about law enforcement officers specifically, it is very common to see as a general trend that courts of appeals have a sense, I'm just going to call it a sense, right, that the rules should be a little bit different for officers than they are for ordinary people. After all, officers are charged with using force. So it feels like the rules maybe should be a little bit different. The problem, of course, is that they're not written differently. And there's not a body of case law that lays out exactly what those differences would be. And so I think we're left with a lot of, a lack of guidance on exactly what those principles are. Professor Monu Betty at DePaul actually wrote a brief article at one point suggesting that, well, in another context where we have people who use force and are subject to a chain of command in a kind of unique context, and here I'm talking about the military, we handle that by having a separate system and a separate set of rules, the Uniform Code of Military Justice. We create a separate set of rules that are designed specifically in mind to think, in the military context, what should the rules of criminal liability be? What should the defenses be? Some of them are very analogous to what we have in our regular system, and some of them are different in certain ways. And he has suggested that perhaps there should be a set of specific rules designed and written to govern police officers. What we find today is a case goes up on appeal and a court is trying to decide what are the rules we're going to create for law enforcement officers. We have very little guidance from the case law. What should those rules be? And the courts have some sympathy for law enforcement, for the position that they're in. And instead, perhaps we need a more comprehensive, a more well thought out set of rules that directly apply to law enforcement. So we don't have this strange dynamic where ostensibly they are subject to the same rules as the rest of us, but in reality, the courts are not going to apply them the same way that they apply them to everyone else. And then I guess, you know, the very few, you know, looking at some research in preparation for this particular question, I would say, you know, there's very little case law talking about in what circumstances a law enforcement officer considered to be an aggressor who thereby cannot claim self-defense. But there are some cases suggesting, and in particular, you know, most of the law I found on this was from the early 20th century, from the early 1900s. For example, an early treatise, Wharton on Homicide from 1903, says that so an illegal arrest is an act of aggression upon the part of the officer making it, which will prevent justification on his part on the ground of self-defense. So that if he, you know, if the officer is not acting lawfully in making an arrest, then he is the aggressor and loses the status of self-defense. And there's several other cases from the early 1900s so stating. Again, I can't find any cases from the last 50 years stating that, and really can't find any cases saying much about it one way or the other. And so I think that there's a problem here of a lack of legal development, a lack of legislation that is designed to explain what are the appropriate rules for law enforcement officers, and in what case, in what circumstances should they have a justification defense, and in what circumstances is it appropriate to hold them criminally responsible.
I want to jump in here. I completely agree with everything that Professor Whitmer-Rich was just saying. One thing I wanted to point out is that Kentucky has a statute, their self-defense statute, generally speaking, that has basically, you know, again, you can be the first aggressor, defensive force if somebody's coming into your house, but they have an exception specifically in the rule in the Kentucky law for law enforcement. This gets back to Professor Rutledge's initial point and the conversation previously about knock and announce, right? So what the law specifically says is that, you know, you don't have the presumption of self-defense if the person against whom the defensive force is used is a peace officer who enters or attempts to enter a dwelling or residence, again, it could be also a vehicle, in the performance of their official duties, but the law also requires that the officer identify him or herself in accordance with any applicable law. And so I think so much of the conversation is turned on whether they actually identified. Obviously they knocked, so normally you'd have knock and announce, right? You know, so why would you knock if you weren't announcing? Well, the critical part of that is if they didn't announce, then, you know, then for sure, Kenneth Walker has an absolute self-defense requirement. If they did announce, that gets more drawn into question. And so, you know, as Professor Whitmer-Rich pointed out, there's a dearth of case law dealing with law enforcement specifically, but I do think it's worth pointing out that there is that exception sort of carved out into the rule here in Kentucky.
And as Professor Whitmer-Rich kind of pointed out, you know, maybe some more legislation would be helpful. So what are some other potential solutions to insufficient search warrants?
So I think I'm going to take the lead on this one. I'm going to try and share my screen, have just a small PowerPoint to kind of guide discussion. So give me 1 second. I'll see if I can do this. And if I mess it up, I apologize for every professor I've ever given a hard time about their Zoom capabilities. So let's see. I have PowerPoint. Uh-oh, 1 second. See, well, sort of unforeseen consequences.
Would anyone else like to chime in while Mr. Dixon is getting his PowerPoint ready?
Having been the professor on that side of things, sometimes I think we're all willing to give him a little bit of grace here.
Well, it appears that I'm not going to be allowed to use my PowerPoint unless I close out of the Zoom app, and I don't want to risk that, so I'll just kind of roll with it. It was mainly just kind of getting big pictures across, so I'll post this in the forum later. But so when we're talking about solutions to insufficient search warrants, I think it's important that we identify readily accessible, smaller solutions while not being afraid to think of larger ones. Because this problem of insufficient search warrants is clearly applicable in this case with Breonna Taylor, but it also goes to a larger problem of police accountability as a whole. And so when we talk about smaller procedural safeguards, some of the solutions that have been suggested include defense representation present during the presentation to the magistrate judge. and a closed hearing to go along with that. And so I think as a start, that would help. And whether you have that be a person with that is their permanent job of contesting search warrants, just ensuring that police officers and applicants seeking to get these search warrants are doing their due diligence to ensure that they are following the probable cause standard, and we don't see judges functioning as more or less a rubber stamp. Professor Rutledge mentioned earlier that there's a time discrepancy as to how quickly Judge Shaw signed these warrants. I was looking at the police reports earlier, and she signed 5 warrants for that evening in about 12 minutes, which I would venture to say is terribly inefficient and insufficient to actually determine whether or not probable cause exists to support these search warrants. And so I believe if you do that in a closed hearing with some type of defense representation present, that'll kind of ensure that everyone is doing their job. Another potential solution, again, a smaller procedural one, is that we could have an extra layer of review before that even reaches the judge. And this would be done by perhaps like an assistant district attorney or someone in that prosecutor's office saying that they themselves have to sign off on search warrants before they get to the judge. Again, we just want more eyes on the problem and want less of a chance of shoddy police work getting passed on and inflicting harms on citizens. I've got a lot of friends and colleagues who are taking the MPRE today, and they will tell you that prosecutors are held to professional conduct standards that are higher than police officers are. And so I think that having them be the person to tell the judge, hey, this is a good warrant, we need to have this served, I think will go a lot further in ensuring sufficient police work, but also making sure that people's rights are defended properly. And then another potential solution that has been proposed is having an additional affidavit to support no knock and announce warrants. So I think that if we are going to operate under the assumption that no knock and announce is a good policy, then I believe surely we should have an additional affidavit outside of the original one, because we saw in this case, this no knock warrant for Breonna Taylor's apartment, which subsequently allegedly got changed to a knock and announce, was lumped in together with all these Jamarcus Glover warrants. And so what happens then is what happened here is that a lot of that information was copy and pasted from the other affidavits into Breonna Taylor's. So in the first panel, they talked a lot about the facts of the case and how there's no evidence that there's suspicious packages or anything. And I think if you had an additional affidavit, that would at least, again, provide another small safeguard for something like that getting through. That being said, I think the no knock and announce warrants are bad public policy, just because, again, if bad things are more likely to happen, which is why I usually have a higher requirement to get them. So if someone is breaking into my apartment at 12:40 in the evening, I'm not going to assume that it's the police, and I might react more rashly and with a higher chance of using deadly force if I have a gun or what have you, which again is bad for police officers and bad for citizens as well. I'm gonna move on to some bigger procedural barriers that we have, and after I get through my whole spiel, I'm gonna ask for some assistance from my much more educated and practiced colleagues to explain these concepts, because I've been working with them for a far shorter amount of time than they have. But those two, I think, that interact in a very negative way are qualified immunity and the Leon exception for a good faith belief that you're executing a warrant properly. So in a nutshell, qualified immunity states that when a public official is performing a discretionary duty, they cannot be held civilly liable unless they are clearly breaking a clear statutorily or constitutionally protected right. And so what ends up happening in a lot of these cases, and with Breonna Taylor's case, is it's not the police officers who are paying out these settlements, it's the city, which then turns out to be taxpayers funding police misconduct. And so when you have that combined with the Leon exception, which, for some background, generally speaking, there's the doctrine free the poisonous tree, for those of you who are not law affiliated, but essentially saying that if you don't have a proper search warrant or Miranda rights aren't read, that you don't get to use the fruits of your bad labor in trial. So you don't get the evidence in if you didn't follow the rules. But with the US v. Leon in 1984, we have the Supreme Court laying out an exception where officers, if they're acting in good faith that the warrant was executed properly or signed off properly, then that evidence can still come in. And so I think when you have these two doctrines interacting with one another, it really generates a culture that kind of distances itself from police accountability, because if they can break the rules and they're not held civilly liable and their evidence still gets in, I don't see how that is going to lead to good police work or a positive interaction with citizens. And so then moving on, we have, I think, with this problem, we can't ever let ourselves think too small. And so this problem of insufficient search warrants comes in tandem with problems I think we're having overall with our police and police forces across America, and a lack of accountability and kind of a disconnect between police and the citizenry that they are in charge of policing. And so I had a chart pulled up for you all, but I'll tell you the long and short of it. There's a big split amongst Americans on their support of the police. So this is a 2019 survey by the Congressional Research Office, and they're saying that if you're white, the odds of you believing in the police are 59%, and if you're not white, it's only 40. So that's a big, very big discrepancy. Political ideology, if you're a liberal, odds of you supporting the police and thinking they're doing a great or good job is only 33%. If you're moderate, it's 46%. If you're conservative, it's 75%. And so if the breakdowns along age and demographic show that as a society, we do not collectively believe that our police are acting properly. And so we have to ask ourselves, how do we fix this problem? And so we've seen, especially in recent months with all the protests that have been going on, there's been talk of a defund movement, which I think has suffered from its own messaging, because if you're talking about defunding police, that sends all these scary words and thoughts into people's heads of a lawless society where there's no police anywhere. So I think we think of that more as a restructuring of police forces, where they are tasked with not as many duties and are not expected to do as much, and therefore are not getting the same, and reallocating that funding to different offices that can handle those problems correctly, such as homelessness, drug addiction. We've talked about the war on drugs and about how it has led to a number of constitutional failures. I think that if we focus on reallocating police funding to organizations and agencies that can do those jobs properly, that again, we have more trust in police. Then we also could talk about, we've seen conversations for complete restructuring and re-overhauling of police departments. And there's been talk of that in Minneapolis following the George Floyd case, but we've actually seen it happen and seen it working. So you have Camden, New Jersey, who in 2013 completely started from scratch because they had a distinct lack of confidence in their police force and just did not believe that it was serving their community properly. And so they axed 250 officers and built from scratch. And since then, their violent offense rate has dropped 42% and their murder rate has dropped over 50. So I think that as lawyers and as public policy people looking to make our society better, we shouldn't prevent ourselves from looking at any particular solution. And then the two final ones before I would like to ask for some help on qualifying immunity and Leon exception would be our overhaul of training of police. So I am a third-year law student, and I cannot tell you how many hours that I have devoted to learning the law and being able to apply it to a situation. I do not get a gun and go try to enforce those laws. And so for police officers, again, this is where charts would be great. And so again, I'm really sorry, Professor Cook and Lawler, for ever complaining about Zoom not working, because visuals are very powerful and I'm not able to provide that right now. But a police officer in Louisville and Lexington have on average about 30 weeks of training before they are put out into the field. Okay, so then that turns into roughly 1,000 hours of training. And so in the United States, in order to become a lawyer, you need over 4,000 hours of training. To become a nurse, you need over 4,000 hours of training. To become a plumber, you need over 3,000 hours of training. And to become a cosmetologist, you need over 2,000 hours of training. And I don't believe that anyone in this Zoom meeting could say that it makes more sense to have cosmetologists requiring twice the training of police officers. And then we have by country, I think the United States could look around the world for some insight on this. because there are plenty of countries who view this as an actual problem and worth addressing. So you have in Western Europe, Vietnam, Dubai, Finland, India, all these places require over 4,000 hours of training. And what that looks like is a 2 or 3 year college degree to be a police officer. And you're trained not just in combat, but in sociology and psychology and how you can properly police people in a way that doesn't end up with them in a body bag. And then finally, I think that a key thing that would perhaps help communities interact more positively with their police and vice versa is some form of oversight. So in the United Kingdom, you have all police departments reporting to one national oversight service. And I understand that this may cause federalism concerns. And, you know, we as Americans, we tend to not want much federal oversight for local issues like education, like policing. However, I think that at this point in our history, we have seen decades of policing that has disproportionately affected poor, Black, and other communities that just does not even come close to upholding the American dream or American ideals. And so I think if we establish national standards, that could help in this problem. But also we need local civilian oversight. There have been experiments around the country with doing local civilian oversight committees where they are comprised of whether it's just the public or former police officers or what have you, but where they are the ones who look at police conduct, because as has been discussed in this panel and in others, police do a poor job of policing police. The investigations that we see come out are often proven to be false later or biased or what have you. And I think if we have civilian oversight committees, we can and give them teeth to actually enforce their recommendations and decisions, then we can maybe get to an area where, again, we bring that police and community more closer together. So I apologize for being long-winded and for going through kind of a broader thing, but I don't think we can properly address insufficient search warrants without talking about how we think about police as a whole, because as we see, it has real consequences. And Breonna Taylor is not alive. Why? Because we have a warrant that whether it lawfully or not, it's held to be insufficient. It is not sufficient because we have officers, we have Brett Hagenson firing his weapon blindly through her south bedroom window, because we have, again, this combative relationship between civilians and the police that is at the heart of what we're trying to address. So all that being said, I would like to ask for some assistance on explaining both qualified immunity and the Leon exception, how they interact and how they might influence potential solutions for insufficient search warrants.
Anybody want to take a crack at that? I can briefly just comment on the knock and announce principle. As we've talked about that a lot, but of course, in Hudson versus Michigan, the Supreme Court said, if the police fail to comply with the constitutional command to knock and announce, we are not going to exclude the evidence as a result. So the exclusionary rule is not going to apply to violations of the announcement rule. And so, you know, one consequence of that is that obviously there's less, I think, likely less compliance with the rule because the exclusionary rule doesn't apply. And we have less development of the case law about what the knock and announce principle really means. Because even if you have a violation of that rule in a criminal case, you're not going to get suppression as a remedy. So the courts do not discuss it. It doesn't get developed. So that's one, you know, key kind of side benefit, I suppose, of the exclusionary rule is that the law gets developed because there's a remedy that matters and that people litigate over. So
I wondered on the qualified immunity, if it would help the credibility of that doctrine. And this goes back to something you were talking about in terms of the number of hours of training that police officers get. I think that if one of the things you hear about relating to how quickly new officers especially are going to pull their weapons because they've never been in a stressful situation before. I think if we figured out some way to create an incentive for people who have been trained as military police to become police officers in whatever their local settings, that might make people feel a little better about the types of people with that type of training who are becoming new officers.
And switching from the search warrant now to the grand jury proceeding, what were some of the problems surrounding the grand jury proceeding? Professor Abramson, would you like to share your thoughts?
Sure. I mean, I think in terms of trying to identify the problems about the grand jury, I hate to sound like that professor who says in response to every question, well, it depends. It depends on your perspective, because anytime there's a concern about what happened in the grand jury, you're invariably going to fall back on the traditional aspects of the grand jury. Probable cause standard of proof, comparing that to a trial standard of beyond a reasonable doubt. So it's only necessary to show probable cause in order to indict somebody. That, in a sense, wasn't an issue here, although I'll get to it. Second idea with the grand jury is that they're usually hearing only one side of the case, whereas the trial standards in our jurisprudence are based on adversarial proceedings. Third, in the grand jury, rules of evidence don't apply, whereas despite what students who are taking evidence would say, there are too many rules of evidence. The rules of evidence don't apply in grand jury proceedings by explicit exceptions. And so in grand juries, hearsay abounds. I mean, even questions that are asked of a witness can be based on illegally obtained evidence. We have that Calandra case, for example, in 1974. And then the other aspect of what's different about the traditional aspect of grand juries is the secrecy idea. You know, the traditional protocol here is that we want to somehow encourage witnesses to come forward. But the reality is the secrecy only goes to, and we know this all too well, I guess, through the recent litigation and Judge O'Connell's opinion. But the secrecy doesn't go to the witnesses. Witnesses can go out and tell their friends, tell their lawyer, tell anybody they want to, the questions they were asked and the things they said. In any event, I think the thing that is the biggest problem, and so to some extent, that all those traditional aspects of a grand jury are potential problems depending on which side you're on and what you thought the grand jury did that was correct or incorrect. But you know, the bottom line here is that the prosecutors run the show. So you know, here, for example, the prosecutors, and I think it wasn't difficult to deduce this even just based on the Attorney General's first press conference. But as the more and more we have learned, and the more and more changes there have been to what was said at the initial press conference, the prosecutors apparently decided here in advance which offenses they were going to present to the grand jury. And it wasn't based on whether there was probable cause that was satisfied, but it was based on whether they could get a conviction at trial. That's not what the grand jury is for. The grand jury is just to make a decision about probable cause to believe that this defendant committed a crime as well as that there was a crime committed. So once that became their method, the grand jury doesn't appear to have been presented with any other offenses against against Hankerson, and wasn't presented with any offenses against the other two detectives. So based on the statements from the Attorney General, that means that the prosecutors decided the charges just based on looking forward to whether they thought a conviction was possible. And we are, as has been referenced, the discussion by the first panel addressed some of these issues. If you indict on the basis of probable cause, then chances are that there would have been indictments based on some wanton or reckless form of homicide. And then you leave it to a jury trial, including motions for directed verdict, to decide whether first of all, there was wanton or reckless homicide, but also much more important, as it would turn out probably, whether the officers were acting wantonly or recklessly in their decision to use deadly force. So I think a lot of the problems that people identify with the grand jury in this case are just inherent problems that people have with the grand jury. But like I said, it depends, because a lot of people are just as likely to say, well, if the prosecutors take into account the likelihood of a conviction, then what we've done is to spare somebody who has been indicted, spare that person, rather than being indicted, spare that person having to go through a trial, having to pay an attorney if they are able to afford that, as well as a variety of things that can happen to that person's reputation if it's so clear that the person's going to be acquitted. And I think, again, that sort of takes us back to the whole concept of prosecutorial discretion and what prosecutors have the discretion to do. They have the discretion to do a lot of things: who to charge, when to charge, where to charge, dual sovereign problems, a variety of things. Dual sovereign problems here potentially could have been in play if there had been an indictment of all three of these people, especially for homicide. And then you still have the possibility of federal charges being brought for criminal violation of their of the two victims' civil rights. Anyway, I'll stop there and not go to the next question, unless you want me to.
I'd like to jump in on that if I could. I've had the pleasure of serving as a prosecuting attorney years ago, so I've presented to the grand jury. We need to remember that the grand jury is comprised of ordinary citizens. And these ordinary citizens tend to rely heavily on the prosecuting attorney. Prosecutor discretion is very important, but here we're not just talking about prosecutor discretion. Yes, the attorney general and no prosecutor really has to bring a case to the grand jury because of prosecutorial discretion that they don't plan to prosecute, right? If the prosecutor decided, we're never going to bring this, there's no way we're going to get it guilty, we don't have to bring it. My problem with this whole proceeding was the deception. The Attorney General Daniel Cameron said, and I'm going to quote from his transcript of that first conference, that homicide charges were not applicable to the facts before us because our investigation showed, and the grand jury agreed. That's a problem. And then later he said, the grand jury comprised of our peers and fellow residents have made a decision. And then later on, instead of another press conference, he sends a tweet out that he only asked the grand jury for indictment on what he thought he could prove. That's a problem because whether you think he is actually being deceptive or at minimum misleading, it's tainted the integrity of the process. And I think because of that, we really need another special prosecutor and another grand jury impaneled.
And the interesting thing about special grand juries, or maybe somebody would find it interesting, is that in Kentucky, a special grand jury is more or less defined as a group that can be impaneled by the chief circuit judge of that circuit, and they can sit for up to 90 days and even be renewed for 90 days, whereas in Kentucky, the typical grand jury is there for 20 days. And I guess as soon as their 20 days are up, they're out. And so a special grand jury has that ability has the time because of the statute to hear from people firsthand, rather than the typical seamless story that's presented through hearsay. And and of course, one of the things that we talk about with our students is it's sort of a good news, bad news. The only indication in Kentucky law, and I think Kentucky's relatively progressive on this point, only possible sign of something progressive is that a defendant who's been indicted is the only person who's entitled to find out what happened in the grand jury room, other than things relating to the vote. And I don't know whether the redactions that occurred in this case were beyond the scope of that rule, but in any event, that's the good news. The bad news is if everything was presented by hearsay, what the heck good was the broad scope of disclosure? And forget the fact that somebody may have forgotten to turn the recorder on or plug it in. And you think I'm kidding. And students have come back and said, yeah, my prosecutor I worked for said that happens often. Anyway, so I think I agree with you that the statements that were made by the Attorney General in that initial press conference, I think led us to believe that what happened was not what happened.
I want to jump in also to piggyback on Professor Rutledge's comments. Two things. One was that at the time, the other thing that struck me, what he said that has turned out to be problematic in some way, is he said, by my count, it was 4 times. I haven't gone back. You apparently have a transcript, so I have not gone back to look at a transcript. But by 4 times, he said the grand jury found the shootings to be justified. And at the time, it raised the question to me, because for those familiar with grand jury processes, again, all you need is some evidence that somebody committed the crime to find that it's probable cause, right? Jurors aren't usually allowed to be considering evidence of justification, which would be a defense. And so when he said that at the time, I thought, that's interesting. So did they present justification to the jury? Obviously, we found out they didn't get any of it, right? But that, so then, that at least explains a little bit about why that didn't make sense at the time when he was saying that. And back, another point that Professor Rutledge made that I think is very important is, again, that grand jurors are ordinary citizens. And so the statement we have from the one grand juror who has come forward already said, we asked to see more of a video, and they said not to worry about it, right? And I think it raises, I'd be curious, I was not a prosecutor, but obviously Professor Rutledge was, and maybe some of my other colleagues here were as well. At what point, if a grand juror asks something like that, do they have the right to really push on that? They're certainly not going to know they do if they do, right? But what's the sort of balance of obligations when a grand juror says, we'd like some more information, and the prosecutor says, sorry, no, right? I mean, is that undermining the grand jury function? Again, the rubber stamp, even though it normally is, when the grand jurors are trying to get more information,
Right. Picking up on that first point you made, the most of the time, the rules in most jurisdictions, the rules about preliminary hearings say the job of the judge is to determine probable cause. There's no room for presenting affirmative defenses because that's not the purpose of the preliminary hearing. Well, if it's not the purpose of a preliminary hearing in an adversary context, it sure as heck ought not to be the purpose of what grand juries are supposed to do in an ex parte context. So again, that's another, just a connection with other rules for other proceedings that could just as easily apply here. But because they're secret and because they're ex parte and because there's not a judge around, we would never hear about these except for this unique situation.
When I was a prosecutor, if the grand jury wanted any information, I believed in being transparent. In fact, if a defense attorney said, can you read this statement to the grand jury, I would read it because ultimately it was their decision. And I tried to shy away from making recommendations. The problem is that is not uniform. That's up to the discretion of each individual prosecutor. And that in and of itself is a problem.
Yeah. And one of the things that isn't, well, I wonder if you, Professor Rutledge, could respond to this too. Some people talk about the idea that the person who presents the case to the grand jury ought to be the person whose case it is. That is, if you present it to the grand jury, you ought to be trying the case because hopefully, maybe by then, you're more familiar with the case. than the person whose job it is, who does nothing but present to the grand jury. Any thoughts on that?
I think that's a really valid point. I think sometimes it depends on the difficulty of the case. You know, if it's a basic hand-to-hand buy bus transaction, that's a simple case anyone could present, or a shoplifting case. But when you start getting to complicated matters, especially involving witnesses, I think that's a very valid point. In the jurisdiction that I served in, I always had the ability. So I wasn't uh, placed in the grand jury division, but as a felony prosecutor, I took many cases to the grand jury, right? And so it was just a matter of the different customs of the individual DA offices. But I think that would be a really good idea, because then you're more familiar with the case, the facts, and if there are any inconsistencies, right? If someone lies to the grand jury, would you ever know about it as the prosecuting attorney, since it's secret?
Yeah, well, and there are, and so would you agree that as the prosecutor who was presenting, you decided which cases to present, you decided which witnesses to call, you decided which documents to show, at least on your initiative, maybe somebody, one of the grand jurors asked for whether there were additional documents. And if at a minimum, I guess, if any of the grand jurors asked you about a recommendation in a case, one of the things that came out, I think, was something about the no true bill business, and there's a 99+% of federal prosecutors get an indictment when they present the case, but sometimes if it turns out, this is sort of a kind of a dress rehearsal for what the trial might look like, in terms of whether the witnesses are strong enough. And secondly, and so you might not ask the grand jury to indict in that situation if the witnesses weren't strong. And also, if it turns out that the witnesses were okay, but their testimony was supportive of a lesser included offense than what you initially thought you might be able to get an indictment on, they're going to get an indictment on that. So that both those situations significantly narrow the scope of situations where you present and the grand jurors, you can't even get a 3/4 vote, which is what the minimum vote is required in Kentucky. So that's another difference. You only have to have 3/4. Only 3/4 of the people find probable cause. I mean, no wonder. Well, Professor Rutledge was being self-effacing, maybe that she could get indicted, but that's where the whole idea about a grand jury would indict a ham sandwich.
But interestingly, less than 2% indict in matters of police misconduct. Right? So the reverse is true too. They can always indict when it comes to any other case, but statistically, when it comes to police shootings, is less than 2%. And probable cause, let's face it, a reasonable basis to believe a crime's occurred, that's a low standard. So I didn't necessarily have to always have witnesses or documents. Sometimes me just giving a statement of hearsay was enough for the grand jury.
Yeah. And so that sort of throws over, your statement that, the grand jury process contrasts with being able to proceed by information. There are about 28 states, I think, can, without any hindrance of constitutional or statutory provisions, can go by information without having to get the okay from the target of the investigation. And in fact, and also, I think about half the states have done away with grand juries altogether. And so, for example, Connecticut and Pennsylvania, I think, use grand juries only for the purpose, going back to what we were initially talking about, for long investigative purposes. If they really think it's important, let's give these people let's give these witnesses an audition and see how they do under oath. But normally, they're going to go by information, which, just for clarification for those who are not law trained, the information is simply a piece of paper filed by the prosecutor with the court saying, hey, I think there's probable cause to believe a crime was committed and that this person committed the crime. Boom, that's it. That's it. That's all you have to say.
I think it's instructive of some of these issues to think about. There were two grand jury proceedings in this case. There was an indictment of Kenneth Walker, which happened very quickly, on murder charges. It was not a weeks-long presentation involving all of the witnesses, all of the footage. It was a brief, I think, likely. I don't know exactly all the details of that, but I think it was a relatively brief, ordinary type of grand jury presentation, and the grand jury returned an indictment, which was later dismissed. In contrast, the grand jury process for the officers was lengthy, detailed. It's the pattern that certainly we saw in the Tamir Rice case here in Cleveland, where in essence, a prosecutor is trying the case in front of the grand jury, except the prosecutor is really serving as an advocate, as a defense lawyer in the grand jury proceedings for the police officers. That's certainly what we saw here with the grand jury proceedings in the Tamir Rice case, where it was an extremely lengthy, detailed, multiple expert witnesses called, and some witnesses in the grand jury proceeding who later spoke to the press talked about how it was certainly a one-sided process. And it was one-sided, that the prosecution had decided they did not think charges were warranted, and they were clearly, strongly presenting the case in that way. And like here, they didn't even eventually present charges to the grand jury. Everyone just kind of said, all right, we did our thing. The grand jury did not return a no bill. They just did not consider charges. And I think, so there's that contrast of how prosecutors behave in grand juries, which is just could not be more different in ordinary cases and in cases involving police officers. And the second issue, I guess, is the question of how to empower grand juries, because grand juries actually have a tremendous amount of power. We talk about how they're completely dependent on the prosecutor. They just do what the prosecutor tells them. I think that's largely accurate as a descriptive matter, but it's not legally the case, right? Grand juries are very powerful entities. This grand jury, had they wanted to, could have held a vote on those murder charges, even though the prosecutor said, I don't want you to do that. You don't need the permission of the prosecutor to evaluate and decide whether you're going to vote on charges. But of course, most grand juries are not going to do that. They don't, they're going to defer to the prosecutor. So a big question then is, what, if anything, can we do to empower grand juries to act with independence from the prosecutor? I will say that here, our system is not at all perfect in Cuyahoga County, but we have an unusual feature where I don't think this is present in most places. The presiding judge, after convening the grand jury itself is selected from a cross section of citizens, as in most places, but the foreperson of the grand jury is handpicked by the presiding judge, not out of the ones randomly selected. A person in the community is selected by the presiding judge. And so, for example, a couple years ago, the presiding judge asked me if I would be the grand jury foreperson and preside over a grand jury. Now, as it turned out, I don't live in Cuyahoga County. I don't live in the county, so I was disqualified. I could not serve on that grand jury. But if I had, I don't know what that grand jury would have looked like, but I would have been interested in flexing the independent muscle of the grand jury a little bit. I would have been a different sort of leader of a grand jury, and to be able to pick people with independence and experience, lawyers, judges, former judges, law professors, that sort of thing, as forepersons of grand juries, I think is an interesting way to try to empower grand juries to not be completely dependent on a prosecutor.
Yeah, historically, there were, and maybe they still survive, maybe in Ohio you still have them, but historically there were things called blue ribbon grand juries, where, going back to you, luckily not being in the correct venue, but blue ribbon grand juries were used when the judge wanted any particular public issue to be investigated. So blue ribbon grand juries would sit and investigate the schools or the sewage system and return reports. And those, except for your local process of picking the foreperson, they've gone away. They've gone away. So the second thing I was asked to think about relates to whether prosecutors can use the grand jury as political cover in police shooting cases. And if so, how so? And why would they do that? I don't think it's confined to police shooting cases. I think theoretically, yes, but going back to one of the things one of us talked earlier about, prosecutors have an ethical duty to do justice. And so sort of to avoid, I guess, to avoid runaway grand juries, which is not, that runaway is not usually used in conjunction with the grand jury, but to the extent that you're looking for some way to avoid indicting police officers, or if you're looking for tougher standards to be used before decisions are made about whether to indict police officers, and it could go, as Jonathan said, it could go both ways. It could go to the person who initially shot, as well as to the police who responded. Prosecutors have an ethical duty to, as they often say in the cases, to do justice. But if, for those of you who are watching out there in broadcast land, it's 3.8a says the prosecutor in a criminal case shall refrain from prosecuting a case that the prosecutor knows is not supported by probable cause. Now, you notice that there's not a corresponding standard which would say the prosecutor in a criminal case shall prosecute a case that the prosecutor knows is supported by probable cause. There's no flip side there. Stay tuned. That's what we're depending on people like Mr. Dixon to, do the right thing later.
So from my experience, utilizing the grand jury to get rid of bad cases is not unusual for prosecutors at all. What's unusual about this case is the misleading statement about what the grand jury did, or at least we hope that that is an unusual activity.
Yeah, and so I'm trying to figure out then, in the typical felony case, I know I'm starting to sound like a promo for Law and Order. In the typical felony case, there's going to be an arrest, there's going to be a preliminary hearing, and in 99.9% of the cases, there's going to be a finding of probable cause, which brings up the whole idea of duplication or an overlap with the grand jury. But I guess what we're, well, I can ask you this, Professor Rutledge. Did you ever encounter a situation where there had been probable cause found at the preliminary hearing, and yet you decided not to present the case to the grand jury? Or is there some sort of moral obligation to follow through with that?
In the state of Texas, we don't have examining trials. The law says that you're entitled to examining trial until or unless the case has been indicted by the grand jury. So what practically happens is there's a probable cause judge who just says, I found probable cause, here's your bail. They have an initial arraignment, but no real hearing, and the case just goes straight to the grand jury.
In the, I think the Tamir Rice case again here is instructive. Professor Abrahamson's question. In the Tamir Rice case, some local civil rights attorneys who were extremely creative, and this is a good story to tell to students to think about your power as lawyers. Nothing was happening in the case. It was being investigated, being presented to the grand jury. It was really taking a long time. And these local attorneys did what good attorneys do. They looked into and read the Ohio statutes. And lo and behold, there is an old Ohio statute that allows ordinary people to file affidavits with a judge seeking a probable cause determination in a criminal matter. And they did that. And nobody had done that in Ohio. I don't know. None of us had ever heard of it. Nobody even knew this existed. But sure enough, there's the statute. And so they filed these affidavits seeking a finding of probable cause. And it was assigned to Judge Ron Adrien, one of our graduates here at the law school. And so well before the grand jury had decided anything in the Tamir Rice case, Judge Adrien, the chief judge of the municipal court, issued a probable cause determination and found that, of course, there was probable cause to support various criminal charges in the Tamir Rice case. it was based on just the affidavits. It wasn't a full-blown presentation, but that's how the process was under state law. And so in contrast then, Professor Abramson's question, the prosecutor did not interpret that probable cause finding as putting on him some obligation to actually try to seek an indictment in the case. He didn't interpret it that way. He simply kind of put it to one side, I guess, and independently decided how he was going to present the case to the grand jury.
Yeah. The other interesting way in which that Tamir Rice case serves as some sort of precedent or assist to what has happened here is that I read a case, I think it was called In Re Rice, where local clergy, I think, in much the same way as the grand juror here, local clergy filed a separate lawsuit trying to get more detail or any detail about what had happened in the grand jury room. And so the case is useful because it repeats some prior case law talking about that a judge has the inherent right to do a go around the traditional secrecy requirements, but in the case decided to deny the claim anyway.
If no other panelists have any thoughts to share on those questions, I'd like to move to our Q&A. Okay, the first question we have is, are there any specific requirements to justify executing a warrant in the middle of the night as opposed to a daytime execution?
So I'll jump. I'm not aware of any, I haven't heard anybody say anything about Kentucky law on this. If anybody knows, I'd be happy to hear about it. Most jurisdictions, I think, unlike Kentucky, do have, like in their criminal rules, a presumption, like the common law presumption, that warrants have to be executed at night, during the daytime, and they often specify the hours. So I think Ohio, it's 7 a.m. to 8 p.m. at night. The federal rules of criminal procedure, 6 a.m. to 10 p.m., something like that, right? Now, there are exceptions. You can get authorization to execute at nighttime, but again, you have to give a reason why you want to execute at nighttime. And that's, certainly in this warrant, there's just no discussion of it whatsoever, because as far as I'm aware, there's no provision under Kentucky law that kind of addresses that specifically. I do think, again, that there's a very strong case to be made that looking at how the court handled history in Wilson versus Arkansas, the knock and announce case, that the daytime entry rule is a part of the Fourth Amendment command that searches be reasonable. Not to say there aren't exceptions to that where nighttime entry might be permitted, but as a presumption, I think there's a very strong case that the Fourth Amendment requires daytime entry unless you articulate some specific reasons and get authorization in the warrant for executing at nighttime.
Yeah, there's a 1988 case that simply recognizes that there's no standard, like you said.
We also have, I'm going to kind of combine two questions. I feel like they're related. The first one is, how can a society hold, or how does society hold district attorneys and attorney generals accountable for their behaviors? And the other question is talking about how we as a society elect our officials, and we elect the officials that end up appointing some of these people. And so, other than maybe our power of our vote, what are some ways that we can hold attorney generals and the like accountable?
I think the main one is the power of the vote. So that's, and that's one of the, it just, A, go out and vote. That's my plug. And B, there is a constitutional amendment right now on the Kentucky ballot related to how long prosecutors and judges are on, serving their terms, right? Is seeking to increase those terms. And this is how that is sort of relevant in that way.
And there's also the possibility of disciplinary action being brought against an elected official who happens to be a lawyer. But I don't think the incidence of that is very broad at all.
We also have a question specifically for Professor Rutledge. Let me find it. It seems that kind of past and current solutions that people are presenting to our government haven't really brought about the change that we need to see broadly. Where do you think that we as a society need to concentrate our efforts to really bring about a difference?
Changing the laws. Right. I
Yes.
think many of you are already doing it as members of the bar and future members of the bar and going in law school. The legal degree is such a powerful tool, right? And lawyers have the ability to do a lot of good. The way our criminal justice system works is if everyone does their job, whether you're going to be a defense attorney or a prosecutor or a judge. If someone drops the ball, bad things happen. If we had a prosecutor's office who had pre-reviewed that search warrant, maybe things would have been different. If the judge, and I hate to play Monday morning quarterback with the judge who signed the warrants, but oh, how we wish maybe if she hadn't have been presented with 5 warrants at once and hadn't combined everything, maybe she would have done things differently. Defense attorneys, who try to fight for the anonymous grand juror so he could be heard. We all have a role in trying to make things better. First, I totally agree with Professor Lawler, voting. Voting matters. Voting absolutely matters. And we've got to make sure that we're engaged. If you can't advocate for yourself and vote, how can you be an advocate for anyone else? And then get involved with the criminal justice system. If there's one area of the law where you can make a difference, it's criminal justice. I love being a prosecutor because the goal and the job of the prosecutor under Texas rules and the ABA is not to see convictions, but to see that justice is done. And to have that power of prosecutorial discretion to make sure that things are being done fairly is so very important. So I think those are some good starting points.
I mean, I think one relatively minor compared to the vote, one relatively minor idea that I think Mr. Dixon alluded to, and I think we teachers have all talked about this at some point when we're talking about search warrants, is to make the standards more demanding for informants. In other words, not just, this person has presented evidence in the past that resulted in arrest. Well, so what? How many convictions? I also want to know how many times was he wrong? Things like that, which would, and maybe this should be a situation where, as you were talking about, Mr. Dixon, the idea of having another layer. And I realize that sometimes search warrants need to be issued yesterday, but those are things that and I understand that if we started having things like that, requirements like that, that more and more police would say, "Oh, I had no idea who the heck he was. It's an anonymous informant, and therefore, well, maybe we ought to have a database of informants." So that we can figure out who has a good track record and who doesn't. But that's nothing compared to the vote.
Kind of related to what you just said, Professor Abramson, someone had a question specifically to you. What changes have you seen in the system from the past kind of up to today?
Are they asking me that because I'm the oldest on the panel or what?
I'm not for sure.
Okay. I have not seen many changes. And I think each of us is from a state where, to the extent that there are differences from circuit to circuit or from county to county, they frequently are a function of, is it urban or is it rural? If you talk to somebody who practices in a relatively rural area, the things they're going to tell you, you can't imagine ever happening in an urban environment where maybe there are that many more pairs of eyes watching what's going on. And of course, it even starts with, how frequently does court meet in the summer? If we assign somebody to be a clerk for a judge in the summer, and most of their reports say, we didn't meet that week or that month. In any event, I haven't seen a lot. I mean, I think there are often proposals made, and sometimes they're enacted, but proposals made for speedy trial, speedy disposition. And I think those have helped, I think, at the federal level. But even then, because of the federal sentencing guidelines, plea bargaining has changed drastically. You know, in federal court, you decide what charge your client's going to plead guilty to, and then they'll present that to the grand jury. It's backwards from what normally happens in state practice.
Okay, I know that we are at our time. I am going to extend this just a little bit longer. I think we have one more really important question. This one is addressed to Mr. Dixon. Do you believe that our generation will finally bring about the change that we need in going forward?
No pressure.
Yeah, thank you. So I think if I read that question, the second part of that was like, or should we wait for the next generation? And I think that the answer is always no. There is never a time where I think we should argue for delayed justice or for incremental justice. I think that it is always time for making the most positive change we can now. And to echo what plenty of other people on the panel have said, voting is incredibly important. And you know, I think I barely made it into the tail end of the millennial generation, so I'm not quite Gen Z yet. But I think that there, particularly in discourse among people around my age, I hear a lot of discussion of the futility of engaging in the electoral process because it doesn't do enough, because you know they don't listen to us anyway. And I think that's kind of a self-fulfilling prophecy that is definitely going to not get us the direction we want to go. Because our options are you participate in the electoral process, you don't, or so the only other way for change besides the electoral process is violence, which is not going to get our country anywhere that it wants to be. So can't speak on behalf of my generation, but if I were to do so, I would just say that it is imperative that we as a collective recognize that our voting block is now going to be out in terms of our numbers. It has at this point, I believe, outpaced all other generations. And so as cliched as it is, like the time is always right for justice. And we do have the ability. It's just whether or not our generation has the drive to do so. So I think that it does, can, and should, but that nothing is guaranteed or promised. And so you have to fight for every step.
Hear, hear.
Well, if no one else has any other insights, Professor Lawler, do you want to speak?
I was just, if you were going to finish up, I was going to say, I think we've been remiss in not thanking Professor Cook for organizing today's panel of events. It's been really fantastic so far, and I hope people will continue to attend the lunchtime session with Representative Scott and the other panels this afternoon.
Agreed. Thank you, Professor Cook.
Yeah, unfortunately, we've reached the end of this panel. Thank you to all of you panelists for your wonderful, thoughtful insights. Thank you to our audience for your attention and your questions. We're now going to break for lunch. As Professor Lawler said, we will have a lunchtime speaker, Kentucky State Representative Attica Scott. That will start at 12 o'clock. Also, if you're on social media, please use our hashtag Say Her Name Symposium if you want to talk about this on social media. And thank you all.
Thank you.
Good afternoon, ladies and gentlemen. My name is Dwight Haggard III, and I am a third-year law student at the University of Kentucky, J. David Rosenberg College of Law. I want to first thank the moderators and coordinators of this event, all the legal scholars and powerful minds who volunteered their time today, and especially Professor Blanche Cook. I now have the privilege of introducing Representative Atticus Scott. I have followed her journey in activism since high school, and I find courage in knowing that she is fighting for justice throughout the state of Kentucky. Her story is truly extraordinary. State Representative Atticus Scott serves Kentucky's House District 41, where she is on the Education, Elections, Constitutional Amendments, and Intergovernmental Affairs, as well as Veterans, Military Affairs, and Public Protection Committees. In 2016, Representative Scott defeated a 34-year incumbent to become the first Black woman in nearly 20 years to serve in the state legislature. I am a firm believer that no weapon formed against you shall prosper. Representative Atticus Scott is a beacon of hope for our Commonwealth. It is with great honor that I introduce to you all our state representative, Atticus Scott.
Thank you so much, Mr. Haggard, for that wonderful introduction. I appreciate you.
You're welcome.
I literally cannot breathe. I can't see my daughter. Where is she? My eyes are burning. I have to take my face mask off of my nose and mouth to cover my eyes. I can't see. I'm falling. Why is this burning my eyes? Why is this smoke so thick? What did we do to deserve this? Black people in Louisville are in the midst of twin pandemics, COVID-19 and systemic racism. Black people are disproportionately impacted by COVID-19, and we are constantly under the terror of the system of policing, a system that grew out of keeping our Black bodies enslaved. White night watchmen would hunt us down if we dared to escape the bondages of human trafficking known as slavery. They would hunt us down and drag us back by our hair to that hellhole of bondage and captivity. What did we do to deserve that? Those watchmen are now in today's police forces. Thank you to the University of Kentucky Rosenberg College of Law for hosting today's symposium focusing on justice for Breonna Taylor. I am honored by the invitation and know that my friends Sam Aguiar and Sam Marcosin have already presented you with the substantive issues in this case. And I am looking forward to being part of this conversation because engaging with young people is what gives my role, my position, my title as a state representative fire to keep going and do this work. This is why I'm standing up for justice, so that our young people today and for the next and 7 generations to come, as my Indigenous siblings would say, have a better way of life than those of us who are here today. I know that y'all have talked about the procedural problems in this case. I know that my friend Dan Cannon is going to talk about the damages. And I know that y'all are going to touch on the role of the feds in the case. And I know that attorney Lanita Baker is going to dig deep into race and police shootings. 224 days since Breonna Taylor was murdered on Friday, March 13th. I want to share with you what justice and community and on the ground has looked like for 149 days of sustained protests, marches, rallies, and powerful solidarity. As we go into day 149 of seeking justice for Breonna Taylor, her family, and her community, with sustained protests at Injustice Square Park right here in downtown Louisville, we are clear that we are moving with continued urgency in this movement for Black lives. And what I experience at Injustice Square Park is love, community, and solidarity. As my daughter, Ashanti, who's a sophomore at U of L, always reminds me, we don't move in fear. I literally cannot breathe. I can't see my daughter. Where is she? My eyes are burning. I have to take my face mask off of my nose and mouth to cover my eyes. I can't see. I'm falling. Why is this burning my eyes? Why is the smoke so thick? What do we do to deserve this? As we wear this burden and as we were being tear gassed during the second day of protests on Friday, May 29th, I asked myself these questions and other questions, like, why were the state troopers in Louisville in the first place? Why were police in riot gear and mobilizing violently against their neighbors who were marching and chanting and laying on the ground and hands up and kids on megaphones? But I saw none of that Just days later, on Sunday, May 31st, in the predominantly white neighborhood of St. Matthews, in the district that I represent, when we were out marching, chanting, and drumming. Yet, the governor called out the National Guard on Black people, and on June 1st, Mr. David Yahya McAtee was murdered by the Guard, and there has still been no justice for him or his family. What is painfully clear to me from captivity, human trafficking, and our enslavement as Black people is that power, domination, and control over our bodies is exerted at every level of government. And as our government sanctioned continued violence against our protests, I asked myself some of the same pressing questions about why this was happening to us. As we plugged our ears in hopes of not having our eardrums burst because of the long-range acoustic devices or assault devices used against us in June and July, I asked these questions. And I'm so grateful to my colleague, State Representative Lisa Wilner, who is currently working on legislation to demilitarize police forces in Kentucky. Why should our cars be blocked off by armored vehicles or weapons of chemical warfare used against our bodies? My child might choose to carry a child herself in the future, and I don't want her exposure to tear gas to harm her reproductive system. But the violence didn't end on March 13th when Breonna Taylor was murdered, or on May 29th when we were tear gassed and I was shoved by a police officer, or when we ducked for cover when flashbangs were used against us in August. Over and over, we have been exposed to trauma on top of trauma and have too often felt abandoned and alone by elected officials at every level, and quite frankly, even some of our neighbors across Kentucky. We felt that strongly when we faced an unjust arrest on Thursday, September 24th, nearly 4 months to the day that we were first assaulted by police. What did we do to deserve the lies that were told about us by police? That we had attempted to firebomb with a flare the beloved library in the district that I represent, the library where my son helped to start a book club when he was in elementary school, the library that I fought for funding for every budget year in Frankfurt, the library. So my teenage daughter launched a campaign to get our Class D felony riot charges dropped, and they were. On November 16th, we go back to court to fight the absurd misdemeanor charges of failure to disperse and unlawful assembly. What I know for sure as we move forward in this movement for justice for Breonna Taylor is that these words from Audre Lorde are so true. When I care to be powerful, to use my strength in the service of my vision, then it becomes less and less important whether I am afraid. I am not afraid. Fear is a weapon to keep us silent, to keep us immobilized, to keep us believing that justice is an impossibility for Black folks, our Indigenous siblings, and other people of color. When we are not afraid, we can build some of the most powerful movements this world has ever seen. We're already doing it. Black women have been on the front lines of justice. My dear friend Shamika Parrish-Wright, the operations manager with the Bell Project in Louisville, has held down the space at Injustice Square Park in downtown Louisville. Injustice Square Park has become the epicenter of the movement for justice for Breonna Taylor. My friends, Rena, Keela, Kalila, Tia, Tyra, Nicole, Jasmine, Carmen, Jamila, Cheyenne, and others have been feeding thousands of people for free, providing PPE to protesters for free, creating safe space for people who are houseless, creating an environment for worship, and de-escalating the issues that arise when folks begin to feel hopeless in the midst of extreme trauma. We knew we couldn't wait for anyone to show up for or with us. We've been the only ones in so many places and spaces protecting ourselves and one another. We are clear that our protests include policy change and include supporting a better generation of politicians, a generation that is growing out of this movement. So let's move forward together into a different world that is built from love and not the sting of lashes, from solidarity and not stolen land that we all are on, from our shared humanity and not human trafficking. I have pre-filed Breonna's law for Kentucky to end the use of deadly no-knock warrants across our Commonwealth. Breonna's law would mandate that officers submit to alcohol and drug testing when they are involved with shootings and other deadly incidences, and require that officers have and use body-worn cameras when interacting with the public. I created Breonna's law in partnership with Sam Aguiar, attorney for Breonna Taylor's family, and with the ACLU of Kentucky and the people on the ground fighting for justice. This is the law that we need. These are all common sense measures to keep us safe from police. 11 legislators of the 100 members of the House across Kentucky have signed on as legislative co-sponsors. 4,100 community folks agree and have signed on as community co-sponsors. I hope that those of you from Kentucky will ask your state representative to sign on as a co-sponsor if they have failed to do so. While policies and practices won't change hearts and minds, legal remedies can often keep people from being paid to inflict violence upon me and other folks who are targets of racial hatred. The fight for freedom must never end until all of us who struggle under the weight of systemic oppression and structural racism are free. And I know we can get there. I became the first Black woman to serve in our state legislature in nearly 20 years because people believe in another Kentucky. As an activist and organizer, I have spent years on the outside of government walls seeking justice. Now, I work with people in my community to bring them inside when and where decisions are being made. That's what we are doing with Breonna's Law for Kentucky. But we know we can't do any of this alone. Zora Neale Hurston once said that love makes your soul crawl out from its hiding place. Move, step out of whatever is a hiding place for you and join the rest of us as we do the work while saying her name, Breonna Taylor. I'm going to turn it back over to you, Mr. Haggard, to facilitate the Q&A, I believe.
Thank you so much, Representative Scott. I really appreciate that and powerful words from you. If we could all give Representative Scott a virtual round of applause, that was wonderful. I know you can't hear it, but I wish you could. If you all have any questions, we can go ahead and take those. Let's see here. I'm going to open up the question and answer. Let's see. Is it possible for you to open up the question and answer, Representative Scott? Can you see?
Let's see. Yes, so I see a question about what is the potential for the state, federal legislatures to perform their lawmaking function adequately and pass statutes aimed at legal reform? Or are we left with our current reliance on the judicial activism for making law that varies with the ideological standpoint of the judges? How dangerous is this for our democracy, given the current political trends in judge appointments that seem to value brutal police power over legal competence, broad humanitarian worldview and experience? That's an important question. So I will start by saying that judicial seats are vitally important. In Kentucky, in Louisville anyway, we're going to have about 43 judicial seats open in 2022, and we're already beginning to look at those seats and supporting people who want to run for those offices. We don't need another judge signing these no-knock death warrants without actually really reading them and asking critical questions and challenging police officers around these search warrants. And yes, the legislature has failed miserably in passing legislation directed at holding police accountable. Instead, what was done my first term in office in 2017 is that the Blue Lives Matter bill was passed to give police even more leeway to murder Black folks with impunity. That's where we are. My second year in office, the legislature passed the so-called gang bill to allow young, especially young Black and Latinx folks to be racially profiled by police and have enhanced sentencing when they are involved in minor activities that anywhere else, like I mentioned, St. Matthews, predominantly white area that I serve, white kids can walk down the street in groups and not be harassed by police. So instead of doing its job, the legislature has failed miserably and continues to do so. I've asked the Speaker of the House, Speaker Osborne of Oldham County, right next door to Jefferson County, for a hearing on Breonna's Law for Kentucky during this interim session before the end of December. He told me about a month ago he'd asked the chair of the Judiciary Committee about that, and I have not heard anything since. So I followed up with him last week and haven't heard anything back yet. So the reason why legislative bodies can do this is because the people are withholding their power. You, the people, including young people, students, have the power to hold your elected officials accountable. You have to use that power. You have to exert that power.
Wonderful. I also have a question for you, Representative Scott. I talked to Professor Cook earlier last semester, actually, about kind of the implications that come with standing up for your community and how you kind of get hit with backlash when you do so. In particular, Judge Stevens, when he came out and with Kenneth Walker's case, actually put him on home arrest. And to see the backlash from the community of people saying, this man just committed a crime, or, not thinking he was acting in his legal capacity of force, they looked at Judge Stevens as a criminal in a sense. So to be criminalized for standing up for your constituents and going out on the front lines and peacefully protesting, to be hit with a felony, how did that make you feel in that moment? If you could elaborate.
I appreciate that. And I think it's important for people to be real honest and acknowledge that the examples that you're lifting up are what's happening to Black people. So when the president of the Senate here in Kentucky held a press conference a few months ago to say that he was working on a no-knock piece of legislation, we didn't see any public outcry from the Fraternal Order of Police. But when I filed Breonna's law for Kentucky, the Kentucky State Fraternal Order of Police attacked me on every single one of their social media. I've also experienced since, particularly since our arrest on Thursday, September 24th, messages on all of my social media, at my legislative email address, on my voicemail, from people who are saying things like, we should burn down your house like you tried to do the library, or calling me a hateful, bigoted N-word. I mean, I've experienced all of that, as have the Black women who've been holding down the space at Injustice Square Park. They've literally gotten letters from white nationalists, white hate groups, saying that on election day, their heads were going to get blown off. This is the reality that we face. So when we fight hard and we speak strongly about Breonna Taylor, it's because we know how real this is in our lives, and how not only do we have to get justice for Breonna Taylor, but at the same time, we're fighting for our lives and the lives of our families. I think I see another question in the Q&A if you aren't able to see it.
Thank you.
No problem. Let's see. Uh-oh. Oh, there we go. Is it conflict of interest to have Jefferson County Attorney Mike O'Connell and his daughter, Judge Annie O'Connell, preside over the same case, especially when the judge found her brother dead from a heroin overdose 6 years earlier? Maybe the judge should have recused herself. I'm not sure what the death of her brother from an overdose has to do with anything. My mother died from an overdose of alcohol and drugs. She experienced the pull of that demon of addiction for many years. And so I don't see what that has to do with anything. But what I will say is that County Attorney Mike O'Connell is responsible for the felony and misdemeanor charges that protesters have received. Judge Annie O'Connell is responsible for the issues surrounding the grand jury. Those are different. They are not doing the same job. Judge Annie O'Connell has nothing to do with being able to dismiss our misdemeanor charges. She had nothing to do with County Attorney Mike O'Connell dismissing our felony charges. Those are two separate pieces of this movement that they are both responsible for. So I just want to put that out there, because I'm maybe folks weren't aware of that. And I see another.
Okay, we've got another one. I'll read it to you. Mm-hmm. Oh, if someone has a question in the chat, we can also look at that, but I can read the questions off to you.
Okay.
Okay. Why did the family settle for so small amount from the city? It's not about the money, but the amount that seems to minimize her family's trauma.
So her attorneys will have to, Miss Tamika Palmer, Breonna Taylor's mom, her her attorneys will have to speak to that. I know that they are part of this conversation because I was not part of those conversations and I should not have been. What I will say is that there's no amount of money that would ever be enough for the murder of your child. I know as a mother of a son and a daughter, no amount of money that any governmental body could give to me should something happen to them would ever be enough. What I will do is applaud the family because they have taken that money, and unlike what some people have said about them and how they were going to use the money, because there are so many hateful people in this world, what I will say is that they've taken that money, started a foundation in Breonna Taylor's name, are right now going door to door safely to remind folks to register to vote, just dropping lit on the doors, not even knocking and disturbing people so that they don't have to worry about being 6 feet apart and having on masks. That's what they're doing right now. They are also being out at the square, and they've been contributing money for months to make sure that we could feed people for free, especially people who are houseless. So that's what the family is doing with the money that I know of that they've shared publicly. But no amount of money would have ever been enough.
Our next question is, does Kentucky have measures in place to recall state officials that have administered their office with duplicity and deception and have lost the confidence of the populace? Is there a recall process available?
Well, unfortunately, here in Kentucky, we don't really have that ability at our fingertips. Unfortunately, it's by design, though. We have to keep in mind that none of these systems were really designed for the kind of accountability that we need right now. They also weren't designed with people who look like me creating the systems under which we operate. So now we're fighting with our whole selves to try to make them halfway better. What I will say is here in Louisville, there's been a big push to get the current mayor to resign because really for us, barring the Metro Council actually having a vote of no confidence that accompanied with that is removal from office, we would have to depend on him to resign. He's got 2 more years in office. He's up in 2022. And I know that's what folks have got their eyes on right now. They're just saying, let's spend the next year, 2021, supporting folks to run for that seat in 2022. So that's where we are right now.
Awesome. It doesn't seem as though we have any more questions at the moment. Once again, if you all could give Representative Attica Scott just a virtual applause. We really thank and appreciate you, Representative Scott, for coming on and talking with us and discussing these issues. I personally feel as though UK has done a fantastic job with this symposium. Breonna Taylor being from UK and being a UK student, sometimes it kind of feels like the world can get overwhelming, especially when you're in school and things and trying to battle all that. So, to see the world come together and to have these type of discussions, it really puts, the pieces into place of how we can start to solve this as a society and together as a nation. So I thank you so much. And I appreciate you being out there on the front lines because I know it's got to be hard and stressful and challenging, but you are doing some of the greatest work that I've seen in my lifetime. So thank you.
Thank you all so much.
Thank you. And up next, you all will have our panel discuss damages. Our moderator will be Eric McCarley, who is also a student at the University of Kentucky College of Law. Thank you all so much.
Good afternoon, everyone. My name is Eric McCarley. I'm a 3L at the University of Kentucky College of Law. This is going to be the third panel for our day-long symposium devoted to Mrs. Breonna Taylor, entitled Damages. Please welcome me today in welcoming our esteemed panel. First, we have Attorney Sam Aguirre, attorney for Breonna Taylor's family. We have Professor Ramsey Woodcock, Professor of Law at the University of Kentucky's J. David Rosenberg College of Law. I'm sorry. We have Professor Daniel J. Cameron, Professor of Law at the University of Louisville's Brandeis College of Law. And then we have Attorney John Flashiker. In the interest of time, we won't be reading their bios, but their bios are available on the link on the registration site if you'd like to learn more. And this, again, this panel will be covering the topic of damages. And to that end, Professor Woodcock, if you could kick us off by providing us with a broad overview of the law in the area of damages.
Yes, happy to. Thanks very much for having me on this panel, Eric, and Professor Cook as well. It's a pleasure to be here. So the suit that was filed against the police officers was a tort suit sounding in wrongful death. And so we have a number of different rules that we apply to decide what the damage is from a wrongful death. The first is the most obvious way to measure damages would be to think about the pain and suffering of the person who was wrongfully killed. And that is part of the damages measure. We do try to place a value on pain and suffering. And once that's done, the next area of damages that you would want to consider is the loss to those who are left behind. So the first way in which the law tries to deal with that is to look at the lost earnings of the person who is wrongfully killed. So we consider what would have been earned over the remaining years of this person's productive life, and sum all of that up, and add that to the damages pool. The next issue is other less tangible losses to those who would have potentially benefited from the continued relationship with this person. That would include, most obviously, grief. However, it's an odd fact of American law that grief is not generally included in the damages measure. So Ms. Taylor's mother, obviously suffers a great deal of grief as a result of her loss. One would have expected that some measure, some money value would be placed on that grief, but the law generally does not provide that. However, it does provide what in Kentucky is called loss of consortium, more generally loss of society. And that is, the idea here is the positive benefits that loved ones would have gotten from a continued interaction with the victim. That you can receive a reward for. So this would be in the form of the benefits of love and affection that would have been provided by the victim to their loved ones, sort of services, training, help, with things encountered in life and so on. A money value can be placed on that, and that would also be part of the recovery. And then, so that's sort of the standard set of what we would call compensatory damages, damages that are designed to directly compensate for the loss. But in addition to those, where the action that led to the death was undertaken in a way that the law calls maliciously, meaning either the perpetrators intended to cause the harm that resulted, or that they behaved so recklessly, so wildly, so without regard to consequences that it's tantamount to having acted with intent to cause the harm, to cause the death. That's called gross negligence. And that clearly seems to have been a part of what went on here. And that gross negligence will open the door to what are called punitive damages, which are damages that are intended to go beyond just providing compensation for the actual loss of those who are left behind, and to, in fact, punish the perpetrators. And so in Kentucky, there's no limit, I believe, on the level of punitive damages that can be awarded. It's up to the decider to determine what level of punishment, financial punishment, is warranted under these circumstances. So that's a very brief overview of the way damages are calculated, the way the remedy in these kinds of lawsuits is totaled up. I should note that it's very, very common, and appears to be the case here, that in suits against police officers, these monies are not paid out of pocket by the defendants themselves, but covered by the government, by their departments, by the city, by the state. So I will leave it at that, but that's sort of the underlying law that against the background of which this settlement would have been negotiated.
Thank you, Professor. It seems like you touched on quite a bit of topics that we want to cover today. So that actually provided a pretty good segue for our next question. Mr. Aguiar, if you could just elaborate for us, was there a civil claim in this suit, and whether that civil claim was mediated?
Sure. Can you hear me?
Yes, sir. I can hear you.
Great. I'm not the best. Apparently, I was Zoom bombing the last person. I looked at the last panel, so I felt horrible. I was working on a paper, and I looked down, and I saw a message from Professor Cook that said that I was causing a bunch of noise. So now I'm all self-conscious about this Zoom stuff. So yeah, let's touch on this settlement. I would agree to a certain extent with what was just presented in terms of the damages, other than the loss of consortium. So in Kentucky, you do have a loss of consortium claim that is going to be, for a minor child, if you lose a minor child, or or a spouse. So in this particular situation right here, I don't think we had a viable loss of consortium claim. The damages that we were able to pursue here were the pain and suffering, which is very subjective. We ended up getting some focus groups together, trying to figure out what 30 seconds to 3 minutes of a person's life is worth in this context. Then, we had to get an expert. We got to basically see the amount of money that Breonna was going to earn throughout the course of her lifetime. That factors in fringe benefits and some things along those lines. In Kentucky, you don't take out consumption. And then the rest was punitive. If we'd eventually filed a federal lawsuit, Professor Woodcock probably could have got into 1983 claims, and we would have had a claim for attorney's fees and expenses as well. So in this situation, we filed the civil lawsuit. Those damages are all in mind, but a lot of this was really a passion play. And what I mean by that is that in a case like this, you really need to look at the sentiment, at the climate, and ultimately, I think both sides here agreed that we needed to get together and try to resolve this for purposes of healing the city and showing that the value of a Black woman's life was important, especially in the situation. We didn't mediate it in the traditional setting, so I'm not a big fan of, getting a mediator in and writing a number on a piece of paper and sending it to a room, and the other side crossing it out and putting their number down. That tends to be fairly contentious. In this particular situation, we needed the negotiations to be collaborative, especially because we wanted reform, and we're able to negotiate reform as part of the settlement. And ultimately, that's something that we couldn't have even asked for as part of a civil suit. You can't go to a jury and say, here are the 12 things we want from you in addition to money. And here the city, embraced that. We wouldn't have had these negotiations if that didn't happen. These negotiations came as part of what was originally a session that took place with lawyers and the mayor and everybody else, and then a dialogue that took place within branches of those groups, going back and forth on the reform, and Mike O'Connell basically calling each other each time we were relaxed and had a cigar and didn't want to yell at each other about this case, and realized that cooler heads could prevail. And ultimately it was not, it wasn't as much, let's put it this way, to focus on the context of this panel. It was not as much of us going back and forth over what a jury would pay and what the damages are we could claim, as opposed to what would represent a resolution that both sides felt like could be perceived as a nice step in really healing this city and showing that Breonna's life did matter from a civil standpoint, if that all makes sense.
Thank you so much, Mr. Aguiar. That was very insightful. So this next question is going to be for, or a series of questions is going to be for the entire panel. And any of you all can weigh in as you see fit. Just unmute yourself. So first, how do the parties arrive at the settlement figures? What is the process? What are the factors? How are the factors weighed? And how, I suppose this is a more philosophical question, how do we value human life in dollar values? So anybody can jump in as you see fit.
Can I add something? This is John Flyshaker.
Absolutely, sir.
First of all, I think from listening to what Sam said, I'd like to see a breakdown of the economics, but I don't think the pure economic figures played a part in this. I think this was I think he used the term a passion play. And I think that really accounts for an awful lot of what went on here, both the amount and the amount of the settlement and the timing of the settlement. Number one, I think Sam is to be congratulated on the size. I think it is bigger than many people expected. And I'm curious, and I'm not sure Sam can respond to this, but I think an awful lot needs to be asked about the city, from the city and from the county attorney's office, as to what factors played a role in their decision to try to get this settled this quickly and to pay the kind of money that they agreed to pay, which was more than anybody had ever been paid before on similar circumstances. If there really are any similar circumstances, I would suggest that it was a passion play on both sides. I think the city had, and again, I'm a neutral observer. I'm from the outside here, but I think the city had a real interest in getting this settled quickly, which included the fact that it appears, at least, that they wanted to get it settled before the Attorney General went to the grand jury. It also appears to me that at least in the process of settlement, that the city was very interested in maintaining secrecy and a lack of transparency about what had actually happened. What has transpired in terms of the transparency has not been a result of this litigation per se, but it has been a result of a great deal of effort, media work and other efforts outside this lawsuit. So I would not understate, I don't think it can be understated, the interest of the city to get this done quickly. I think they were probably willing to pay a great deal to get it done quickly. And I think that they were also very intent, I think, on maintaining secrecy and a lack of transparency about the facts that transpired the night that Ms. Taylor was killed.
Hi, and this is Dan Cannon. And before Sam takes the mic here, because I really want to hear from him on this. I mean, this is his question. I would echo like sort of all the general questions that John has, and just add to that as somebody that has done these cases in Kentucky and Indiana for 15 years, I've seen several similar situations, and I'll get into it later during my piece. But I mean, I've seen several similar situations where the city has not offered one red cent to settle the case. And I know you see John laughing because he knows that's the way it's been, for a very long time. So enormous congratulations to Sam on this judgment or on this settlement. And I'm wondering if Sam thinks that it represents an overall sea change in the way that the city is going to handle these cases from here on out. Because, I mean, really, they've been quite laissez-faire about, just letting the courts handle it, and ultimately letting lots of cases that should have paid out to victims' families just get summaried out by the terrible federal courts that we have. So I'm interested to see, just based on your negotiations, Sam, are they going to start handling these cases any differently?
So first of all, thanks to you all for the kind words. Dan, no, they're not, unfortunately. I don't see this as a sea change. I think that a few things that were done behind the scenes in this case will make a lot of sense to these folks. I haven't really talked about this before, but one thing that we all need to remember is that George Floyd is going to settle for a shitload of money. And the city would have been in a very difficult position had George Floyd's case settled first, because that would have been the new barometer. And that would have been, we would have been in a spot to say, wow, George Floyd's family is going to get paid this, and a Black woman's family is going to get paid that. So you need to remember that $12 million when this case settled was landmark. It was fantastic. It was wonderful. And let's just throw a number out there, I don't know, but let's say George Floyd settles for $35 million. Then all of a sudden, if we get together and we settle Breonna's case for $12 million, it's a huge slap in the face. So that's one thing that, we did kind of have to remind the city that ultimately Minneapolis is a very different dynamic. George Floyd is a little bit different case from a valuation standpoint. And I hate even talking valuation when you talk about, Dan has to deal with this. We deal with this. We have to talk about what a person's life is worth. And that is awful. You have to put a dollar figure by it. The other thing, Dan, that I'm sure you saw in this case, and I think when some of the climate changed, is when we were able to, and it was alluded to earlier, the work of investigative journalists and some folks that really just gave us free bodies to do discovery on this case. In early July, when some of this case started to focus on the big picture as to what was going on at LMPD, and how it went up the ladder, and how it really was going to stop at Greg Fisher, whether he denied it or not. This was a police squad that was put in place at the direction of the mayor. It was the mayor's baby to go clear out an area for development. More and more information started to come out about that, and I think that was really where it was a punch in the gut, to where they said, wow, this is going to get really ugly. I don't think it was necessarily about trying to hide the facts associated with Breonna's death specifically. The Attorney General did a good enough job hiding all that. That was his job, to go and get that information. I'll never know to what extent the city had some more information there, other than maybe they had some body cameras, but I really think it was the big picture. And what I've seen in some of the other cases I've been able to handle is that if you can go to the top and you can really, poke the bear a little bit and get that fear factor out, that's where they get a little worried. And I think that might be what distinguishes this case from maybe a youth explorer case, because that's horrible. That case hasn't settled in years, and you have kids that were sexually molested, and you have guys going to federal prison. Dan and I could name 10 cases, I'm sure, between the two of us right now that we had, that if it was a normal case, not against Louisville, they would have done the right thing, gotten rid of it. So I'm kind of rambling here, but hopefully that makes sense. In this one, the pressure that was being put on initially was strong, but it was only when the pressure really got all the way to the top did we really see this as a time to where maybe they would be very receptive, not only to a big settlement, but to also talking about legitimate reform.
So, Mr. Aguiar, just a follow up, and also for the panel, broader panel as well. Was there an impact? What was the impact of the uprising and the political activism on that specific figure, if any, or in general to the panel? Do we typically see that these political activism around a killing such as this, that do they typically affect the number that we would settle for?
So I can start there, and I'd love to hear what everybody else has to say. What I'd say really quickly is that you see a lot of momentum settlements that happen across the country. You see things that happen quickly in reaction to try to diffuse a lot of the action that's going on, and you see that a lot of times it works. I mean, look at what kept Louisville going versus these other cities. These other cities had prompt prosecution. They had bold statements from politicians that said this will not be tolerated. You had people removed, whereas you had status quo here. I think one thing that Dan and I have noticed through the years is that Louisville, unfortunately, has played the it'll blow over card way too much. So their litigation stance and their stance on resolving these cases has always been, time is on our side. We can deal with this initial flurry of punches, but in the end, the court system may rule in our favor, or these people may get desperate. Either way, we're going to delay and delay and delay them justice, and ultimately they end up suffocating the process. It's not good. I think that part of the reason why this turned into the case that it did and the result that it did is because of that longstanding mentality of theirs. Let's face it, if they had come to us in May and said, we screwed up, we're doing everything we can, but the only thing we can do is try to resolve this civilly, let's come to the table, this wouldn't have been a $12 million settlement with 12 substantive police reforms. And it's a gamble they take that they win on a lot, but when they lose, they're going to lose big.
Sam, this is John Flyshaker. You and Dan have really been involved in a different way than I've been involved over the years, but I've been involved for a very long time in dealing with trying to get police records and law enforcement records in cases like this, including the Explorer case, which is on, I've got a case that's ongoing even as we speak. I think it's important for everybody to understand. I think your observations are correct. They really do at least for the 45 or 50 years that I've been doing this. It has always been it will blow over mentality, and there has been a really consistent effort by the Louisville police and various city administrations to hide everything. I mean, this is we can get into a talk about the politics of it. You can get into a talk about the FOP. You can but the fact of the matter is that LMPD has been one of the major agencies in this state that tries to hide everything always. And I think it's important in terms of the Breonna case to talk about the fact that they were hiding it until 2 months after it happened. And all of a sudden it started to get publicity and it started to get some action. The protests were very important. I think it is really telling that the mayor refused to release any information. And I can assure you the mayor had every right to release information. He still has the right to release information, but he hasn't done it. And that's the game they've been playing for a very, very long time. I think it's important that protests continue. I think that the momentum that was generated by you, by the people that were protesting, needs to stay in place because, at least from my experience, nothing else works. I smile, I laugh, I ridicule, whatever, but I think, the mayor talks about, how much concerned he is about the rights of police officers when we have the rights of citizens being violated on a regular basis. And he talks about, well, gee, we might have to pay something to a police officer if we violate his rights. And the fact of the matter is, I believe that the position of the mayor and others has really cost the city probably hundreds of millions of dollars in terms of the protests and the loss of economic activity. And I think all of those things have to be talked about in the context of Breonna. I've been amazed. I think it's the fact that Breonna went national, went international, was predictable long before the city people realized what was happening. That's just an observation. And I think that's the city has really mishandled this. And I think you did a terrific job of using that.
I just want to echo that a little bit. So, legal decisions are fundamentally always political. The law, at the end of the day, is applied by human beings, and human beings are political creatures. And so, what we see here, just starting with the damages remedies available, all of the ones that I outlined to you, from calculating future earnings to deciding what pain and suffering is, all of these are not precise measures, right? They all involve discretionary judgments about what the future would have looked like, and certainly putting a dollar value on pain is inherently a subjective process. What that means is whenever you have that kind of ambiguity, you have room for the political to matter. And I think that's what we're hearing, and what Sam is telling us is that, when it came to negotiating this, it wasn't, that we were looking at, what potential future earnings would have been. It was that this was a situation in which you had enough people out on the streets protesting and demanding justice that the city and the powers that be got nervous and were willing to come to the table and talk about a substantial settlement amount. And without that, you never would have seen that happen. But that doesn't mean that in order to have better policies, there have to always be people in the streets. Part of the reason why you need people in the streets here is because there's clearly, right, one person cannot act alone effectively at anything. There's enough people in city government and standing behind city government who support, drawing these things out and not providing substantial compensation or even admitting harm. And they're willing to support each other. And because you have that kind of a network and that sort of contrary vision, you have to have people on the streets here. Whereas in some other cities where, within government, there's enough of a feeling that, this kind of behavior has to stop, you see much quicker action, and perhaps you don't need as much of the power on the streets because that view has already been internalized.
Sort of jumping the gun here on the questions that we have, but of course I agree with everything that's been said. I think that the reason that I got into the line of work that I got into in the first place is because of the stuff that I was doing in college, which in undergrad I was working with Amnesty International, and we were doing, the local chapter of Amnesty International was doing almost no international work because we were focused on police violence in Louisville at that time. And, almost 20 years ago, there was a guy named James Taylor, not the singer, and I don't think related to Breonna Taylor, different Taylor, but he was handcuffed by Louisville police who were out looking for somebody different. They, supposedly saw, walked past his apartment, heard a commotion, and the apartment door just happened to be open. So they walked in and broke up the commotion. I don't know if John and Sam remember this. But they handcuffed Mr. Taylor, who was about 95 pounds soaking wet. handcuffed him behind his back, and then proceeded to shoot him 12 times. And that obviously was very bad. and people were in the streets over that. And, it wasn't a sustained effort that you saw in the streets over, a period of months. But there were people in the streets, and there was a lot of media coverage on that. And there were serious discussions about a citizens review panel that would have some kind of teeth in looking at, Louisville cops' actions and being able to take serious disciplinary action. All that went by the wayside. You got a black guy that is handcuffed behind his back and shot 12 times. All that goes by the wayside. The case goes to a jury, and the jury awards $0. I mean, I think that, there was this sort of sham grand jury proceeding that happened at that time. But I will say that the sham grand jury proceeding that happened for James Taylor's case, they at least presented a murder charge, and that's almost 20 years ago. That the Commonwealth attorney at least presented a murder charge to a grand jury, and the grand jury said, we don't want to indict. Okay, fine. And so then there's a subsequent civil case that the city decides they don't want to pay money on. And that goes all the way through, and I think that was Aubrey Williams's case. That goes all the way through to a jury trial, and the jury says, we don't want to hold them accountable. So there's this cycle of enabling that goes on, right, between, not only judges, especially federal judges, which are terrible, and, the mayor and the FOP and the police, but also there's juries that are in the mix that are to blame too. My first year of law school, there was a case, the case of Michael Newby, where Michael Newby is a 19-year-old kid that, a drug buy with an undercover cop named Mackenzie Mattingly went south. He turned around to run, and Mattingly shot him in the back 3 times. Everybody was in the streets over that one too. And that settled for a very small amount of money after a trip up to the Court of Appeals and back down again, because the city just didn't want to pay it. So, part of the reason that I asked Sam that question as to whether or not this is a sea change is because people have been in the streets before. And, there have been, verdicts before. There have been, some measure of accountability has happened in the past, even though these cases keep happening and happening and happening, and the cases continue to happen, right? The practices haven't really changed. The police are still the police, and the cycle of enabling continues. I think that, one of the more disturbing things about all of this is the fact that, like lawyers like me can sit around and talk to other lawyers and look at, I think 5 years ago, had Breonna Taylor's case happened and you didn't have people in the streets for months and months, it's probably not a case, right? I've talked to another civil rights lawyer that does these kind of cases all the time. When this first happened, we sat around and said, I don't know, if this case came in, would you have taken it? I think, gosh, I don't know. Is this the kind of thing that we find? Like, there's a guy that's got a firearm and he's, supposedly shooting at police as they try to break into his apartment in the middle of the night. And that's just something that we've come to accept as civil rights lawyers as, well, that's not a case. Because if anybody's got, a gun or a knife or a flagpole, somebody attacked a police officer with a flagpole in Louisville a couple of years ago, and that wasn't the case. I don't think anybody even filed a case. If you got somebody that's obviously mentally ill coming at a police officer with a flagpole, police officer just puts him down, kills him immediately on the spot, because what else are you going to do? My God, he had a flagpole. But that's the attitude that we've sort of had as a society in dealing with these police cases. Well, if somebody's got a weapon, or if they're even perceived to have a weapon of any kind, like James Taylor had a box cutter supposedly behind his back while he was handcuffed, then that's not a case. And it's not something that, you're going to be able to get any kind of compensation for, because a jury's not going to buy it, or a judge is going to bounce it out, or the city's not going to pay a settlement, of any substantial sort on that kind of claim. And that's sort of where we've been living as civil rights lawyers for a long time now. I don't see that changing unless people stay in the streets. And even then, I think if a city had decided to say, to hell with this, we'll take our chances and take Breonna Taylor's case to a jury. I don't know what your sense of the thing is, Sam, but, I still think it's a toss up. I still think that there's a substantial likelihood that you take that case to a federal jury where you're pulling, a bunch of lily white jurors from like Grayson County and Oldham County and all these surrounding counties or wherever they come from in the Western District of Kentucky. And they're not going to care. And they're going to cut the police every benefit of the doubt, like they have done for as long as I've been in practice and longer.
Eric, can I jump in? You okay? We doing okay on time?
Sure. Yeah, go ahead, sir.
Cool. So yeah, Dan brings up some good points. So the one thing well, a few things. Number one, I think John and I have something in common. Hopefully, if I've got his practice kind of read correctly, we're information junkies, and we're going to fight like hell to get information. And I think that, two things might be out there right now that make this time and place kind of that era of change and are going to make cases easier to settle. One is body camera. Obviously, we didn't have that here. This has really exposed. It's shown us how much better, it's been for us to hold officers accountable when there is body camera. The era that Dan's talking about, there was never body camera. So it was always the officer saying, I feared for my life, and giving some bullshit story about what happened. And then 10 of his people behind him backing it up versus the one, person who's either dead or has a criminal history and isn't going to be believed. Now you can see most of what happens on camera. So I think that a lot of the reform for everybody that's watching and listening today, we need to be pressing so hard for body camera and accountability for not wearing it. The other thing now is just this, you got to have in these cases to fight like crazy to get the information. What we saw in Breonna Taylor's case is the image of what happens if you don't fight. It was, we made entry into a home with a lawful search warrant. Officers fired at us. We shot back and a person died. And of course, everybody that sees that on TV says, oh my gosh, this poor officer's in the hospital. Thank God he's not killed. And, why did these people shoot at them? And that's all until you start digging. And everybody's seen in Breonna's case in particular, how deep it really gets. And you have to fight. You have to fight like John does for open records. And you need to call these departments out when they're not transparent. And you need to use the benefits available to you through the litigation system to do that as well. We had a question as to why we filed in state court over federal court. And the answer is very simple. If I file in federal court, I've got to, face an immediate motion to dismiss, and then I've got to go through this scheduling period. And only when the court actually enters that and I survive a motion to dismiss do I get any right to discovery. If I file suit in state court today, I can send out a subpoena tomorrow. And that was what we needed in this case. We needed some answers. And once we started winning some hearings in front of the court and they started making them turn things over, it really, really helped. Now, Dan, the one thing I would say about taking this case to a jury where I may differ from you a little bit, I think we would have got a hell of a verdict. And I think the one thing you may be forgetting is how you can take this case and really paint it in a picture that's going to be sympathetic to your jurors that typically would not be on your side. This Castle Doctrine case, as soon as the facts of this case started getting out, we started having people reach out to us, Trump supporters, right-wingers, people from the sticks in Kentucky saying, by God, if somebody beat down my door, I'm going to shoot at them. They didn't do anything wrong here. And thank you for fighting for justice on this case. And it was very different than what I'm used to in these situations. It may be the one civil rights case I've ever worked on. We had both ends of the spectrum, at least from that standpoint, coming together, which is why I think you ultimately had this effort within the police force and across some factions of America that tried to just fight like hell to paint this image of Breonna Taylor that put her as part of you would have thought that she was dealing drugs with Pablo Escobar, the way that things were coming out about it. But anyways, I think we're at a good point to where if you can keep putting together, the fight's going to be easier for us going forward than it was in the past for the families of James Taylor and things like that.
Can I add a couple points, Sam? Number one, not just body cameras, but I think even more importantly, everybody's got a phone. Everybody's taking pictures. That really has made a sea change. And at least in all the talks I give, I think that has made all of us a reporter. That makes everybody capable of being a reporter. And that is a major sea change. You didn't have that in Breonna's case because of when it happened and how it happened, but it is a major change. I think the second thing that I'm fully aware of, and not many people are, is I will guarantee you there's going to be an effort in the General Assembly in January to tighten up what is going to be released. We fight that fight every year, and we fight it. I say we, the Press Association, the media fights it. It's extraordinarily important, and we get very little play. We get very little effort from anybody else because it takes place up in Frankfurt, and it takes place in the state of Kentucky with all the rural interests that are out there. But I will guarantee you that the Breonna Taylor situation is going to generate more efforts to close records than it will to open records in the state legislature. And we have that is a continuing fight that has to be fought at every instance. And the not just the Louisville FOP, but the FOP statewide and nationally is extraordinarily powerful, really powerful. That is a game that's never over. You're going to have to keep playing that game time and again. So every time something like this happens where we discover that there are a lot of records out there that are really telling, that are really important, the first effort that you see is to close those records to the public, not to open them up. And that's just the way it's been for as long as I've been doing this. And that means it's a continuing fight. You never win that fight. You just try not to lose it.
Wait, I wonder, there's been a bunch of questions in the Q&A about whether the large settlement amount is going to lead to lasting change. I don't know if Eric, we might.
Yeah. So there's a bit at the end where we can get to that if you can hold it off.
Sure.
All right, thank you. So I just wanted to push forward a bit, and this question kind of goes hand in hand with the last one as well. And Sam, feel free to take the lead on this one as well, but I do want to hear from the panel about this also. Was there significant liability and exposure in this case? And explain, please.
Yes and no. So ultimately, I think by the time everything came out in this case, and by the time if we had to name more parties and really go into things, I think that we were going to have a lot of exposure. One of the things that Professor Woodcock had kind of alluded to early on, though, is how much of that is actually collectible. So in a situation like this, a lot of it depends on, I think that, let's put it this way, if we gotten some mega verdict of, I don't know, $100 million or something, just because we were trying to prove a point and put a big number up there, we don't collect that. The court's going to overturn that. Was there an opportunity for us to go get more than $12 million and be able to collect it? Yes. Was that likely? Probably too soon to tell. From an exposure standpoint, I think it's just as important to look at not only what a jury pay, but what would the case value be worth for settlement if George Floyd, Ahmaud Arbery, some of these start settling for $30 million, what if that became the new norm? Then all of a sudden, that we may have created the new norm with this case, and it may be, the new norm may go up substantially after that. But also, what was going to happen to the city of Louisville if Attorney General came down and did what the hell he did, and now when you look back in retrospect, it seems to me like maybe the city and the mayor had some advance notice of this. What the hell was going to happen if you had no civil justice and you had no criminal justice? And what would the streets of Louisville look like now? And we're still fighting, and we got a long way to go. But the exposure to them, I think, was more than just this case. Look at how I'd love to see the figures on what we paid for officers working overtime details, for the city having to pay property damage claims, for all the other lawsuits that are going to come out and start incurring at least cost of defense as it relates to pepper balls and tear gas and everything else. The financial consequences of what this case caused to the city were huge, and we're only going to keep getting worse. So the long answer to an easy question is that the total exposure was huge. In terms of the case itself, it was high, but at the same time, the settlement was fair. I mean, again, having to sit here and say what's a case worth or what's a human life worth, I think that everybody here that's got experience with this will agree that this case, when you look at it that way, paid well above and beyond what we normally see on these cases. And there's been some questions as to does this need to happen? And yeah, when you got a mayor and an administration and a budget they're all tight, when you hit them like this, it makes them think twice, and they need to change the way they do things. So that's what I got. Jump in, help me out here, guys.
I take a less optimistic view of most of this stuff than my colleagues do, I'm afraid. Particularly on the point of, what changes, like what creates long-term changes. Do big dollar settlements do it? Maybe. We've seen big dollar settlements around the country, for a while now. Occasionally something like this will happen. And yet our culture of policing nationwide continues on and really has not been substantially reformed in any community that I know of. I think they're taking positive steps in Minneapolis now to do like sort of large scale reform, the kind of thing that we need. But, every year or so, there will be a gigantic scandal about, somebody gets handcuffed behind their back and shot 12 times, or like Ayanna Stanley Jones is a 7-year-old girl that got shot in the head with a machine gun in Detroit in a botched raid. Not really too much in the way of reform that's happened as a result of that. I would have thought 10 years ago that was the spark that lit the fire. You see some minor reforms going on at the prosecutor's office in St. Louis, but even since the Mike Brown incident, you've got a culture of policing. The police culture is essentially the same as it was. And to say that, I don't want to, John knows everything, so I can't really realistically disagree with him in any way. But to say that body cams and cell phones have changed the landscape, we've been doing that now for a long time. And, you still see, Professor Woodcock can correct me if I'm wrong here, but I don't think there's been any study that has suggested that police violence has diminished as a result of body cam usage, or as a result, I don't know how you even quantify that kind of thing, but, or as a result of, the videos that people take with their cell phones. You can film something like a police officer in South Carolina shooting Walter Scott in the back and killing him as he's running away, and then planting a drop gun underneath the body. And still, that doesn't change the way that we do things overall with regard to policing in the United States. And so that makes me sort of despair of any major sea changes happening at sort of a top-down way, right? So I don't think this changes because we get a new mayor. I don't think this changes because we get a new prosecutor. I don't think this changes because, the city council enacts an ordinance that says that no-knock warrants have to be changed, or the way that they do no-knock warrants, or any aspect of police procedure has to change. And so when you hear activists talking about defunding the police and abolishing the police, for somebody that's like a middle-aged white liberal, we all, like that's upper middle class, we kind of go, wow, that sounds really radical. That sounds really like, holy cow, abolish the police. I don't know about all that. But yeah, actually, that's the direction that this needs to go, because I don't think, after having watched this for 20 years, I have not seen any major changes as a result of anything, no matter how scandalous we've seen happen over and over and over again. And we've seen the worst of the worst on video, and yet it persists.
Just to jump in on that, I tend to agree that, particularly when we're dealing with sort of law-related issues, there's a tendency to feel that there's only a mechanical solution, that, if you tax them more, you charge them more for misconduct, their behavior is going to change accordingly. But unfortunately, governments are not sort of rational profit maximizers. And, for them, often this is just a cost of doing business. And, you've got, big cities will pay out, $50, $100 million a year in settlements or damages based on officer misconduct year after year after year. For, in the 90s, there was a study that came out that showed that, New York City wasn't even keeping track of these things, right? They would just, these suits would be filed, they pay this, they didn't even know how much they were paying. And so at the end of the day, despite the sort of mechanical feel that the law gives to these issues, at the end of the day, what matters is what's in people's heads. And that's why I think that, the protest movement has been changing a lot of minds, and it has been getting into people's heads. But this is, it's not something that happens overnight, right? Cultures change epochally. They change, it's a matter of generations. So, I think that each, the experience of the last 6 months matter, and they have moved the culture, but there's a long way to go. Eventually, we will get to a place where, there's a conception of what it means to run a police department and what it means just person to person, how we treat each other, which will be radically different from what we have now. But I don't think that the solution is a mechanical one in which, you drive up the dollar amount that you make governments pay, and that's going to sort of mechanically produce a rational response based on the fact that our budget is limited. And so therefore we can fix the budget by changing their behavior. That can help, but it helps only because it sends a signal about what's right and wrong and gets into our heads, not through the budget, in my view.
Professor, can I ask a question? Because this is something I've been struggling with because of the situation here in Louisville. What is the obligation, both as a citizen and as a lawyer, to those lawyers who are intimately involved from a government side? What is the Commonwealth Attorney's obligation to do right, as opposed to just follow the law, whatever that means? What is the county attorney's obligation? Does the county attorney have an obligation that extends beyond simply defending the police in every instance? And this goes back to the kind of thing we were talking about at the very beginning of this session. Do lawyers have an obligation, especially elected lawyers, elected officials, have an obligation that extends beyond simply defending their client in a situation where the public interest is really intimately involved?
I think this is an excellent question, and I would almost pose it slightly differently. So typically, you're an attorney, you represent a client, you have a duty to carry out the client's interest, right? And you as a lawyer, except in very limited situations, you as a lawyer, if the client wants it, they want to be defended, and you have to defend them. At most, you can say, I don't agree with this, I'm not going to be your lawyer anymore. But that's it. But when you're talking about lawyers who are representing government entities, I mean, these entities are effectively fictions, right? There's no single human client out there that you're representing. You're representing a kind of a fiction, and you as the lawyer now have a responsibility to decide, because that thing you're representing, the government, can't speak to you, right? Can't tell you what it wants. So you have this sort of additional duty to decide, what does it want? And that, I think, right, what would, if this were a human client, would they want me to defend here or not? Because sometimes you represent a client and they say, you know what, I was wrong. Settle this for me. And here it becomes very complicated, right? Because you're both the instrument of your client, and you also have to decide what your client would want. And there, I think there's plenty of room within professional responsibility for an attorney representing the government to say, you know what, this is a case that my client, if it were a real person and not a fictional entity, would want me to settle.
Thank you, Professor. I just want to skip forward a bit and ask a question that's sort of on topic, because I want to make sure we do get this one answered. And this is for everyone. So should police unions pay these settlement figures? And if so, if they did pay them, would that lead to institutional change?
I can start with that. So, Professor Woodcock just brought up a great point, and it's the inherent conflict of interest that arises within these, within civil litigation against the government and against these officers. So just so everybody watching understands, you can't just sue the agency most of the time. You actually got to sue the officers. And the officers then are going to get a lawyer paid for them by the city. And ultimately, it results in that fine line that they got to walk between what's best for this officer. Well, what's best for the officer is always settling the damn case, so that way he can get it off his plate, versus what the city's telling me to do. And it's something to look at. And the same thing goes for the source of these settlements, which is what you just got into. So a lot of people always say that it's the police unions that should pay for these settlements. I 100% disagree. I think it should be the police department's operating budget that pays for these settlements. So for example, the city of Louisville this year, I want to say out of their $650 million budget, like damn near 300 million of it is allocated towards the police. Well, let's make that 288 million now after you pay Breonna's case. And let's make it 285 million, and I think that once you take it out of their operating budget, I mean, the unions, that's just never going to fly. Like, how are they going to, that's not going to work. I don't see how that's feasible. It's one of those things we could all think about and say, well, that sounds great. Police unions aren't going to agree to it. The law doesn't provide for it. The law says the city has to indemnify, not the unions. And if it's the city's budget that's got to pay it, but you take it directly out of the police money, then I think that goes a long way. If they can't get their raises next year, if they can't get that fancy tank that they want, or if they can't go out and get this, maybe they'll think twice about what they got to do. So to me, yes, I do think it needs to come out. And I think you need to split the baby. So what I had proposed to the city actually as part of reform, but it was just something that they weren't willing to negotiate, was that they go 50-50, city's general operating budget for whenever it hits the city, because it takes a little bit to actually hit city money, 50-50 between that and the actual police operating budget. And I really do think cities should start doing that. I mean, yeah, police are going to bitch and moan every time that happens. Of course, they're going to say, no, no officers are going to come work for us. But if everybody does it and it becomes the new norm, then it is what it is. And just like we're going to think twice about some things we do today if there's financial consequences to it. I mean, other than the fact that there's a morals and decency component as well, these officers you'd like to think would too. And even if it's not the low-level ones, their sergeants and the lieutenants and the people above them, if they know that their ability to pay for what they want, whether it's their toys or their bonuses or their needs, is going to be affected by their officers' conduct out on the streets and the exposure it creates, I think that's a mechanism for change. I tend to be with Dan. There's no one, we write it out and come up with a perfect solution today. I'm not as much of a cynic as him. I'd like to think that there's got to be a way to change this, but that it's going to take a lot of discussions and a lot of actions and a lot of, decisions that police aren't going to like, and you're just going to have to make them do it. But again, another long answer. I think you take it out of the city's operating budget from the city.
I agree with Sam. I mean, I think that there's a way to change it. I don't want to, sound that dark about the whole thing, but I think the way to change it is very difficult. And I don't think that you're going to work within the police culture that exists right now, because it's a culture of impunity that we've enabled for decades in this country. And again, it's a cycle of enabling between the federal courts and between municipal organizations and the police and the FOP and, John Q. Public like you and me, right? So, I think that if you start taking a bunch of money out of, the police's, the city's budget for policing, that's great. But what we've seen too is that they're just going to go and add more money to that budget. They'll take money out of the libraries in the city. Oh, this is exactly what's happened in Louisville, is that they take money away from everything else. And say, yeah, but we need to still have this gigantically bloated police budget. I mean, I think that at some point, you get to a point where the council will be fed up with that, and they'll be fed up with, sort of trying to figure out how to allocate all that stuff and pissing off constituents, and then figure out, and do the kind of thing that Minneapolis has done, where they have a referendum on, let's get rid of the police department and do something else, right? And sort of starting over from the ground up. It's going to take a lot of pressure before something like that happens. And I think that, cities, if people are not in the streets every day for months at a time, cities always have especially within the 6th Circuit and the 7th Circuit where I practice, I mean, cities will always have the option of just saying, to hell with it, let's try all of these cases. We're not going to settle them all. Let's try them. And we figure that these all-white juries that we pull from the rural counties in federal court are going to side with the police officers about 75% of the time. It doesn't really matter what they see on a video, and it doesn't really matter how horrible the officer's conduct has been. And that's what we see coming out of the federal courts. So if the federal courts are willing to balance out perfectly good cases, which they've done millions of times. And if juries are willing to write police officers a blank check, which they've done millions of times, we've got a big problem. We've got a big accountability problem. And so that's the logjam that I see that is very, very difficult to resolve without some real courage on either the part of municipal legislators or state legislators, neither of which I expect to see in Kentucky.
Well, Professor Cannon, I'll go ahead. I'm sorry. Go ahead, Professor Woodcock. Go ahead.
Well, just to add briefly, I think budget cuts can have some effect, certainly, but we shouldn't underestimate the ability of organizations to behave in a financially irrational manner, which is to say that, you just think about business firms, Kodak making film. I mean, did it not see that the digital camera was going to destroy its business? Why didn't it do something about that before it actually destroyed its business, right? And that we're talking about a streamlined business firm whose only purpose is profit maximization. How much less likely is a city government or a police force to react completely rationally to the incentive to reduce this behavior in order to keep their budgets up? It really makes me wonder. So I think it's also a matter of changing culture and thinking. I'd also say that my sense is individualized sanctions, not necessarily financial, because there's a limit on what you can take from an individual financially, but just things like being fired and not getting your pension. I think that these actually do affect thinking to a great extent, and maybe more so than the experience of your department's overall budget being reduced in size. So I think it's a combination of pressure points that need to be targeted.
Thank you, Professor Woodcock. I want to ask this question to Professor Cannon first, but everybody else can weigh in after. Is it difficult to bring a civil suit against in a police shooting claim, and why? If so, why?
Yeah, I mean, I think that I've already basically addressed that, you know, in the sense that we end up as civil rights practitioners telling people no a whole lot, even on cases that ought to be perfectly good cases, you know. And I think that's just part of the difficulty of, if you're thinking about going into a career practicing civil rights cases, you know, you have to be prepared to tell a lot of grieving family members, you know, no, this really isn't a case. It's not difficult necessarily to bring these cases mechanically, you know, in the sense of, you know, procedural requirements that you have for the cases. Section 1983 is the law that we litigate under for in the federal system. And I mean, it's something of a minefield, but not too bad. You can figure it out. It's not like, you know, doing securities or something like that. And it's, you know, usually the simple matter of filing the complaint, and then you do discovery just like normal in any other personal injury case. But the problems for individual practitioners who want to do this kind of practice really boil down to practical financial decisions. If you bill yourself as a civil rights lawyer, you're going to get calls every single day about a cop that has most likely done something wrong, right? Some of the calls will be bogus, but that's the nature of the beast. But you'll get calls about stuff that you're like, wow, that's really terrible. And then maybe sometimes you'll see videos of police officers or corrections officers doing things that are legitimately terrible. And you think, well, maybe this might be a pretty good case. But lots and lots of cases, because again, you've got this cycle of enabling that goes on with municipalities and particularly the federal courts. You've got this issue that even the cases that you think would be really good are not that good, and are oftentimes only as good as the city that is defending them, whether or not they want to pay the case or not, because they know if they put it up in front of a judge in the Sixth Circuit, that they're likely to get summary judgment, or they're likely to at least hobble your case so substantially that you're not going to be able to get a good result for your client at trial, even assuming you draw a jury that's sympathetic to your client at trial in the first case, which, as I've said, is a difficult thing to do in the Eastern District or the Western District of Kentucky, particularly the East. And, you know, I mean, the panelists here can tell you horror story after horror story with these things. I mean, I had a case involving the Kentucky State Police years ago, in which a Kentucky State Trooper drove out to serve a warrant on a guy at his home, said to the dispatcher on the phone on the way there that he was going to kill the guy when he got there. And lo and behold, he went around to the back door of the guy's house and shot him through the back door and killed him in his sleep. And that case in the Eastern District of Kentucky was a summary judgment case. We got it back on appeal, but it takes 2-3 years to get those cases resolved, and then they don't resolve what they ought to resolve for. So you're looking at a case like that where it's like, okay, here's a case where you've got a cop that says he's going to murder somebody, actually goes and murders somebody. All of this is a matter of public record. The forensic examiner for the state says it couldn't have happened the way that the cop said it happened. Our own expert says it couldn't have happened the way the cop said it happened. And still a judge looks at it and says, nope, not a case, right? You know, municipalities know that, and municipal lawyers know that, and they are acting accordingly, right? So if they want to, you know, sort of take a gamble on, if you end up in front of a terrible judge and they want to take a gamble on, you know, the likelihood that they're going to get summary judgment, that oftentimes will pay off for them. And so, you know, you're trying to make a decision as to whether or not you're going to take a case like that looks like a great case, but you got to take all those political considerations and the fact that you're going to have to shell out, you know, what, $15,000 for an expert, like right off the bat, or however much it is for your expert right off. to be able to actually litigate the case, not to mention the 100 hours that you'll have to put into it by the time you get up to the Court of Appeals and back down. Forget about trying the thing, right? Those decisions are tough to make. And so you're really limited in the number of cases that you can take. And so the point is, all these other abuses keep happening and there's no means of accountability whatsoever, right? So you file an internal affairs complaint, and where does that go? It goes into a circular file someplace. And so who is out there that wants to litigate 100 hours worth of, just your run-of-the-mill Fourth Amendment violations, or even something that's as bad as a police officer kicking somebody's teeth in or breaking their arm, right? We don't take these cases unless there is a death or somebody is rendered a quadriplegic, and that doesn't create a meaningful system of accountability. I mean, maybe if you had a nonprofit organization with an advocacy arm that was cranking hundreds of these cases through small claims court, that you would start to see some pressure that would create some accountability. I don't know. It's something that we've sort of spitballed about before, but right now there's just no meaningful system for accountability in place.
I think that's right. But we should still recognize how important it is that we have the ability to bring these cases and get money compensation whenever it is possible, which is something that is not true in a lot of other countries. The fact that we could get a $12 million settlement in Ms. Taylor's case is extraordinary and very unique to the U.S. Approach, and it does justice. It doesn't necessarily do reform, I think, is what the message is. That being able to get the money does some justice. Whether there's a direct link between that and actual change of behavior is one that I'm personally more skeptical about. And this is why I think what Sam did with insisting on commitments for concrete reforms is very important and may actually be something that we should pay more attention to going forward.
Thank you, Professor Woodcock. We're almost out of time, but I have one more question if you guys want to jump in and briefly discuss. Well, earlier we talked about whether or not the police unions should pay for the settlement figures. Who currently pays for the settlement figures, and is that problematic?
I guess I can take that. So right now it's a kind of a tiered system. So the simple question I would assume most people ask is, do taxpayers pay them? Well, the answer is yes, of course they do. So the city will try to basically say, well, we have this self-funded, insurance layer of $500,000 for each department. Well, that insurance layer was put together from tax dollars. After that, if you have a settlement that's over $500,000, it has to go to a government insurance trust that is basically a committee that meets 4 times a year as custodians of the money. They determine whether or not they're going to shell it out for a certain case. That's administered by a very good lawyer, actually. So once you get to, that's the next $2 million. If you get to $2.5 million, yeah, the city would have paid all that. So in Breonna's case, that came from insurance trust, but it was taxpayer dollars that funded it. The next $5 million after that comes from an excess insurance policy. That's like us going out and buying car insurance. City tax dollars paid for that excess insurance policy. And I think that Louisville right now is very tough to insure. So I think what we'll see is that a company like that has to go and pay a bunch of money, in Breonna's case and maybe on others, that we'll probably won't be able to get coverage through them going forward. Once you hit $7.5 million, everything above that is the general fund. So the first 7.5 in Breonna's case came from city money, but it wasn't money that actually was, came out of the budget. Everything after that, they had to take, $4.5 million and find it, and go pay it. So yeah, that's where it comes from. And it's why I don't want to become, I don't want to make my life's calling bankrupting the city of Louisville. I'd much rather wake up tomorrow and find out that the world's utopian and that I can go back to other types of cases with big bad corporations, because ultimately, if you have a good result in this case, it does hurt the city.
Thank you, Mr. Aguilar. Is there anybody else want to comment on whether or not that scheme is problematic?
Well, sure. I'll jump in on this. So just wanted to be completely clear, Sam. So the officers in this case aren't paying a penny of the settlement. Is that right?
No, they're not. Just like if you or I did our job today, if we had an employer and we really screwed up and did something really bad, that's, our employer's going to pay that. And in this case, I saw somebody make a comment on here that, if they do something wrong, it should be the employer that pays it, not the city. Unfortunately here, it's the same thing, one and the same. They're employees of Louisville Metro government.
Is it something that I don't mean to be cross-examining you, but I'm just curious. Could you have insisted in the settlement negotiations that the individual officers be personally responsible for some part of the settlement? And is that something that you ever considered, or what is your thought about all that?
I guess theoretically I could have, but at the same time, what happens if all of a sudden I say, well, the officers need to go ahead and pay some of this themselves? First of all, the city's not going to agree to that. Second of all, the officers aren't going to agree to that. Third of all, just to play devil's advocate, what happens when the city just gives them the money, and we think it's coming from them, but it actually came from the city. So and one of those things, from a certain standpoint, it sounds all good and well and good, but at the end of the day, the only time the only time I think I can think of where I've had to go after individuals for personal assets in situations are where they did not have indemnification or coverage, and where they did something egregious. So we have the egregious part here, but they had coverage. I think if you look at the Claims Against Local Government Act, they were actually the law actually requires the municipality to indemnify the officers here. So now that I think about it, even if I'd asked the officers to pay out of pocket themselves here, they had legal protection from that under CalGO. Dan, isn't that right?
Yeah, and I think most jurisdictions nationwide, that's what I just typed into the chat window, they're going to have statutes that say that, officers are indemnified for situations like this, where they're not totally off the rails and doing some, criminal thing, which, prosecutors have already determined, I suppose, that this is not a criminal action by police officers.
Dan, isn't the standard good faith that they're indemnified so long as they acted in good faith?
Well, I don't, under CalGO, I'm not sure. Under most insurance policies, it would be, so if you get out into the smaller cities, you've got private insurers that deal with it. The city of Louisville is self-insured, or Louisville Metro is self-insured.
Usually course and scope. So I think those are the magic words, of course and scope. And here, I don't think that there's any legitimate argument that we could make, at least based upon what we've got now, that they were acting outside the course and scope of their employment. And frankly, if that was the case, they wouldn't have paid the settlement to begin with.
Perfectly within. That's the problem, and they know it, right? If you look at this big long screed from Mattingly that he sent out to the whole entire department, was Mattingly, right? That sent out the big long email to the department about how we're on the side of truth, justice, and American way, and that's why we kill people in the middle of the night. That's what they believe. Like, that's the fundamental problem, and it's what they're trained. If they kick down somebody's door in the middle of the night looking for a bag of drugs, and that person draws on them, even if they're justified in thinking they're defending their own homes, you put that person down, you kill them. The federal courts have said that's fine, and police departments have said it's fine, and the FOP says it's fine, and they said that for decades. And they really believe they're doing the right thing here. So, in a sense, Mattingly is correct in that he was acting according to his training and according to, everything that those officers that night were basically doing what police officers do and what we let them get away with for a very long time in this country.
Thank you, Professor Cannon. Oh, go ahead, Professor Wilcock, if you have one brief more thing to go.
Okay, no, I was just, but I think this was a really strong case for gross negligence, wasn't it? I mean, particularly, the shooting blindly, through a window. Dan, are you saying that you think that in court that wouldn't have turned out that way? Or
Well, Sam, I mean, the negligence standard doesn't really enter into things in a 1983 case. It's whether or not it was an unreasonable search or seizure. And we're not talking about what's his name's actions and shooting through the wall, because I think that Sam, correct me if I'm wrong here, I think we've determined that that's not the person who killed Breonna Taylor. I don't know, maybe we don't even know that. But you're looking at the liability for it, because there's no liability on the police department itself, right? There's liability for this individual officer for a Fourth Amendment violation, whether or not that was an unreasonable seizure for him to shoot Breonna Taylor and kill her under those circumstances. And if he believed he was being fired upon, I think most courts, at least up to this point, and I hope that this is changing, most courts would write him a blank check on that. Well, he thought he had a gun, so he, especially in this, seems as though he actually did have a gun. Kenneth Walker actually did have a gun and was firing at police officers, right?
Dan?
Yeah.
Isn't the reality that most lawyers, most plaintiffs want the city, want the municipality to assume responsibility because they can get paid?
Exactly.
You don't want the municipality to say, go get it from Officer Jones, because then you're left with an empty bag.
You want to get whatever measure of relief you can get for your clients under these circumstances, and bankrupting an individual police officer ain't going to do it.
Right. So, I mean, it's really an abstract discussion that has no real meaning when you get into the real world.
Yeah.
But from the perspective of reform and influencing behavior, a police officer who knows that they can be held substantially, individually, financially responsible for their conduct, that may affect their behavior.
We don't know. We've never tried that.
It's just not going to happen. These police officers make $60,000 a year. So the reality is that there's just not going to be a situation where I think we ever see that come into fruition, which is why I think the next best thing is looking at the police operating budget, being able to fire the officers. You need to have something that's going to scare the shit out of them. I just don't think it's going to be their individual wallet. So it has to either be their job or something else that's going to, or jail, actually show them that, but I just don't think it's going to be their income. Eric, you poor guy, you said we had 8 minutes ago. How you holding up over there? We all done or what? I don't want you to get in trouble.
Yeah, we need to go ahead and wrap this up. But if you guys have any last words, then we can go ahead and get those out.
No, I just appreciate y'all letting me be a part of this, and really good panel, some really good people on here. So thank you. And Eric, you did a great job.
Thank you, sir. Thank you, Mr. John Fleischer. Thank you, Professor Woodcock. Thank you, Professor Cannon. And again, thank you, Mr. Aguiar. You've served on 2 panels today, so double thank you for that. Thank you to but Professor Cook. Amazing job putting this together, and thank you for your leadership. We are going to go on to the next panel for the feds, which will be hosted by my classmate, Miranda Roberts. So thank you, gentlemen, again, and hopefully you guys can tune in for the next panel.
So it's a little bit of hello. I can see you, Cynthia. Are we all good here?
Hello, my friend.
Hello. Hi, Benjamin. How are you?
I am good, Roy, and even though I've written Benjamin on here, please just call me Ben.
Okay, okay. It was very formal, but I know some Benjamin who don't want anything short. So, Miranda, how are you?
I'm doing very well. How are you?
Great, 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 great.
Good.
All right. How's it been going so far? Anyone been watching other parts of this?
It's been wonderful. It's gone very, very smoothly. I've been very, very impressed with all the panels so far. So
Great.
sure you all will be different.
Well, we will bring it down. If you have me and Cynthia on a panel, I'm sure we will make a mess of everything you love so far.
Well, I tuned in all day and I think it's spectacular. So I've kind of listened and looked all throughout the day, and amazing job. You pulled this off really fast and very well.
Well, with that being said, I believe we are ready to get started. So I'd like to go ahead and say good afternoon, ladies and gentlemen. And on behalf of the UK Rosenberg College of Law, I want to welcome everyone to this day-long symposium dedicated to Miss Breonna Taylor. I want to thank Professor Cook before we even get started for putting this together. I mean, she's done it so quickly and so incredibly, and every panel thus far has been absolutely incredible. We've had the honor of and privilege of hosting some of the best legal scholars in the nation. I know we've had Ms. Taylor's family attorneys, Representative Attica Scott, legal experts and practitioners, activists, and even my classmate was on a panel. So we are a public institution here at the University of Kentucky, and we are dedicated to serving the public. And I think this whole event exemplifies that. So my name is Miranda Roberts. and I will be serving as your moderator for this fourth panel of the day. It's entitled The Feds, and we will be addressing the anticipated problems with the federal proceeding that may potentially occur. And I'm a 3L here at the University of Kentucky College of Law, and I'm just honored to be here, and I'm so excited to speak with you all. So please join me in welcoming our esteemed panel today. We have Roy Austin, who is a partner at Harris, Wiltshire, and Grannis. Ben Glassman, who is a partner at Squire, Patton, Boggs, and a former U.S. Attorney for the Southern District of Ohio. Cynthia Deedle is the Director of Civil Rights Reform at the Matthew Shepard Foundation and a former Special Agent of the FBI. Patrick Malloy is a former Assistant U.S. Attorney for the Eastern District of Kentucky. And we will also be having Harold McDonough joining us at some point as well. So we will have more information about our panelists available. I know their bios are available on the registration site. You can also access them at the website would be law.uky.edu/BT-bio. And there's also a PowerPoint with each of their information running between the panels. So without further ado, we're going to go ahead and get started here. So Attorney McDonough was going to lead us off, but as he is absent currently, I will ask the panelists here with us if they don't mind to address this first question, which is kind of a base issue, so that our audience members can get a fundamental understanding of how a federal proceeding like this works. So could one of you, all of you, whatever you feel like doing, could you please provide us an overview of what color of law prosecutions mean, and how exactly does the federal government get involved in these police shooting cases?
I could start off and take that. And thank you so much, Miranda, for inviting me to participate on this panel with these esteemed other panelists. I have known Cynthia Deedle for probably going on 20 years now, when she was not just an agent, but she was the head of the civil rights unit for the FBI. And so we've known each other for a very, very long time. So thank you for bringing us together for this. Quite simply, the main statute that the federal government would be looking at is 18 United States Code 242. And there are three main pieces to 242. It's that it is under color of law, which means that it is the actions of a law enforcement officer. Two, it is the violation of a constitutional right. Here we're talking about most likely what would be the Fourth Amendment right for regarding unreasonable searches and seizures. And third is that the act is done willfully. And the willfully part of this is the part that has been a hang up for criminal prosecutions by the federal government for some time, because willfully is the highest standard of mens rea in the criminal codes. And what it means here is that at the moment that the incident in question happened, the law enforcement officer knew that what he or she was doing was wrong, and they did it anyway. And so that standard has been a tough one. And if one looks at the recent Justice and Policing Act that passed the House, they've removed that willful language and they've changed it to make it reckless and/or knowing. And so that is a lower standard that there's some desire to get to so that the federal government can get more involved in many of these cases. So I'll leave it there and let others weigh in, but that's the main piece of the law that we're talking about when it comes to the federal government.
Does anyone else want to add anything before we hop into some more questions?
Well, I look forward to it.
Oh, Ben, I don't know. Can anyone else hear Ben? Okay, Ben, we can't hear you right now. Okay, you're good. You're good. while Ben's taking care of some technical issues, I'm going to go ahead and keep going on. And it looks like we have Attorney McDonough also joining us. I believe we had some tech glitches there. I'm Attorney McDonough, as is Zoom-based life right now. Hal, can you hear us?
Oh, yeah. Sorry.
Awesome. No, you are fine.
Technologically inept.
No, I'm sure everyone is having issues today. I think that's just 2020 in a nutshell. So this is Harold McDonough. He's our other esteemed panelist, and he's also a former assistant U.S. attorney for the Middle District of Tennessee. And Attorney McDonough, Attorney Austin has already given us a brief overview on what color of law means, but I would love to get your input before we get started on any other questions on what your take on color of the law prosecutions mean and how the federal government gets involved in these police shooting cases.
Well, it's usually under the Section 242 of Title 18, and then it basically applies to any type of government individual. And commonly, it's a police officer or sheriff's deputy, a jail or prison guard, or even a judge in some cases.
Wonderful. So I'm going to go ahead and start another question. So what, in your opinion, what are the problems in prosecuting the police, and why is it so difficult to prosecute the police? Attorney,
you directing that to me?
Anyone can go. I know Attorney Glassman was wanting to hop in earlier, but was having some tech difficulties himself. So I was going to give him the floor if he would like it.
Sure, absolutely.
Is the volume working now?
You are very low, but I can hear you.
Okay, how about now? I'll just talk really loud.
That'll do.
No, I think that the main point for this panel, and I think would be very interesting to address going forward, is the point that Roy opened with, which is that the willful standard is what makes federal prosecutions very, very difficult. And in many of these situations, having served as the U.S. attorney when an officer, when there's a civil rights investigation and people look to the federal government to try to come in and dispense justice, it's a very, very difficult situation for the federal government under current law. Most of the time, the best statutes to use are state statutes. So it's a very, very difficult situation under current law with the willfulness standard. Really, because remember that federal prosecutors bring charges only when they are confident that they have proof beyond a reasonable doubt that establishes every element of the offense. If you don't have that evidence, if you don't believe you have it, then it would not be proper for the federal government to bring a criminal case. There's marginal evidence.
I was just going to add one point, Miranda. From an investigator's point of view, from the FBI's point of view, one of the earliest and most difficult challenges that we face as investigators is that we start with somebody else's investigative file. So we don't start the investigation. We are handed somebody else's grand jury minutes. We're handed somebody else's witness statements, somebody else's forensic evidence. It's, we're given this case file that's not ours, and we're stuck with it. So we have to use that and then find more witnesses, see if we can corroborate the testimony. But we're already hampered because we're handed evidence in the beginning. So I think that's one of just the investigative challenges.
Feel free to hop in if anyone else would like to before we move on to the next question.
I mean, Miranda, beyond this just the statutory challenges, it's just a challenge to prosecute a police officer, period, no matter what law you have. And there are a variety of reasons for that. One is, in general, police officers get the benefit of the doubt. In general, police officers do have very difficult jobs to do, and oftentimes in very dangerous situations. There are numerous protections that are given to police officers that the unions have provided them. And I suspect we'll get into some of these later, but I just want to note that there are just some general challenges with prosecuting a law enforcement officer, regardless of the jurisdiction that's happening from. And I suspect others have talked about that in this day's symposium also.
I heard Keith Ellison, who's the Attorney General, whose office is investigating one of these matters, and I thought he gave a pretty accurate description of these types of cases. And he said these are really tough cases to make, and a lot of times what you wind up with is a hung jury, split, 6-6, or pretty close to that. And I thought, that's a pretty accurate description. It's just hard to get 12 people to agree on convicting a police officer.
I think there's also a human factor too. I mean, when I was investigating these types of cases for years, I knew that if we failed, so either we failed because we couldn't bring sufficient charges, or we failed because we got an acquittal, or we failed because we got a no true bill in the grand jury. But if we didn't succeed, we always knew there could be additional riots, there'd be additional distrust against the FBI. So people look to us as the last bite at the apple to try to get justice for the victims. And there's just that human factor that as investigators, we knew that if we failed, there was just a very real likelihood of more rioting and distrust and just violence to the community.
And Attorney Deedle, I want to go back to something you said that kind of caught my ear, and something that I hadn't even thought about when I thought about this kind of stuff. When you said the whole aspect of getting somebody else's file, can you kind of explain that a little further for the audience, and like how that exactly would hurt the case instead of helping the case?
Probably the best way to talk about this is whenever the state investigation has concluded, whether it's after a no true bill or after an acquittal, or however that's ended, we will either get that police file through consent or through subpoena or through another way or court order. But when we get it, the first thing we have to do after you read it, obviously, is then you have to go back and redo it, in other words. So if, Roy Austin was one of my witnesses, I'd have to go find Roy, I'd have to re-interview him, but then interview him about the circumstances surrounding his interview. So did he feel like he was under duress? Did he feel like he had to name a certain person as the subject? So I'm stuck with what he said in the beginning. I know he's going to give me a different statement because you never give the same statement twice, but it's also the circumstances surrounding his statement could impact that original statement. So you think of every investigative step that was taken by the local officials, we have to go back and do it over. And then we're just compounding evidence with more evidence and conflicting evidence. 2 laboratories looking at the same DNA, for example. It's just, nothing's ever going to match. It's very difficult to have that evidence match up 2 or 3 times.
Yeah, that makes total sense to me. It's just extra work and almost like redoing it. So that makes total sense, and definitely an interesting aspect that I don't think many people think about when they consider federal prosecutions of police. Attorney Malloy, I haven't heard from you yet. I was wondering if you had any insight on this, or if you wanted me to ask you a different question. Oh, you're on mute. Oh, Attorney Malloy, can you hear me? I believe you're on mute still. Do you see a button that says unmute mic on the bottom left? The one beside that. Okay, well, Attorney Malloy, I'm going to hop back to you and just, oh, there you go. You got it. Yay. Oh, I still can't hear you. Attorney Malloy, your volume, so I can't hear you. Can anyone else hear Attorney Malloy? Okay, Attorney Malloy, I'm going to come right back to you. We'll have our IT department check your sound, okay? And we'll swing back. So I'm going to circle back to something that a couple of you have already mentioned, and I was going to get to it later on in the panel, but I feel like now is probably the appropriate time to bring it up since it's been said multiple times. The federal standard of willfulness. Do you believe it's too high? And in the alternative, additionally, should the federal standard be changed to include reckless and negligent conduct? And anyone who wants to start off, Attorney Austin, I see.
I'll let Ben go first.
Go.
Lead off with a partial tranche of the question, only by saying as to whether it is too high or should be different. I think it's very fair, really indisputable to say that if the standard were less, if the standard were reckless or knowing, federal prosecutors working together with federal agents would be able to bring more prosecutions under that standard. So if you think that's a good thing, then you need to change the standard.
Yeah, I mean, he's absolutely right. And, you know, along with the whole policing issue, and here's what the concern is that there are a lot of local governments who have no interest in prosecuting police officers and even taking a serious look at police officers. And so it is incredibly important that both the FBI and Department of Justice Civil Rights Division and the U.S. Attorney's offices have a way into these cases to make sure that they're done right. Now, first and foremost, whenever Cynthia and the FBI started poking around with local law enforcement, they usually stepped up their game. When they knew that the FBI was going to be there to say something, to get involved in some way, they became better and did better investigations. It's the same thing if they know that the U.S. Attorney, there's a competition there not to look like you're not doing your job. And to know that, and so just simply knowing that the U.S. Attorney could get involved, the DOJ civil rights would fly in from Washington, D.C. is a big deal in these cases and can matter significantly with them. Now, beyond that, you just have a question of justice. And look, let me be somewhat elitist. I think those of us who worked in the federal government were exceptionally well qualified, exceptionally well trained to do this kind of work in a way that a lot of local prosecutors' offices just simply don't have the amount of experience and training to do these kinds of very difficult cases. So I would prefer to have the federal government doing these cases oftentimes, though you really do want it to be a local issue resolved by the locals. So I think it is important to expand the authority of the federal government, both to get justice more often, but also just because it has a natural ability to force the local prosecutors, the local law enforcement, to significantly step up their game and to look at these cases more seriously when they know if they don't do it seriously, then Ben or Hal or Patrick are going to roll in and they're going to take it from them, which none of them like to see ever on any case.
Attorney Deedle, do you have anything to add? Or
Well, I was going to say that it's, I would echo, let's see, do I want to call myself elitist? I don't know. Let's just let Roy hang out with that. But he's right about one thing, that if you are an FBI agent or a U.S. attorney or an assistant United States attorney and you've investigated several of these, you get good at them, and you figure out really quickly if you have enough to prove that willful conduct standard, which is so hard, as they've said earlier. But the more you do these, the more you just become more of an expert, because it's a very specialized program. I know in the FBI, and the agents that do it, there's just a few of them, but they do it exceptionally well. But it's a learned skill, I think.
Miranda, can I ask a follow-up question of Cynthia?
Of course.
So let me ask you this though, from your perspective, from your agent perspective, under the current system, if everything is working the way we want it to be under the current regime, shouldn't we have the FBI field office, having a strong relationship with the local police department and being able to provide some guidance and technical support, even if it is initially a local investigation?
We've done that in the past. So I'm reminded of the Abner Louima investigation in New York City many years ago. And we worked hand in hand with New York City police sergeants and detectives from the beginning. And then local charges were not brought, federal charges were. But that's one way to do it, is you start in the beginning together. You start investigating everything together. The one good thing that comes of that is there's one file. There's one file. So there isn't multiple statements normally from witnesses. There's maybe one or two witness statements. All the evidence is collected either by the FBI or by the locals, but you know who's collecting it, you know how it's processed. So if you do it together, there are definite advantages. But I would punt over to you and to Roy to answer the follow-up question, which is, that's a great idea investigatively, but you two have to tell us, are you taking it? Because if you're not taking it, there's a whole lot of federal investigative steps that were taken that now have to be used in a local investigation. So that's the rub is, when everything goes sideways, we'll just blame the federal prosecutors. It works really well.
I might give you one suggestion for that. I live in Nashville, and the local district attorney here has said that if there are any type of police shootings in Nashville, he doesn't want the police department investigating them. He wants the TBI, the state police, the Tennessee Bureau of Investigation, to do the investigation. So you eliminate this possibility of having the police department investigating their own. I've been out of it for about 4.5 years, but when I was in the U.S. Attorney's Office, we also had potential civil rights cases that came out of smaller rural areas, and usually those were investigated by the TBI also. So you avoided having the local police or sheriff's department doing the investigation, and we would try to get in pretty early on, communicate with the TBI if they were involved in it, and also with the local district attorney, so we didn't step on each other.
So I guess it's Hal just noted, is something that it's a big question right now that is happening in these cases, and that is who should lead the investigations. And there's been a big movement toward having outside people move these investigations, but it's a real question. And I recently wrote an op-ed on this question, because we now have a set of reform-minded prosecutors who feel like they are better equipped than historically local DAs have been, to be the ones to conduct these investigations. TVI may be very good with homicide cases and assault cases, but a lot of your state level investigators, your AG's offices, don't have the skills to do kind of a street crimes case. So we see this in the hate crime space, we see this in the policing cases, where they just don't have the skills, and yet everybody say, well, send it to them. And it's really kind of remaking Attorney General's office. Now, the other models that could work, and this is someone raised what Ellison is doing in Minnesota with respect to the George Floyd case. He's actually brought onto his team a bunch of alums of the criminal section of the Civil Rights Division, who are helping him with his case on both the appellate side and at the trial side. The other thing you can do is they can also cross-designate assistant U.S. attorneys to work on the local cases. The FBI works hand in hand with locals so that you don't need to do any formal cross designation. But you could actually have assistant United States attorneys, many of whom have come out of those local DA's offices, team up with their old offices to do the case using local charges. So there are a number of different models, and the bottom line point is that we have to get to justice here somehow or another. And I think using people who have the skills, have the experience, have the resources that you often find in the federal government to do these is a great way to do them, regardless of whether you bring federal charges or state or local charges.
I agree. I think that's right on point. And I just wanted to give a couple of quick examples from my own recent tenure. We did that in a couple of cases that were in Franklin County, Ohio, which is Columbus. We had cases where the FBI and the local police department jointly investigated a hate crime, and we ultimately decided that we were not going to be in a position to bring the federal hate crime charge because of the statute. And so one of my AUSAs was cross-designated as a special assistant prosecutor for Franklin County, and working together with the Franklin County Prosecutor's Office, prosecuted the bias and intimidation case in state court successfully. And then by the same token, we had a case of an officer who I can now say, because the case is done and adjudicated, willfully using excessive force on someone in the course of an arrest. And again, the FBI investigated this together with local authorities. And in that case, again, because all jurisdictions are putting their resources together to be on the same team, the Franklin County prosecutor sent assistant prosecutors to be special assistant U.S. attorneys to do the case together with us in federal court, resulting in a guilty plea.
I was just going to add one more thing to what Roy and Ben said, and even what Hal said, which is a lot of times the FBI agents investigating a color of law case are not from the city that they work in. They didn't go to high school there. They didn't go to college there. They're not friendly with the police officers they're investigating. A lot of times that is very helpful when you're not from there. And that was my case in New York City. I was not from New York. So it was, I had no allegiance to the New York City Police Department. It didn't, they were just another police department I was investigating. So I think that's another aspect to the federal case that's very attractive in a lot of ways, is the people investigating it are not connected to those subject officers.
Sure. And Attorney Dito, while I have you here, Professor Cook picked up on the Louima case, Abner Louima, and she wanted you, if you don't mind, to explain to the audience what that case was about, for those who don't know.
Sure. I think Roy and I have done this many times, where we would throw out these names and we think, well, everybody knows this. Don't you know this? But thank you for asking. So Mr. Louima is a Haitian immigrant, and he was living in New York City. This was in the late 90s. And he came out of a nightclub along with a lot of other people about 4 o'clock in the morning in Queens and Flatbush. And the police officers, NYPD was there just trying to disperse the crowd, and some punches got thrown. And Officer Justin Volpe from the 70th precinct got hit by somebody, and he went down. He got back up. He looked at Mr. Louima and said, "You hit me." And he said, "I didn't hit you." And he didn't hit him. But he was nonetheless arrested and was thrown in the back of a police car. He was taken to the 70th precinct. He was booked, he was processed, he was put in a holding cell. Mr. Volpe and another officer, Chuck Schwarz, took him out of the holding cell, took him into the bathroom of the 70th precinct, and sodomized him with a stick, telling him, "Don't you ever hit a police officer again." Pulled his pants back up, threw him back in the holding cell, and in a very short time, Mr. Louima started hemorrhaging and became very ill. 911 was called. That's how the case broke. It was front page news in New York for, oh my gosh, months and years. There were other officers that were investigated and indicted for being involved in the cover up, for hiding what they knew about Mr. Luima's assault. And ultimately, Mr. Volpe pled guilty the first day of the federal trial and received 30-year prison sentence. But that was a case that it was determined very early on by the Department of Justice, by the Southern District of New York, that we would investigate it together, the NYPD and the FBI. And even looking back, I think that was absolutely the right model, because nobody could ever say that the investigation was tainted, that the New York City Police Department was investigating their own, therefore they were biased. Well, then you would have to say all of us were biased too. So I think it worked well. And like I said, the witness statements, how we collected the evidence, the grand jury testimony, everything went through the federal system, but NYPD was with us. And I think it was the right result in the end. And I got to know Mr. Luima very, very well in that time frame, and he is a humble and gracious young man. So I'll throw that in there too.
Mr. Malloy, have you been able to figure out volume yet? Let's see. Still nothing. What I'm going to tell you, Mr. Malloy, is you keep working on it and you just chime in whenever you feel like it. If I hear your voice, I will hush because I'm dying to hear it. Okay, we'll figure it out. No worries. So I'm going to bring this whole panel to the symposium right now. And so I want to ask you all, do you foresee a federal prosecution in the case involving Breonna Taylor? And can you explain why or why not? And Attorney Austin, I'm going to start with you this time.
No, quite simply. And look, the main reason at this moment, no, is because for the federal government to step in right now would be for the federal government to step on the state, step on the local prosecution. Even if the federal government does not feel that the charges are sufficient, they would not get involved once the state has indicted, because it makes a mess of the case. Exactly what Cynthia was talking about becomes even messier if you're in the middle of some kind of prosecution. And the other reason why is there's no reason. There's no statute of limitations. So the federal government can sit back, watch what happens at the state level, and then make a determination whether or not it wants to come in after. And this is kind of Rodney King is the best known example of this exact thing happening, where the state actually, where the officers were acquitted at the state side, they were brought to trial by the federal government using 242, and 2 of the 4 officers were convicted later. But, and I think it depends on what administration is there. We have an administration, and let's be completely honest, we have a Republican Attorney General who has made a decision on what charges to bring. The current administration, quite surprisingly, has gotten out in front of their skis on this and made it very clear that they are perfectly happy with everything that this Attorney General has done, the state Attorney General has done. And so they're never going to, the current administration is never going to come back and say that what this Attorney General did was in any way, shape, or form improper or not right. Now, if there is a new administration, I think you have an interesting circumstance as to whether or not they later bring charges. Then the only other thing I want to throw out there is we always look at that ultimate situation, and that is, the very tragic death of Breonna Taylor. There's no reason why 242 could not be used, and I don't know whether or not such an investigation has been done, but whether or not 242 could have been used to check out that initial warrant that was used in this case. There have been in the press a lot of questions about whether or not this was a proper warrant to begin with. And for law enforcement officers to swear to a warrant that does not have probable cause, is a violation of someone's constitutional rights, and it is something that is prosecutable. Now, I'm not aware of us ever, us being my old group of government prosecutors, ever bringing a case like that. But I'm not sure why that isn't looked at, because it is a serious problem with law enforcement officers swearing to bad warrants. And here we have the most tragic of possible results.
I'd like to just add one quick thing to what Roy said. And I've said this many times. I did color law cases for over 20 years in the FBI. And, you know, I worked in Republican administrations, Democratic administrations, and I never, ever was ever given a signal or a nod or a wink or just a straight statement by anybody in the Department of Justice in any of those administrations where they were going to do something one way or the other because of politics. Never. No, I mean, I was always encouraged to investigate these cases under Republican and Democratic administration. So it always hurts my heart. And I know Roy and I've talked about this many times. It hurts to think that that's now been politicized because it wasn't in the past.
And so, Attorney Deedle, while you're on here, do you agree with Attorney Austin that there will not be a federal prosecution here?
Can I do the it depends?
Well,
So I
yeah,
can't do
this is
that.
a law school sponsored. It would
Well,
be, yeah.
So my heart always says, you know, you can't tell the public that there's no hope. So I guess part of me is going to say there may be a chance of hope, that the federal government could do something. But I think just the little bit that I know that's public information about the case, I agree with Roy. I don't know how we can get, I'm not in the FBI anymore, but I don't know how the federal government can get there. But I don't want to give people a sense that there's no hope. I always want to think that the FBI and the Department of Justice gives people hope.
If I could just add just a little bit more general background in support of what Roy was just explaining about why there's not, at this time at least, going to be a federal prosecution, is that as a very general policy in the Department of Justice, and this has been the policy for decades, always the state or local prosecuting authority is encouraged to go first in an investigation and prosecution of a civil rights case. That's called the backstop policy, and it has been the policy of the Department of Justice for a long time, for a lot of reasons, including that, number one, as a matter of policy, you want to have the local authorities be invested in investigating and prosecuting this kind of conduct, and not simply push it off and say it's not my problem for somebody else. Number two, because as a matter of the principles of federal prosecution for like all investigations and prosecutions, when you are deciding to bring a federal prosecution, you're part of the calculus is determining that you have to do that to vindicate the federal interest, as opposed to having some other prosecuting authority do it. And then third, because as we've already talked about a little bit, often it is the case that comparatively there is a more apt state law statute that can be used to get at the conduct than simply relying on 18 U.S. Code section 242, which is the excessive use of force or any kind of willful violation of constitutional rights under color of state law.
Attorney McDonough, would you like to weigh in as well? I'd love to hear your opinion.
I don't know if I locked myself out or not. Can you hear
No,
me?
I can hear you. I just can't see you, but I can.
Okay, that's fine. That's even better. Frankly, I don't think there would have been a federal indictment even in another administration. And I don't know all the facts, but I do know that there was a search warrant. And that, to me, coupled with the fact that her boyfriend fired the first shot, as I understand it, I think that would make I could see, like I said, even in other administrations, that the Department of Justice would say this is just not a case we're able to prosecute. As regrettable as all that is, like I said, the first thing is if they've got a search warrant, and I don't know the facts behind the search warrant. I haven't heard that they intentionally lied on the search warrant. So that, coupled with the fact that they were not the people who fired first, I think it would make it to a type of case that I could think in the past would not have been prosecuted federally.
Mr. Malloy,
As bad as that may be, that's just, those are the facts you have to deal with.
right. And then, so I wanted to circle back real quick on something that I wondered if the Attorney General, and Professor Cook posted this in the chat as well, if the Attorney General has already said that the use of force was justified, is that essentially a preclusion from a case happening, or is there a way that a case could happen after that?
So quite simply, one, and let me be clear, I think Hal is right that this is a very difficult case, regardless of which of who's in office, to bring 242 charges. I think what I was going to more just to clarify was that once you have the state charges, you're not going to have federal charges suddenly appear. Now, I don't know how closely the federal government even looked at this case, whether they participated in the investigation with the Attorney General's office. And we also we don't know, sitting where we do, all the evidence that is a part of the case. But, what one Attorney General says is not binding on a future Attorney General as just a matter of law. There's nothing about what, Eric Holder and Loretta Lynch said things that Jeff Sessions and Bill Barr have totally ignored and reversed. Whoever, should there be a new administration, they are not stuck to anything that Bill Barr or Jeff Sessions says as their interpretation of the law. So that in and of itself does not prevent the federal government. Now, the facts are what they are, and the facts aren't going to change regardless of who's in office.
Does anyone else want to follow up on that? If not, we can move on to the next question. All right. Okay. So I wanted to take a second and talk about giglio, which Professor Cook very much informed me that is the correct pronunciation, regardless of what anyone else says. So whoever takes the lead on this question first, I would like for you to explain to the audience what giglio is, what the case, what happens in giglio. However, I have a couple follow-ups on this, so I'm going to start piece by piece so we don't get lost in translation here. So what happens when local law enforcement creates giglio? Attorney Deedle, why don't you take us on this one?
Oh, no? I was waiting for Roy to jump in on what is giglio.
I was going to let someone else take
you
this
or
one.
Ben have to do that one.
Yeah. Mr. McDonough.
I only deal with it after it happens.
Mr. McDonough, I know that you know a lot about this because Professor Cook told me that you were adamant about this pronunciation as well.
Well, basically, it's a statement that the witness has given previously that can be used to cross-examine the witness, particularly if it's inconsistent with the testimony before. And I think that's why it's important to try to coordinate the investigation so you don't have multiple investigations going and multiple people interviewing witnesses. As I said, when we did them, we usually did it in conjunction with the TBI and the FBI and tried to avoid the state, the local police doing their own investigation. Once they do that, you're stuck with whatever statement they take. So the objective is to try to get as few statements from a witness as possible.
So with that, thank you, Attorney McDonough, for explaining to us what it is. What happens when interviewing officers destroy the witnesses by getting them to contradict themselves or make statements inconsistent with their memories because they want to destroy the case? What happens then?
Well, then have the witness explain why I said this to the police, and why I said it then, but right now that's not accurate. But I mean, you're already in a pretty deep hole in that situation.
Just, sorry, if I may just weigh in a little bit. So there are a couple strands here, and I think Hal landed on some of it. So in general, you have a Fifth Amendment right not to testify, not to provide any information that can be used against you. And so, the other policy that you're dealing with here that can be very, very ugly is Garrity, and Garrity and Castigar policy. And that is the idea that in an administrative review, a law enforcement officer cannot be compelled to provide information about the incident they were involved in, and then later have a law enforcement agency use that information to prosecute them criminally. And so you have Giglio on one side, but Garrity is another piece of it. And so what you end up creating is these two teams that are looking at all of your information. And so Cynthia is very familiar with the dirty team. So you have a team of people who can see the Garrity information, can see where the involved officer may have been compelled to give a statement, but that information can never go to the team that could potentially prosecute the case. So if you really want to mess with an investigation, and this has happened, is you make that Garrity information as public as possible. And that is a huge problem then, because how does a prosecutor live in a bubble and avoid any, and it's the prosecutor, it's the investigators, no one on that side can know about that compelled statement. In addition, look, if they want to mess up your investigation, they just create awful statements. And it's very easy for police departments to create awful statements from witnesses. It's the questions you ask, it's the way you ask the questions, it's the way you write down the questions that were asked. And so should local law enforcement, and we've seen this certainly, want to destroy a case, you just make a witness look crazy, look like they didn't see what they're now saying they saw. And then prosecutors have to go up there and argue, well, this statement that came before the statement that I'm telling you about is completely wrong, and it is fabricated and what's not. And you end up having a trial within a trial within a trial, which ends up being just a mess. And so there are a number of ways that a local case can interfere with a federal prosecution, or any prosecution for that matter.
I would just add to that. I like how Roy put me on the dirty team, which can I be on the clean team? That just sounds better. But we take, for those that aren't super familiar with how these cases work and getting in the weeds, the FBI and Department of Justice take the dirty team and the clean team and the Chinese wall concept extremely seriously. And I was on many dirty teams and clean teams, and you don't mix. I might know something that is very powerful and very compelling as the dirty team case agent, but I can't talk to the clean team, and I can't share that with the clean team. And it is an obligation and a duty that agents and prosecutors take extremely seriously, that they don't mix. And I would echo what Roy said too about it's really easy to gunk up a case. It's really easy to mess it up and just create so many statements from one human being, especially if you have the witness that gave statements to the media, on social media, to the next door neighbor, not even to mention to law enforcement or to a prosecutor or to an attorney. So it's easy to really mess up a case super fast.
So I want to offer a little bit of a dissenting viewpoint on this question, not on the Garrity so much as on the Giglio. Only to say, I mean, it's a light dissent, because certainly the more time somebody has to tell their story, any witness, the more complicated it becomes. And there is an issue separate and apart from creating inconsistencies of just fatigue that a witness, will have to be telling the facts of what happened to different people like years down the line after having told their story multiple times. But on the question of, I felt like I wanted to push back a little on the idea of destroying a case. I don't think that I have the same level of experience that Roy and Cynthia do. But in my time, I don't think that a local officer or anyone investigating a case can destroy a witness, because ultimately the facts are the facts. And I think that if the federal agent ultimately working on it and the federal prosecutor ultimately working on it, are sufficiently invested and diligent, like you can deal with any previous statements that were elicited, because ultimately you are depending on what the witness says. So I guess from my experience, I think yes, you can certainly, the more statements make that you have to account for can make an investigation or prosecution harder. But I don't think that witnesses can be like just destroyed by any question.
So here's a chance for Ben and I to go at it a little bit. I mean, look, I think the problem is that the police cases are on the margins to begin with, and you rely so much on the credibility of your witnesses, who oftentimes, let's be honest, and this is something we have not talked about. Oftentimes, the witnesses in a police misconduct case are not your rabbi, priest, imam. It is someone who is criminal justice involved to begin with. And the witnesses are oftentimes criminal justice to begin with. And so you add on top of that some kind of very inconsistent statement that the jury then has to weigh against this very clean looking law enforcement officer. And, I think the word destroy is probably right. Now, Ben is absolutely right. Prosecutors are in the business of trying to clean up tough witnesses who have made inconsistent statements. But I think in most of those cases, you're not dealing with something where already the burden on you to show that a law enforcement officer should go to jail for what they did is already such a high hurdle that once you start really putting in ugly stuff on the witnesses, it becomes very, very difficult. So that's just my pushback. But nothing Ben said is wrong. It doesn't, as a legal matter, it doesn't make it impossible to then bring the case.
And I actually completely agree with what Roy just said as well.
I was going to add that this becomes even more apparent when your color of law case is in a jail or a prison. So all your witnesses are either inmates, and it's really easy to destroy the credibility of a criminal, or it's your other side of the witnesses, as Roy said, they're all law enforcement officials. So I had several of those cases, and it was very easy for the prison guards to further destroy the credibility of my witnesses.
And there you go, Mr. McDonough. I saw you wanted to add in.
And maybe this is a little off the topic, but I know that one of the favorite charges that the Civil Rights Division at least used to like to bring was false statements under 1001, that if you could get the defendant to agree to an interview with the FBI, and then you can prove that what they say the FBI is a lie. I know I had a trial with a civil rights attorney where we prosecuted these jail guards for beating up an inmate, and they submitted to an interviews with the FBI and lied. And so charged them with the false statements, but we also charged them with civil rights violations. Well, the jury acquitted them on the civil rights violations, but convicted them on the false statement, which is a felony, which then disqualified them from further work in law enforcement. So there's some ways to get around the requirements of 242.
Yeah, I mean, on that same topic, many of these many investigations into like excessive force under 242 will also include a parallel, if not necessarily under 1001, but also usually a falsifying official records investigation, because most of the time there's going to be an official use of force report, which may or may not match up with what surveillance video or witness statements say.
Well, and I wanted to follow up with a different aspect to that question, but I just wanted to remind the audience watching in, the Q&A is available, and the last few minutes of this panel, we will go through some of the Q&A. So if you have any questions, we do want this to be interactive, so please feel free. I've seen a few posted already, but please feel free to go ahead and continue posting. And I don't know if this is really allowed, but when I listen to you all talk about this, you know, I have a degree in psychology, and there's so many different aspects of what you all are talking about destroying a witness's credibility, a witness not being able to recount their statements, that go back to a purely psychological aspect where it's just not biologically possible to recall statements. It's so easy to have false memories. It's so easy to see yourself doing something and that's not real. And so you take just a fundamental non-legal aspect of something like this, and you can see fundamentally how easy it is to destroy a witness's credibility, even without an expertise in the field. Just my 2 cents.
No, I'd like to actually add on quickly
sure.
On top of that point, is that I actually think, and certainly in my experience over the last several years, investigations into excessive force or other 242 charges, I think have become more makeable as there is a greater likelihood that there's going to be video evidence.
Which makes total sense based on my comment as well. It makes total sense. So rearranging the question just a little bit. So what happens when prosecutors attempt to destroy witnesses in the grand jury? So are those witnesses damaged for the parallel civil proceeding as well as any federal investigation? I know our audience members probably aren't as familiar with jurisdictional issues or civil proceedings being parallel to a federal investigation. So if one of you all just wanted to do a quick explanation of what would happen in that case and what the repercussions would be, I'm sure they'd be very interested.
So I do a little bit of 1983 work in addition, so I'll just start off, but hopefully others will jump in. So the first issue you have is the power of a prosecutor in a grand jury to really spell out the case, and the other struggle there is that that's a statement under oath, and so you have there it's a more powerful statement in the law than would be just a regular police report statement. Because you run through the general cross-examination questions. Don't you remember you took an oath to tell the truth, and didn't you promise to tell the truth? And you know that it's perjury if you don't tell the truth, and you go to jail if you didn't tell the truth, and you didn't tell the truth. And so you jump on a witness going through that whole routine. But the concern, the thing about your question is the grand jury transcripts, and this is what was very odd with respect to what happened here in the Breonna Taylor case, is the grand jury transcripts, certainly in the federal system, they never get out if that case is not prosecuted. And so the civil, you can't subpoena grand jury transcripts in a civil case. They are locked completely shut. And so I'm glad that we all got to see behind the scenes and what happened with the grand jury in the Breonna Taylor case, but that does not happen in the federal system at all. You will not see those coming out because someone has sued another person. So whatever the prosecutor does in the grand jury stays in the grand jury unless those statements come out in a federal trial of some kind or another. And that's Rule 6E And there's just, it is one of the most inflexible rules that I'm aware of in the federal system. But again, you know, it matters who the prosecutor is. It matters the questions that are asked of witnesses. It matters how they're asked. But the prosecutor has all of the balls in his or her court in the grand jury, because there is no defense counsel to push back. The witness is alone, and they're stuck and sitting in front of anywhere from, I think, 13 to 26 people, depending on the jurisdiction, and a court reporter. They have no lawyer there. They have nothing. And so the prosecutor can really dig in on a witness. And look, there have been times when you really want to have that ability as a prosecutor to really try to push for the truth. But I think there, you know, in our current system where criminal justice reform across all categories is being raised, I know the grand jury is another question. People question whether or not the grand jury is something that we should continue to have, or if it should be a relic of the past.
I would also add that in these cases, a lot of times there's two grand juries. There's the state grand jury first, and then there's the federal grand jury. And when I've had access to the state grand jury minutes, a lot of times what we see is the local prosecutor threw it. I guess that's what we used to always say is she threw it, you know, she threw the no true bill. So once you go through and you read all the witness statements and you realize, okay, we can rehabilitate these same witnesses because she just didn't ask them the questions that would have gotten an indictment. So she skewed it with the questions that she did ask witnesses that she had to put in the grand jury because they were very important eye and ear witnesses. So for those witnesses, it was very easy to differentiate the first statement in the grand jury and why that was different from the succeeding statement in the federal grand jury. So there's, even if a witness is, you know, destroyed in a state grand jury, it's, if you know why it was done and how it was done, you can rehabilitate that person going forward.
And Attorney Glassman is chomping at the bit. So I was
just going to say, that's my point.
Do you have anything to add? You were nodding your head very vehemently with Attorney Diehl at the end there.
Cynthia was just making that was the point of my the difference that I was having with Roy. Cynthia was just coming in and making my point. I mean, I will confess that I have not seen that Netflix documentary, but I mean, I will say, just as a matter of, like, you know, first principles, you can't destroy a truthful witness because they're telling what they think is the truth. So anything else that happens, you can deal with and rehabilitate, or you should be able to, so long as the witness is trying to tell the truth, which that's what we have to go with.
I see we have a guest star joining us for a moment.
This is completely unorthodox, but
this is Professor Blanche Cook.
When I see my federal feds, I just get beside myself. Here's the question. I've had cases where investigators didn't like the case for whatever reason. And they have a way of asking questions such as the following. I see you have some probation violations. I see you have some supervised release violations. Let me talk to you about what you saw. Are you sure you saw that? Is that what you saw? Are you sure you saw that? Because in this case, we've got a witness who said that he did not hear an announce 2 times. And on the 3rd time, he heard an announce. And I've sat in on interviews with investigators who do not want that case there. We had cross-burning cases out in Nashville where the locals did not want that case. And when they sat and interviewed that witness, and I sat with them, I had to tell them, now, wait a minute, how are we interviewing this witness? And if the local investigator does not want the case and gets the witness all turned around, that witness is burned for the rest of that investigation, the federal investigation, as well as the civil proceeding. In the case involving Michael Brown, the prosecutor allowed Darren Wilson, who did the shooting, to testify for 4 hours straight without interruption and then use the rest of the hard evidence to frame the story that Darren Wilson gave. But when the other witnesses came into the grand jury, they rigorously cross-examined those witnesses. And there's no nomenclature for a prosecutor to cross-examine its own witness in the grand jury, because you don't usually cross-examine your own witness in the grand jury. But the prosecutors in that case so rigorously cross-examined those witnesses are now destroyed for the rest of that investigation, for any future investigation, for the federal investigation, and for the civil proceeding. So that was what I was trying to draw attention to there.
Professor Cook, you're not talking about, are you alleging that there's implicit and explicit bias in policing? You're not saying that, are you?
Do you want to know anything about
You're
that?
not saying that, are you? That can't all be what you're.
For fear of taking up too much time on this panel, I'm going to disappear again. But that is exactly what I was saying.
She lobs the Scud missile and then she puts herself, she puts herself on mute and goes, oh, there, look, she's gone. The one thing I would say, and again, this is going to sound very naive and very Pollyanna, but I still believe that one of the reasons the FBI and the Department of Justice is so good at this work is because they give people hope. And when Professor Cook was talking about, destroying witnesses and they're hard to rehabilitate, I agree, but it can be done. I had a death in custody case in New York, and my two primary eye and ear witnesses in the jail were pedophiles. They were in jail for sexually abusing minors. You can't get a more hated person in a jail, or someone who's just more despised and not believed. But they gave the same statement over and over and over. And despite the jailers and the local officials' attempts to destroy them, we were able to present them at trial and get a conviction against the officer. So you can, there is hope. I mean, there's always hope in these cases, I would submit, and it's tough, but it can be done.
But let me take Cynthia's story and Professor Cook's story one step further. I was early on in my career, I was working a grand jury in New Jersey, and the assistant United States attorney, I was coming from the criminal section of the Civil Rights Division in Washington, D.C. The assistant United States attorney there from New Jersey did not like the case. And it was a case involving a Black officer physically abusing a lot of young Black men, just throwing them up against cars, stomping on them, doing a bunch of things like that. This assistant United States attorney did not like the case. And I actually believe that he was trying to undercut me within the grand jury. And we reached a point where we had to elevate it to our supervisors. And the decision was made that he would no longer ask any of the witnesses any questions in the grand jury. Like he would be there, but he would no longer ask any questions because he was making a mess of the case. He was digging in on the witnesses on things that I thought were irrelevant. He was leading them in ways that was directed at making a mess of the case. And ultimately, we got the officer to plead guilty. But then in sentencing, the two of us got into the point during the sentencing that the judge said, okay, the Department of Justice needs to get its act together, and that two of you cannot be up in front of me telling me two different things. So we're going to take a recess and you come back here and decide who's going to argue on the sentencing motion. And again, I was able to make the arguments that needed to be made. But that's a federal prosecutor who I felt was trying to destroy a civil rights case. And it can happen from law enforcement. It can happen. Look, I love the FBI agents, but we had a lot of FBI agents who hated the civil rights cases because they needed to work very closely with those local law enforcement officers. And so I say it to say, it's not like we have a perfect answer to this, but the idea that a person with power can really mess up one of these cases it can happen at any level from any jurisdiction.
Can I get back in on that too? Yeah, no, Roy, I think we're talking about two different things there, though, because Roy is, of course, completely correct. And I'm sure nobody would disagree that for anyone to have a successful prosecution in a situation where we're talking about a very high standard of proof and mental state in the first place, you've got to have a fully committed, fully skilled agent and a full case agent and a fully committed, fully skilled prosecutor. So no doubt about that. One thing that Roy's point and Cynthia's point, and actually, and Professor Cook's point also do mention that I hadn't actually thought a lot about before this panel is I personally do have always had fantastic experience with the FBI and just think so highly of that organization and its commitment to enforcing the civil rights laws through these investigations. But that said, there is a tension, even though the FBI, generally speaking, the agents may not be from that location, the field office is still supposed to be working with and building relationships with the local police departments. So one thing that I do think, from my experience, is worth considering, certainly within the FBI, is devising some system or assignment so that within every field office, you have some top agents who would not otherwise, other than doing these kinds of investigations, be involved in matters that interface with the local police department. I'm not exactly sure how that would work because there's a lot of variation across field divisions, but I'd be curious as to my other panelists' views on that.
Well, before they answer, you really just took away my thunder and segueing into the next question, because you kind of hit the nail on the head. I was going to ask, given the inherent conflict of interest when officers investigate law enforcement, do you think Congress should act to usurp the field and create a special department within the Department of Justice, one specifically designed to be devoted to shooting cases from investigation to cert? Or what Attorney Glassman suggested, should there be, local divisions like this dedicated? So I would love to get each of your opinions on this. Attorney Dietel?
I think two thoughts. The FBI has a number of different violations where we have what's called a fly team or a jump team. And they are a group of agents that specialize in certain violations, usually terrorism investigations or cyber investigations. And they can be dispatched within an hour or two, moments notice, to go to a particular location and investigate something that's happening. And they are a cabal of experts that can be dispatched to investigate something that, it's maybe in a completely different state or location from where they work. That is a great model to use. I think I would support the FBI doing that and having, a group of maybe a dozen agents that not only are really good at this, but that enjoy the work, that really have a passion for civil rights enforcement, because there are a few, there are some, but I think they really should be relied upon to be subject matter experts in this area. But I would also say that there are some agents, and I'm reminded of an agent that worked in the Cookeville RA in Tennessee that Hal's probably familiar with. I won't name him, but he was from the Cookeville, Nashville area. He went back there after several years in different field divisions, and he was instrumental in a number of very high profile color of law cases where victims died. He was from that area. He grew up there and he knew these people, and he was phenomenal at this work. He was really, really good. But like Roy said, you have agents that do not want to do this, maybe because they just don't believe in this work, or they think it's beneath them. It's not what a real agent should be doing. So I think that for every division in the Bureau, that special agent in charge has to know by name and by face the agents that are assigned to the civil rights program. Do they want to be there? Are they there because they're under investigation, because they filed an EEO, because of some other reason? Because in a lot of divisions, that's who's assigned to those cases are agents that are under investigation themselves and they got punished. Now they're working civil rights. I don't think that's the case anymore, but it used to be about 20, 25 years ago. Roy is nodding. But I think the way you address that is they need to want to be there and they need to be good at it. That without question, that has to happen in all 56 field divisions.
I agree with both what Ben started off with this and what Cynthia just said. My only concern with it is just whether it can be done logistically. There are over 1,000 police homicides every single year. Every single one of those parents, brothers, sisters believes that it was an improper shoot. These investigations do take time, and look, the variety, the number of ones that are done by the Civil Rights Division, it is very rare, in fact, for the Civil Rights Division to bring a case where there's a fatality. So I'm talking about over 1,000 fatalities, but the number of cases where excessive force needs to be investigated, probably 10,000, I would just guess, where it could be investigated. I'm just throwing out a number. The Civil Rights Division itself is tiny. It's about 50 attorneys, the criminal prosecutors. They can barely handle the number of cases that come through. So just from a resource issue, I think we do have to rely on the local RAs who are already overstretched because they're getting, when you're getting into the smaller resident agencies, they're doing everything. They're doing complex fraud and public corruption cases. They're doing terrorism cases. They're doing human trafficking cases. And then you throw on some civil rights cases. So as massive as we think the federal government is, and I don't even want to speak for the U.S. attorneys who will all complain that they don't have enough resources, but I'm sure they all had more than enough. But for the rest of us, it was just really, really tough. So anyway, I just think, yes, in a perfect world, we would create that specialized unit, but I just don't know that we have the resources to do so.
Attorney McDonough, would you like to weigh in?
Yeah, I think that it's probably just not practical to have a unit that deals with only civil rights cases. Like in Nashville, the office of the FBI was big enough that they could have some agents assigned to do civil rights cases who probably didn't interact with the local police that much. But when you got out into, you mentioned Cookeville and Columbia and Clarksville, are all cities, towns outside of Nashville. They each had a 2 or 3 person FBI office, and those agents had to do the investigation, and they did them well. I have never had any complaints. I never saw any of them let up at all. They did excellent investigations. And for somebody to come in out of out of Nashville even someplace else to come in and try to do the investigation, those folks knew the territory. And I think it would have been very difficult for somebody to come in that didn't know the territory and who's who and who can you believe and who can you depend on. So it sometimes puts those folks in a bind because they have to work with those police departments. But I never thought that they let up at all because of that. They were just right down the line, and we did an investigation of facts of what the facts are. So
I think it's also just one final point on this. It's a question of resources, like Roy said. So it's incumbent upon the Attorney General and the Director of the FBI to say, if they need to devote more resources, more human resources to a particular crime problem, let's say color of law or police brutality issues, you surge more agents to that problem and you devote more agent power to that problem, just like we did for terrorism after 9/11. It's the same idea. So it's priorities, what's important to the director, what's important to the Attorney General. You devote more people to it and you give them the training and the expertise to do it well.
And kind of on a similar note, so I know in the Ferguson case, the Department of Justice did a comprehensive review and report and made many suggestions for structural change within the Ferguson Police Department. Do you see any room for something like that and those kinds of comprehensive studies and actions such as that in the current administration?
Nope. Not gonna happen. Just not gonna. They hate it.
Roy,
Sessions?
please don't hold back.
I'm
Don't-
sorry.
I
I'm sorry.
mean, if you're not going to be honest, and we need you to. Wow,
No,
you answered that so fast.
Yeah, no, they've made it so clear. They made it absolutely clear. Go ahead, Ben. You can't hear you.
Said it like this is just this is a policy change. Like he outright said, like Jeff Sessions out as Attorney General, and when I worked for him for a time, but outright said that. So that's just a policy that needs to be changed.
Yeah, yeah. If Ben, your volume was a little coming in and out, but as Ben said, it was Jeff Sessions' policy not to bring pattern and practice cases, and that policy has largely been carried over by Bill Barr. Now they did have their very first pattern of practice case against, I believe it's Springfield, Massachusetts, on a very, very narrow issue. But it's a complete philosophical difference where they do not believe that there is any reason ever to bring a pattern of practice case against a whole law enforcement, because that's basically saying that law enforcement is doing things wrong. And it's just not it's not something that they believe in. So,
well, even short of a pattern and practice investigation, the current administration also decided not to do like a review that has not to do a review that has technical support suggestions for local police departments, even at their request. So that is just a change from the COPS office, how it was handled under the last administration.
So we did have one question submitted through the Q&A that I wanted to ask you all. We had one earlier, but I asked it on my list before they got to even have it answered themselves. So we had a question that said, could there be federal charges if the federal investigation finds that the warrant was falsified? And this is specifically towards the Breonna Taylor case. If anybody has any thoughts.
so I just very briefly raised this earlier, and I think technically yes. If an officer falsifies a search warrant, that would be a violation of 242. I think what I was saying is I've never seen 242 charges brought on that set of facts. But I think it is something that is worth investigating. Now, you're not going to get to the officers who fired the shots on that and the actual violation. And I had a hate crimes case like this, where the person ended up dead, but what we took was a hate crimes case on preventing the individual from using it was a bar, so using a public accommodation. So you're not looking at the ultimate result. But yeah, I mean, I think the language of the statute would allow it.
I think we had the, try to think if this was her name, Katherine Johnson in Atlanta. That was when you were at DOJ, Roy. She was an elderly woman living in an apartment building. I might screw these facts up, but I seem to recall that the Atlanta Police Department officers, they falsified the warrant, but that they also went to her apartment to get access to it. They falsified the information in the warrant. They ended up shooting her and killing her, and she was completely innocent. It was the wrong apartment. It was a disaster. And 242 charges, I think, were brought against them. But that was a case where the same officers that wrote the bad warrant were the ones that went to effectuate the bad arrest. So I agree with Roy. I think it's good evidence. I mean, it's a good start if you can prove that, and that might, have a domino effect to some other things. But I would echo what Roy said.
Well, I have one final question for you all as a wrap up, and I'd love to hear each one of your thoughts on this, because it's a pretty open-ended question. What do each of you believe solutions that you would propose to the current crisis of police shootings?
You're giving us each an hour, right? To answer that one.
A brief synopsis.
Oh no, I'll let one of the other gentlemen go first.
Attorney McDonough.
Well, Okay, I'll just put this out there. It's something that really eats at me, and maybe it's not pertinent to this, but I think this, I heard an ATF agent that I knew for years, and he's now on CNN or MSNBC as a commentator whenever there's a mass shooting. And I heard him say this one time. He said, "Why are you surprised?" He said, "The country's awash in guns." And I thought, that's an excellent point. I mean, there's so darn many guns around that has an impact on how officers, approach people. Now, that's more than just that. Obviously, there are issues about the fact that they, more likely to act in a certain way against people of color. But the fact is that they find people and they find guns on them, and I think that contributes to their their basis for reacting the way they do sometimes. Now, as I said, that's not the only reason, but that to me is a substantial factor. There's just so darn many guns around, and I think that has an impact on it. But there are obviously many other factors involved. It's just not a simple solution to all this. So I've had my say.
My 3 cents, 30-second is it needs to be a holistic approach. It can't just be defund, revitalize, reimagine a certain city. It has to be top-down leadership in our federal government and across all of the branches of government that they want to address the systemic violence, and they want to do it in a holistic way. You can't address police shootings without looking at poverty, without looking at redlining, without looking at diversity and inclusion issues, without looking at who's in law enforcement to begin with, what's their education level, what's their training, is the training where it needs to be. It has to be a holistic approach. And what may work in Seattle may not work in Cookeville, Tennessee. So it's going to be city by city, and they're hopefully going to fix problems that are endemic and systemic to them. But it really has to be a commitment by the administration and by every government official to recognize that these problems exist and then devote the resources to fixing them.
Completely agree with what Cynthia just said, and would just point out that there is a tremendous diversity of police departments throughout the country, just absolute in every respect. And so it's not possible to paint with a broad brush about what needs to be done with the police, except that I think that I agree with her totally that this is a problem of such great national dimension that it requires leadership and commitment from every level of government, and taking a holistic approach, just recognizing that this country is so diverse that it will take a lot of not just leadership, but also willingness to get down into the weeds all across the country.
And look, what Hal, Cynthia, and Ben have said is absolutely correct here. And what Cynthia said about, do we have an hour? I would friendly amendment, do we have days? Because this is the issue of the day. And it is such a broad situation. But let me just take one very tiny piece of it. And that is New York City had close to 700,000 stops a few years ago. Almost 80% of those stops were of Black or brown individuals. Almost 90% of those stops resulted in no arrest, no location of contraband, no location of anything that would lead to an arrest, which means that 90% of the people were innocent, and yet they were stopped by the NYPD. Because of the litigation that happened there, they dropped their stops down from close to 700,000 a year to about 15,000 a year, 700,000 to 15,000. The crime rate went down despite cutting off all those stops. Now, every one of those interactions with the police, most of them did not end up in any kind of violence or any kind of use of force, but it's a violence when your liberty is taken away from you even for that amount of time by police, and that creates this enormous amount of distrust. And I say this to say that despite all the differences in policing, this idea that the police can just stop people based on some gut instinct is one of the biggest problems with the trust, and causes those kinds of that tension that often leads to excessive uses of force. And so we have to create a system where police are not able to stop people as frequently on such light evidence. That's a piece that, and it's a tiny piece of what you just raised, Miranda, by your question. But it's an important part of what should police look like, and what should they be able to do.
I'm nodding my head furiously because Professor Cook was my criminal procedure professor, and my final exam essay covered the Sandra Bland arrest. And so I'm very familiar with what you speak of. And then again, I don't know if this is allowed, but my personal take on it as a law student, I also think that another piece to the insanely intricate jigsaw puzzle that was that question is the qualified immunity issue. And I think that as long as it stands the doctrine as is today, there will continue to be issues with authority. And so I think it exemplifies that there are tons of little pieces. And I completely agree with what all of you all said, especially Cynthia, with the holistic approach. I think that's the only way to cover the entire puzzle. So, but this looks like it will be the end of our panel. I want to go ahead and say that on behalf of the College of Law, I want to express my sincerest gratitude for each of you coming and sharing with us. And then, on a personal level, I want to say thank you just to the extreme. I know how busy I am, so I can only imagine how busy you are. So thank you so much for taking time out of your busy schedules to come here and share your expertise with us on a subject that is on the hearts and minds of so many law students, lawyers, non-lawyers, everyone out there right now. So I really do appreciate it. I want to thank Professor Cook as well for organizing this incredible event. Again, I know I already thanked her, but I could thank her for the next 4 hours and it wouldn't be enough. And I want to thank her for inviting me to moderate this because, it's been an incredible opportunity, and I've been honored to serve as your moderator. And I hope that the audience is giving you a massive round of applause because you deserve it. You are each amazing. And I know Mr. Malloy was also amazing. I could tell he was talking furiously most of the time. So I wish there was a recording of it because I would love to hear it because I'm sure it was insightful as well. But up next, we will be hearing from our fifth and final panel of the day, and they will be addressing the relationship between race, racism, and police shootings. And it will be moderated by my classmate and friend, Miss Maya Marshall, and Miss Janine Bell will be serving on that panel as well. So I hope you all continue to tune in, and thank you each again very much for coming.
Thank you. You did a great job, Miranda.
Hey, Jelani.
Hi, how you doing?
I've had the craziest day. The pod met at my house today. And two
Well,
9-year-olds.
you get to hopefully after this you can decompress a little bit. Let's hope.
No. I still have another event at 6:30. But between that, I have to feed my daughter dinner. I asked my father if he was comfortable picking up pizza from the pizza place. He said no.
I'm sorry about that. We are definitely all having our difficulties, but just try to make it as we can.
I chose. So.
I'm going to grab something and we'll be right back.
Hey Janine, how you doing? Oh, you're muted.
I'm doing great. It's been a crazy day. It's so crazy.
Yeah, I am sorry to hear that. I think I've had one of those too. That was just like, what? You know, one of those days. So I pray that your day gets better.
Yeah, well, we'll see. We'll see. I have a 9-year-old. I'm a single parent of a 9-year-old. So
Oh yeah, you're busy.
it's insane.
Yeah, you're busy. I don't have my lighting is here. It's so strange. I'm just gonna get this together. I don't think I can.
Hello.
Hi. I was trying to get myself together, July. I can't get my light straight. It's the best I got.
I was changing mine up as well, but
Yeah, I still have a shadow on the side of my face. It's the time of day. I've never worked in this room this time of day. So.
it's okay.
Okay, good afternoon. My name is Maya Marshall, and I'm a third-year law student here at the J. David Rosenberg College of Law. I first wanted to thank everyone attending the College of Law's Breonna Taylor Symposium. This is something we put together in an effort to really honor Ms. Taylor and to shed light upon the legal issues and implications of her case. In this panel, we will discuss the role in which race plays in policing, but specifically the role it plays in police shootings. I am honored and extremely excited to have the opportunity to introduce such an amazing panel. With us today, we have attorney Lanita Baker. Attorney Baker is one of the attorneys for Breonna Taylor's family. We have Professor Janine Bell. Professor Bell is the Richard S. Melvin Professor of Law at Indiana University Maurer School of Law. We have Professor Jalila Jefferson Bullock. Professor Jefferson Bullock is an associate professor at Duquesne University School of Law. And we have Professor Jelani Jefferson Exum. Professor Exum is the Philip J. McElroy Professor of Law at the University of Detroit Mercy School of Law. So if you would like to find out more about our panelists, their biographies are available in the registration site and also in the Zoom chat. And there is also a hashtag that I just put in the chat that can be used on all social media sites. So if you want to continue the conversation, feel free to use that. Before we begin, I would like to briefly explain the format of this panel to give everyone an idea of what to expect. So we will first take a few moments to give each panelist the opportunity to briefly introduce themselves and give their opening remarks. After this, I will then ask our panelists a variety of questions relating to the intersection of race and policing. And then closer to the end of the panel, our panelists will answer some of the questions posed by our audience members. So with that being said, we can get started. Professor Exum, would you like to begin?
I would, thank you. Thank you so much. I'd like to first start by just thanking the amazing Professor Blanche Cook for her vision in putting this together and putting it together so quickly and so well, and all of the hard work that I know went into the symposium today. Thank you to the law school, of course, for being supportive, and to all of the students who have participated and done such a fabulous job. And of course, to all of you for tuning in. I really feel honored to be a part of this panel, to get the chance to present with these amazing women, one of whom is my sister, Professor Jalila Jefferson Bullock. And so this is really exciting. So you've spent the day learning about the legal issues surrounding bringing charges against the officers who killed Breonna Taylor and the possible civil damages. And there's just been a lot of legal talk today. And so on this panel, we're zooming out a bit to talk about this overarching issue of race and how race is involved and implicated in police shootings, which of course has come up throughout the day as well. The last panel ended by thinking about what are some possible reforms. And what I really took away from those last answers is that this is a big problem, right? A huge problem, that policing is different across the country. But I really appreciated Mr. Austin's final answer at the end about stops and race, because it really moved us into thinking about and acknowledging institutional racism and how that is at the foundation of policing, and that it's built into the institution of policing, and how we have built rules around how we treat police and police force and police interactions with individuals in ways that actually bolster and support that racism. And that's what I'm going to be talking about today. I am going to share my screen. Let's hope this works. I think it's been going pretty well throughout the day. Okay, you should be able to see that. And kind of take you through a little bit, sorry about that, take you through a little bit of the racism part of it, let's put it that way, okay? So talking about policing and the perpetuation of racial bias. So if you tuned into the very first panel of the day, then you heard Professor Cousteau on the first panel explaining that the Supreme Court has held that charges against the constitutionality of police officers using deadly force will be judged from a Fourth Amendment analysis, which guarantees us all the freedom, all the right to be free from unreasonable searches and seizures. So if a person is killed by the police, the courts treat it as a seizure. And then the understanding that this is a seizure where we just look to the reasonableness of police action is really what's incorporated into the laws, the state laws allowing police officers to use deadly force. It's the way, it's what informs the instructions that we give jurors about the use of force, including grand jurors in their decisions to bring charges. And so they're supposed to be considering whether police officers acted reasonably in reasonable fear for their lives when they kill an individual. And so we've heard this type of discussion all day, dealing with the killing of Miss Taylor, where no charges were brought. And the officers, you know, the conversation goes, well, these officers were fired upon. So, you know, of course, they were reasonable in firing back, and they were in reasonable fear for their lives. And so therefore they were justified. And that's, you know, that's the way the conversation has been taking place. And that's how these conversations go. But when prosecutors and grand jurors, trial jurors, and the like are considering reasonableness, we have to understand how race plays a factor in that determination. And so when we ask, were the officers reasonable in their fear, what necessarily enters into that determination is really asking the fact finder, do you agree that the people whom the police were facing in that instance were threatening, right? And bias against Black people and beliefs about Black criminality have everything to do with the answers to that question. And so nowadays, scholars used to like to use the term implicit bias to talk about this. And I have my issues with always falling back on that as an explanation, but I do think it's helpful in understanding. I think it's helpful to understand the psychology. So I'll just explain it quickly. But if you've ever taken an implicit bias test, what you end up doing is you're matching up reaction terms like with different facial features. So terms that have positive connotations, joy, love, peace, wonderful, but also words with negative connotations like agony, terrible, horrible, nasty, those sorts of things with different facial features and skin tones. And the test is measuring your reaction time. And so what the test is proving is the existence of implicit bias, with the thinking being that implicit bias describes the cognitive process whereby, despite even the best intentions, people just automatically classify information in racially biased ways. And these studies have found that the majority of Americans tested carry implicit negative attitudes toward Blacks and associate Blacks with negative stereotypes. And so what this means, and why I think it's important to this discussion, is that studies have demonstrated that stereotypes linking Blacks with aggression cause people to judge Blacks' ambiguous behavior as more aggressive than identical behavior by whites. So when you ask a fact finder whether they think that officers were reasonable when they decided to use force in any given situation, what we're really asking those individuals, the majority of whom are more likely to interpret non-threatening behavior by Blacks as actually threatening, what we're asking them is, would they have been afraid and would have thought that deadly force was needed? So to me, this is a huge flaw in how we talk about the police use of force. I've written and given talks about this, calling it the death penalty on the streets when police officers kill people, because I believe that when we analyze police use of force as a type of punishment, instead of thinking about this sort of seizure language, then we can start to talk about it and analyze it differently. We can think about some of the Eighth Amendment cruel and unusual punishment safeguards that we have against punishment, like the requirement for proportionality, that if we did that, that would necessarily prohibit the use of deadly force against anybody who's unarmed. And rather than looking at whether officers were, deathly afraid of someone, which allows for really racist reactions to flourish, we would instead look at the entirety of the encounter and determine whether there were punishment procedures in place to avoid the use of deadly force, like first relying on non-lethal force, or even backing up the review scenario to not just the moment at which force became an option, but actually looking at the beginning of the story. This was also mentioned in the first panel, like the decision to enter someone's home under the warrant authority at midnight or 1 a.m., when there's a higher likelihood that the person inside would fear for their lives and react by protecting their home using force. The Eighth Amendment requires that punishment be carried out in a manner consistent with human dignity, that it not be applied arbitrarily. And even though none of this is actually perfect and without racial bias in the court systems, the problem that I have is that any mention of these types of safeguards is missing when we're talking about police imposing the death penalty on the streets outside of the court system. And by not seeing police force as punishment and just asking about reasonable fear, we allow police to act on the same racial biases held by most Americans. And the numbers really do bear this out. So if you look at the numbers on the statistics on police killing people, you see that police kill a disproportionate number of Black people. So in the US population, African Americans only make up 13%, but they're 31% of all people killed by the police, and they're 39% of those killed by the police while not attacking. And so even though the numbers aren't good for anybody, right? 46% of whites, 12% of Hispanics, they're just completely disproportionate when it comes to African Americans. And so when police describe the use of force or their fear and in their decision to use force against Black people, they often describe their fear in racialized terms. So I'll give you an example. So for instance, the police officer who killed Michael Brown in Ferguson, Missouri, we were just talking about that in the last panel in 2014, he gave testimony which depicted Michael as an enraged monster. There's really no other way to describe it. I'll give you his words. So like this enraged monster, untamable by any amount of negotiation. So at one point in his grand jury testimony, Officer Wilson said that he felt like a, quote, 5-year-old holding on to Hulk Hogan. And he also described Michael as looking like a, quote, demon. All right, so this is how he described what I would say was a gentle-faced young man, right, who witnesses saw standing with his hands up when he was shot and killed. And the grand jury that declined charging that officer were asked to focus on the officer's reasonable fear, rather than on whether the officer followed non-fatal encounter procedures before resorting to deadly force. And this is, of course, because the law doesn't require such an inquiry, right? They were asked the question that the law asks, and they were able to inform that decision based on what we already know are racial biases against African Americans. So I'll end my remarks by bringing up just one more point about race and inflicting punishment outside of the court system. And that is to point out that it's not just the police who are acting out on this biased fear of Black people. So I recently gave a TEDx talk, in which I described what's been happening to Black people really forever in this country as being presumed punishable. And so that we're presumed punishable when we're sentenced on the street, which is the way that I see it. So the police do it and everyday individuals do it. And what I mean by that is that contrary to the presumption of innocence, that is at least theoretically constitutional protection in the courts, when Black people are seen out on the streets, they're just often presumed to be worthy of punishment, even if they're just doing everyday things. And so I'll just give you an example. Here's a list of some of the everyday things that African Americans were doing, just out living their lives, when someone, typically a white person, often a white woman, but typically a white person, calls the police on them, right? And so they do this because they see the Black person as deserving of punishment, and they are counting on the police to do the same thing, right? And to actually to see Black people the same way and to inflict punishment. And studies show this as well. So when we look at thoughts or understandings about criminality. Whites overestimate the percentage of burglaries, illegal drug sales, juvenile crimes committed by African Americans by as much as 30%. And this, by the way, this isn't an implicit bias study where you're testing quick reaction times. This is people who are sitting down, pondering, thinking about the information that they've sort of collected in life, and they come out in this way. Across all races, because this is a bias that's held really across the board, across all races, people overestimate Black participation in violent crime by over 10%. So you may be thinking, okay, well, this is interesting, and hopefully you're thinking it's disturbing, but you might be thinking, what does this have to do really with Breonna Taylor's case and situations like what happened to Miss Taylor? And so I'll just say that you have to remember that these same people who presume that Black people are punishable are the same people who mostly believe also that there isn't a police violence problem in the United States. So these numbers show you from starting from 2015 all the way through 2020. Of course, Black people say that there's a police violence problem. And I should actually, let me go back one. How serious is the problem of police violence against the public? Of course, Black people have seen for a long time, and that bears out in these numbers, that there's a problem. But white people, the gray bars, they're feeling that there's a serious problem of police violence is very low and has historically been low. Now it's gone up since June 2020 with the killing of George Floyd, but still it's not a majority, right? And then when you combine that, so this is people saying that there isn't a serious police violence problem against the public, but a majority of people are saying police are more likely to use force against a Black person. So at the same time of thinking there's not a serious police violence problem, also admitting that police are more likely to use violence against a Black person, you have to read into that people are saying, we get it that Black people, sort of get the brunt of police violence, but they kind of deserve it, right? That they've done something wrong, that they're punishable. And that's really what I'm talking about. So you have to remember that the same people who are reflected in these polls and these studies are the judges and magistrates who issue warrants. They are the prosecutors who bring cases. They are the police officers who are dealing with individuals. They are the grand jurors who are hearing the evidence to decide to bring charges. They are the trial jurors who are deciding whether or not to hold an officer responsible. So, they are Americans, they are us. And that is what we see reflected in this, in these decisions. And so the people reflected in these graphs are the same people who make all of these determinations about whether there's enough evidence for a warrant to issue, whether or not that warrant should be executed under the cover of night, at a time when a person would be afraid and would react using force to protect their home, which would then justify the force used against them, or at least arguably justify it. These are the same people who will then decide how much care should be given to the knock and announce requirement when they execute a warrant. They're the same people who will then perhaps respond with an onslaught of gunfire when the homeowner lawfully defends their home. So, these are the consequences of being presumed punishable, of not being someone who's just deserving of a close look, right, at a case, a close look at a warrant application, a second thought about safety when you enter their home, a second thought about how a search will be carried out. And race has everything to do with being punished by the police and the ultimate outcomes. And I'll just leave you with these images to say that it always has, right? We have to recognize the foundation of policing to have an honest conversation here. And so I'll stop there. I have shared with you the titles of a couple of talks that I've given on this topic, and I'm happy to, you can Google these, but I'm happy to share the links in the chat as well. So thank you, and I'll turn it over to my co-panelists from here.
Thank you. I do believe that it's my turn. So I first want to just say thank you to the incomparable Blanche Cook and to everyone at the University of Kentucky Rosenberg College of Law. It's been an amazing day, and I'm so grateful to be a part of this. It's always a joy to present with my sister, my younger sister, but she is my senior in the academy, Professor Jelani Jefferson Exum, who I adore so much, and with Professor Janine Bell, whose work I've admired forever and ever and ever. And it's also so wonderful to meet you, Attorney Baker. I'm familiar with you as well. So I'm going to talk. So Professor Jefferson Exum spoke a little bit about some of the negative attitudes in her talk about African Americans. I'm going to just remind us for a few moments about where some of those negative attitudes come from. And I know a lot of this may be some of the information that was given earlier today, but it's so important that it bears reminding. And I'm also going to talk a little bit about what some of the effects of all of that is today on us as people. So I'm going to talk a little bit about trauma. And I want to offer to us that we should care about this. All of this is not just that it's unfair. It's not just that we're dying. It is harmful to us as a people. It is harmful to us as a group. Okay, let me just share my screen. Okay, here we go. So as a bit of foundation, I think it's important to acknowledge yet again the United States racist roots of policing. So it's of course no secret that American policing is systemically racist. The American policing model is to target discriminatorily, surveil persistently, prosecute fervently, and punish vigorously. This includes using deadly force against individuals through a variety of means, but most frequently by shooting. Unsurprisingly, the bulk of the oppressive effects of this punitive and primitive, heavy-handed approach to criminal justice is borne by minority communities, specifically Black people. Police officers kill Blacks at rates more than twice those of whites, and these racially disparate outcomes should be no surprise to us given the roots of policing in the United States. It's well documented that modern policing's ancestry lies in slave patrols. So the American South system of policing came about in a different manner than that of the North, originating from the need to uphold white supremacy and establish a class whose labor could be exploited for capital. Slave patrols were the original police organizations in these states. The first formal slave patrol was created in the Carolinas in 1704 and had three primary functions. One, to apprehend runaway slaves and return them to their owners. Two, to provide a form of organized terror to deter slave insurgency. And three, to maintain a form of discipline for enslaved workers so that they could continue to produce capital. After the Civil War, these slave patrol organizations evolved into modern policing departments while maintaining their vigilante-style nature by controlling formerly enslaved laborers and enforcing the racist Jim Crow laws. During slavery, we're aware of this, the use of race as a free-floating proxy for criminality was a necessary tool of social control and manipulation and was indispensable in upholding the institution. In short, police have long been the face of oppression to Black people. There is a stigma of dangerousness and criminality that, incident to slavery's legacy, automatically attaches to Blackness. This stain is permanent, it is burdensome, it is unovercomable, regardless of individual success. In his work, Professor William Carter notes that racial profiling is a modern manifestation of the historical presumption still lingering from slavery that African Americans are congenital criminals, rightfully subject to constant suspicion because of our skin color. So of course, what does that mean for us today? I'm going to just give us a few statistics, then I'll talk a little bit about trauma. So it's well documented that Black people are 3.5 times more likely than white people to be killed by police when Blacks are not attacking or do not have a weapon. That's Breonna Taylor, that's George Floyd. Black teenagers are 21 times more likely than white teenagers to be killed by the police. That's Tamir Rice, that's Antoine Rose. A Black person is killed every 40 hours in the United States. That's Jonathan Farrell, that's Corin Gaines. 1 out of every 1,000 Black men can expect to be killed by police over their life course. This is Tamir Rice, this is Philando Castile, these are real people. Mark Heckstra, an economist at Texas A&M University, has attempted to decipher the role of race in police officers' use of force by comparing responses to emergency calls. Based on information from more than 2 million 911 calls in two US cities, he concluded that white officers dispatched to Black neighborhoods fired their guns 5 times as often as Black officers dispatched for similar calls to the same neighborhoods. So just for your information about some of the disparities that exist. Well, since this is a symposium about Breonna Taylor, let's talk specifically about Black women. So Black women comprise 13% of the population of women in the United States, but we represent 20% of women killed by the police. And nearly 30% of us are killed while unarmed. Further, about 36% of women killed by police since 2015 were killed in their homes, like Breonna Taylor. It is a troubling pattern of Black women's killings being justified as simply caught in the crossfire. Just as in every facet of every institution in this country, we, Black women, are overlooked. For example, while the founders of the Black Lives Matter movement intended the model to encompass all Black people, regardless of gender, regardless of sexual orientation, a study conducted with a team of researchers at the University of Maryland found a gender discrepancy in how the message of Black Lives Matter played out when it became a hashtag on Twitter. A collection of 31 million tweets generated between August 2014 and August 2015 on Ferguson after the killing of 17-year-old Missouri resident Michael Brown were analyzed, and findings indicated that opposition, or rather opponents to police violence, used hashtags for multiple reasons, one of which was to name Black people killed by police. However, of the nearly 300 phrases used as hashtags collected, not even one named a Black woman or a Black girl. It's also worth noting that beyond the gender differences in tweets that were analyzed, the level of public outcry about Breonna Taylor's murder also points to differences in how Black women's encounters with the police are perceived by the public. Okay, let's talk for just a few moments about what all of this means to the general public outside of Black women. What about policing and racial trauma? What is this and why should we care? Well, American policing, with its focus on racial profiling and racially biased enforcement strategies, regularly inflicts trauma among Black Americans. The term cultural trauma is used to describe the relentless effects of systemic oppression, discrimination, and racism on the mental and psychological health of communities of color. Due to the United States' burdensome and overwhelming history of discrimination against minority groups, racial minority communities often experience shared trauma, which is transmitted collectively and intergenerationally over time. This is especially true for Blacks in America who endure routine, systemic oppression, and chronic exposure to racism daily. Due to the persistence of racism in the United States, Black Americans live against the backdrop of unceasing cultural trauma that is continually aggravated, reinforced, and reintroduced. Research even suggests that continual exposure to such trauma can affect DNA structure, adding a potential biological factor to the mix such that cultural trauma comes to reside in the flesh of Black people. Unlike other recognized cultural traumas, however, cultural trauma often assumes a two-tier posture, with one model emerging as more active or pronounced than the other, though both models emerge routinely and are considered commonplace. In its more latent form, what is known as background cultural trauma acts as the backdrop to our everyday life as Black people. It is the devaluing that is implanted in the very fiber of our society in the form of deep-seated systemic racism and is largely discoverable as daily mini traumas. The second type of cultural trauma, or cultural trauma from the routine, as has been coined by Dean Angela Onwuachi-Willig, label, it suggests that even though Black Americans live with certain amounts of trauma, it's possible to experience an increased traumatic episode triggered by what is expected or triggered by what is simply viewed as routine. Three elements must exist for cultural trauma from the routine to materialize. And while she has used this in terms of history to explain cultural trauma from the routine of the routine in cases like Emmett Till and things like that, I'm suggesting that these three factors exist today and they're harming our communities in ways that we're not even specifically aware of. So three elements must be present for cultural trauma from the routine to materialize. One, an established history or accumulation of the routine harm for the trauma group. Two, widespread media attention, usually based on preceding events that brings regional, national or international attention to the occurrence of the harm. And 3, public discourse about the meaning of the routine harm, which consists of public or official affirmation of the subordinated group's marginal status. When all 3 aforementioned factors converge, the ongoing backdrop cultural trauma narrative widens and works to publicly re-traumatize the group in question, such that we are reminded by the exposed shame of highlighting our subordinate status that we've not yet won society's respect, nor any of its attendant rights and privileges. For Blacks today, cultural trauma from the routine is actively occurring. It's abundantly clear today that all 3 factors are present for creating cultural trauma from the routine. First, the history of discrimination against Blacks in this country is robust and well documented, and we have learned to cope with and have come to expect discrimination. Second, the recent killings of Breonna Taylor and countless others have engendered incredible national media attention, reminding the entire country of the disregard that the police have for Black bodies. The third factor requires that there be public discourse about the meaning of the routine harm. This public discourse can occur in many venues, including court proceedings, including protests. Surely there are active movements to eliminate racism and bias in all its forms throughout the country, which, though aimed at alleviating oppression, simultaneously work to remind society of the subordinated position Blacks hold in the United States. The summer of 2020 disrupted the daily background cultural trauma that Black Americans face and thrust it into the spotlight in a way that is both welcoming and highly re-traumatizing. The cultural trauma that Blacks must suffer from the routine experience of police brutality and police-initiated killings is more than debilitating. It is quite simply exhausting. So cultural trauma is a cognizable pain that through targeted and deliberate measures can be successfully interrupted. It must be noted that the change sought is not only for an end to police killings of Black people, that is but the impetus. The change sought is an appeal for the abolishment of institutionalized racism. That can begin by reforming, in this context, the police and the punishment system overall as a whole. The integrity of the entire criminal justice system depends upon these types of reforms and this type of change. And I'll give the rest of the time to my next panelist.
I think I'm next. I want to offer my thanks first to Blanche Cook, who I've known since she was a law student, to the others who made this conference happen, the moderators, the technology people, and all of the individuals who helped in some way in putting this together. I'd also like to thank my esteemed panelists, and finally the viewers who are taking times out of your busy lives during pandemic to hear what we have to say. So I've been a police researcher for the last 25 years. And you should know that there's a long history of police research. Since the 1930s, there have been systemic efforts at police reform. There have been commissions, there have been studies, there have been hundreds of millions of dollars spent on fixing the police. And sadly, we're not even close to there yet, as events around the country show. So I'm going to talk a few minutes about recent efforts to reform police practices, and I'm going to say a couple of things about what I think of these reforms and what, given what we know about police, are likely to happen in the wake of such reforms. All right, so I'm going to start by talking about the rest of the country and not reforms in Louisville, and then I'll circle back a little bit. So first, in the wake of George Floyd's murder, there were cities and states around the country that attempted to change the way the police operate. the first way they did it was a reflection on the events that we saw in Minneapolis. So a restraints on chokeholds, and also a restraint on the use of tear gas. And this was in response to law enforcement officers' response to protesters and the use of tear gas against peaceful protesters. And the first thing I want to say about these reforms is they happened very quickly. Floyd was murdered on May 25th. Within 2 weeks, we saw reforms. One of the most high-profile reforms was in New York. Governor Andrew Cuomo signed legislation banning chokeholds and repealing a decades-old laws that sealed public records of officer misconduct from the public. So this happened very quickly. This was a big problem around the country. Officers were accused of misconduct, and then the records were sealed. There are many jurisdictions that have this form of legislation. There were also chokehold bans that took effect in Connecticut, in California, in Minnesota, in the cities of Phoenix, Houston, and Seattle. And these were very quickly. These are the changes that happened just within 2 weeks. There were also really quick changes in the rules regarding body cameras. And one of the things that I want to say about body cameras is that there have been lots of difficulties getting police officers to use body cameras. They're equipped with body cameras, and we have to tell law enforcement officers to turn them on. So they're wearing in, we have to say, hey, you need to, it's the rules that you turn that camera that you're wearing on. So in Seattle, in Houston, in Denver, there were changes that require law enforcement officers to turn on their body cameras. In Connecticut, the problem was that law enforcement officers decided not to wear them. So they were required to wear the body cameras. And one of the things I want to say about body cameras, and this is reflected both in my own research with body cameras and other research with body cameras, law enforcement officers like body cameras. I've talked to lots of cops and they like them. They believe that the footage that is shown in the context of body cameras is going to exonerate them. And this gets to an important issue with reform and law enforcement officers. Part of the reason reform is so difficult with law enforcement officers is because law enforcement officers believe themselves to be correctly enforcing the law. They are quite righteous about the fact that they are doing the right thing. So it's really hard to get them to change. So part of the reason they like body cameras is they think that the body camera is going to show that the law enforcement officer was engaged in appropriate behavior. This is not always the case. We see situations in which law enforcement officers are caught on body cameras engaging in behavior that they are actually trying to cover up. But this is a problem with reform. All right, I'm going to move to changes in Louisville. This summer we had Breonna's law, which banned no-knock warrants, required body cams when executing searches, and all sorts of other regulations when executing a search. And I can talk a little bit about these during the question and answer, but this came also within the 2-week period that I was talking about the other reforms occurring. That law was signed on June 12th. So also in the, so there have been other reforms agreed to as a result of the settlement with Ms. Taylor's families. It is fantastic and was largely unprecedented to have secured reforms as part of this settlement. It is very unusual to have secured this type of movement in the context of a settlement. And I will speak specifically to a couple of the reforms that were secured. First, there were measures giving officers housing credits to live in the neighborhoods that they policed. Officers, the assumption being that officers who lived in the neighborhood wouldn't have made the types of obvious human rights violations the officers did in this particular context. I want to raise a couple of issues, both based on my experience with law enforcement officers and also with the demographics of the police force. This is a police force that is 82% white. Ordinary people who are white generally don't want to live in even mixed neighborhoods. I've written a book on housing segregation, and the decades of research that's been done shows that housing is still very racially segregated. Whites, even who aren't law enforcement officers, don't even want to live in mixed neighborhoods, let alone in neighborhoods that are predominantly African American. And this is largely, you should understand that this is largely by choice. It is not by economics. The way housing scholars do this research is they show individuals' neighborhoods, fictitious neighborhoods, pictures of neighborhoods, and they say, all things being equal, meaning these neighborhoods only differ by the composition of the neighborhood, and whites still choose to live in neighborhoods that are predominantly white. Law enforcement, there's another layer for law enforcement officers. The law enforcement officers that I studied and with whom I've spoken, even law enforcement officers of color did not want to live in neighborhoods that they were policing. They feared that their safety was going to be at issue if they were shopping in the grocery store and they saw an individual that they had arrested. I heard this time and time again from law enforcement officers that they sought to live in neighborhoods different from the one which they policed. So I would be really surprised if the economic incentive provided would encourage law enforcement officers to change their generalized behavior. The second reform that I want to talk about that was achieved as a result of the settlement is that the requirement that only high-ranking commanders approve search warrants request. Any changes, and this applies in general to any changes to search warrant procedures. Law enforcement officers, even when they're not supposed to be carrying out law enforcement searches in a particular type of way, end up doing that. So for instance, there is research that shows that even in Louisville, that no knock warrants and warrants where there is a knock and an announce requirement are carried out in very similar ways, which is, from a constitutional perspective, is quite problematic. There's also the issue that one wonders how the best way to punish law enforcement officers. There was punishment built into this particular solution, given law enforcement training that suggests, long training that suggests law enforcement officers would not receive any sort of punishment for violating warrant requirements. I want to stop there because we, with the reform, there are other reforms, but we have lots of ground to cover here, and I'd rather save time for the moderator to ask us questions. So thank you.
Thank you. And thank you to my co-panelists and to those of you who are spending this Friday afternoon with us. My name is Lanita Baker. I am one of the attorneys that have the honor of representing the family of Breonna Taylor. Before I became a civil litigation attorney, I practiced in criminal law substantially. I did 5 years as a criminal defense attorney, both as a public defender and in private practice. And then I switched sides and became a prosecutor. I also, in Kentucky, in Louisville, Kentucky, I prosecuted at the Jefferson County Attorney's Office. That office also represents the city and its agencies in a civil capacity. So I spent the year advising Louisville Metro Council. And so I do have a lot of familiarity, not just from suing cities, but from practicing, being a prosecutor, working hand in hand with police officers, and seeing firsthand how policing differs when they're talking about African Americans. Even, you know, in the past few days, if you followed along with in the Breonna Taylor case, with things that are still going on, we've seen Sergeant Mattingly give an interview, and in one he says, you know, we don't racially profile, we criminally profile. Well, when he says that, and he says, you know, if someone doesn't look at, you know, if we pull up next to a car and they don't make eye contact with us, you know, that's suspicious to us. That puts us on suspicious. I'm sure when he said that, he didn't say if Black people don't give us eye contact, but when we see officers use that, oh, they looked away, they looked nervous, they're referring to Black people. They don't use that same terminology when they are referring to white people. And we know that because it's documented through citations, through arrests, through police incident reports. It's profiling, no matter how you want to do it. It's racially profiling. And it goes back to, I forget which sister was talking about it. I think it was Jalila who talked about the trauma. The reason we look away is because of the trauma that we've come to have. You know, you don't want to, we are afraid of police officers. And with good reason. You look at those percentages and the disproportionate rate that African Americans are violated by police, whether it's killed, whether it's other ways to excessively force, the way that they've dealt with protesters. We've seen a lot of protesters here overly charged in Louisville, Kentucky. And so I'm not gonna go through a lot of time because I think my co-panelists have done a good job talking about policing and race. And so I don't want to go into that too much, but I do want to respond to some of the Ms. Bell's things about the reform that we negotiated as part of the settlement. The housing credits, only time will tell if people will take advantage of them, but it wasn't so much it would generally change the way police, what our thought process was, and it comes from not necessarily our beliefs, but what you hear people when they talk about community policing and the rationale that goes into community police. When you know people, even if they are of a different race, they are less likely to be a threat of you. So if police officers live within the communities that they police, then the people around them are less likely to be a threat. The problem in Louisville, Kentucky is a large portion of our police department lives nowhere in the city, not just racially mixed neighborhoods. They don't even live within the city limits. They live on the outskirts of the city. So Louisville, and then Louisville itself is very segregated. But you have, I also represent 2 families where last year, 2 years ago, we just hit the 2-year mark of that. Louisville Metro Police had a policy, people, places, narcotics. That's what they called it, people, places, narcotics. Black people driving nice cars in the west end of Louisville, which is predominantly Black, would be pulled over and they would be searched for drugs and weapons. Their own statistics, 1 out of 10 of those stops would turn up anything. And sometimes that one thing that they got would be marijuana, something so minor that the prosecutors here are not even prosecuting marijuana, actively prosecuting possession of marijuana cases. So, the police were engaging in this activity that became very controversial, that there are a lot of pending lawsuits now for racial profiling to not end any type of violent crime. Because what happens when you pull someone over for that pretextual stop just to get a search is the ones that you are finding guns and large amounts of drugs on, they're getting thrown out because it's a violation of the 4th Amendment. And so I think when people who want to give the benefit of the doubt to police officers, and again, I'm a former prosecutor, I know most police officers are good people, and I would agree with that. But at the same time, we really do have to change the way that we police, because we're not keeping people safe when we engage in this behavior at all. In fact, it's making it more dangerous, because you do risk cases being thrown out because our rights are being violated. But again, my co-panelists did such a good job leading into this. So I'm excited to answer questions, Ms. Marshall.
Thank you for all of your opening remarks. We can move into the first question. So some of you touched on this, but what are the broader issues with policing in the criminal justice system that lead to instances like Breonna Taylor, these police shooting cases?
I think one thing, and I could have said that in my opening too, you don't end up with a Breonna Taylor if she was not a Black female. And I say that because, one, there would not have been a no-knock warrant sought for someone with so minimalistic of a suspected activity. Again, our position is she was not engaged in any criminal activity. The things that have come out since that search warrant was had, and the lies that were put in the affidavit to get the search warrant would substantiate our position in that she was not engaged in that activity. But even if someone did have that, there would not been a no-knock warrant sought. That search warrant would not have been executed at nearly 1 o'clock in the morning if she was not a Black female. Even when you look at Jamarcus Glover, the main primary target of the warrant, that warrant would not have been executed in the middle of the night in a white neighborhood either. And so the way that we perceive that police officers perceive African Americans as a threat led to what happened on March 13th, a search warrant, it's a simultaneous search warrant, so multiple search warrants executed at one time, such a huge police presence for low-level drug dealers. So even when we talk about Jamarcus Glover, he's not, Al Capone. Like he lived in the houses for which they call trap houses. You don't get that's not a big time drug dealer, right? And so when you use so much force against someone, it's the war on crime. We go back to the war on drugs. It are the resources that we're putting into the war on drugs against Black people, because we see, when white people began to use drugs, we went to more of let's send them to rehab. It's rehabilitation. It wasn't the let's lock everyone up that we saw with the crack cocaine epidemic. So all of it ties into race and the way that we police. And I'm sure my esteemed co-panelists can add on to what I began with that question.
If Oh, I'll go ahead, Jaleel. You can go.
Okay, okay, thank you. I'll add on just very briefly. I mean, part of the issue, and we've been talking about this all day, is this idea of inherent Black criminality and a basic disregard for Black bodies as valuable, Black people as actually people, as humans. And when you couple that with kind of an institutionalized belief that the police are correct and that they are all worthy of carrying a gun and a badge, then you have a very dangerous combination for Black people, and it leads to these types of outcomes. And so, I mean, what's required, it's a Herculean task of completely dismantling our entire system. We heard today from Professor Bell that police believe that they're acting in accordance with the law. We heard from Professor Jefferson Exum that indeed the Fourth Amendment doesn't give us the type of protection that we require. Neither does the 14th, because of a requirement of finding discriminatory intent. And so we're in a situation where the entire system has to be rethought if we're going to make any type of progress towards protecting Black people from police-initiated killings.
And I'll just add to that we have a whole system of laws and legal procedures and court decisions that allow for the racial bias that Ms. Baker talked about, that Professor Jefferson Bullock just talked about, to sort of be shielded in our system. And so Ms. Baker just talked about this, but I'll just explain it a little bit more for folks who aren't lawyers, or maybe you don't, if you are, maybe you don't practice criminal law and you've forgotten your criminal procedure class. But some things like Ms. Baker talked about pretextual stops. So the Supreme Court has said in a case called Wren that it is perfectly fine for officers to have any sort of biased, illegitimate reason for stopping you, as long as they can come up with a legal one. So their whole reason for stopping you in the first place could just be like, I don't like the looks of you, right? I've just kind of heard on the street that you're not, you're not a good person. And so race has everything to do with this, with these perceptions. And so if officers can just say, but I'll just wait, I'll find my pretext. So the time that your tail light is broken, or you made a big wide right turn, or you didn't fully stop at the stop sign. Okay, that's my legal reason. But the real only reason why I was looking at you is because of my feelings about your criminality, which has a ton to do with your race. So that's, pretextual stops. We can talk about Terry stops and frisks that officers just need reasonable suspicion to go up to someone, to actually detain them, question them, and search their person. And reasonable suspicion is, we've talked, this came up on past panels, that probable cause is a low standard. Reasonable suspicion is lower than that, right? It's just saying that, I can, again, articulate some reason for doing this. So you just hide the race part. You don't mention that, but you can say things like you live in a high crime area and made furtive movements, right? This is you looked away. But that has everything to do with race and how, Black people distrust police for good reason and how they react. And so it puts the onus on the individual to make sure they don't do anything that looks like it could be construed as suspicious behavior, right? Which is just too much for people to bear. It just is. Right. And so there's stops. I could go on, war on drugs, we could add in sentencing, but we have built a system that allows for racial bias to flourish and to hide and to go unchecked. And that's really the root of all of this.
And even if the law was favorable, and my criminal procedure students are always surprised at how utterly and completely unfavorable the law is to you as a citizen, and the ways in which the vast majority of situations in which law enforcement officers are making stops, that just take car stops, they can stop you for nearly anything legally. Our traffic code is highly regulated. So even if this weren't enough, right? And it's huge, right? Even if this weren't, we have to pay attention to who is doing policing, who runs policing, right? The role of unions, the ways in which police procedures are organized, And all of those make for incredible problems because, you know, I mean, speaking just about Louisville, right? You know, there are very few Black cops, right? Black cops are less than 20% of the entire police force. And I want to sort of agree with Ms. Baker about the value of having Black cops in a neighborhood. Yeah, that matters. Because one of the things that all of the defund conversations miss is that Blacks are victims of crime. They really are victims of crime at huge rates. And they need someone to investigate and catch perpetrators in that context.
So that was perfect, a perfect segue into my next question. Recently, we have heard a lot of discussion surrounding efforts to abolish the police and the prison system. So I was just wondering if you all found these arguments persuasive and then what you just thought about them in general.
All right, I want to talk first because I don't want it to seem like I'm not in the defund camp. I believe in sort of limiting the use of law enforcement officers because the people in the defund camp, the vast majority of them are not talking about getting rid of police. They are talking about limiting the reach of policing and policing practices. And I think that absolutely needs to happen. I, for instance, do not believe that law enforcement officers should be making the vast majority of traffic stops. You should, as a couple of places in this in the US have done, and also in Canada, Toronto has done this. I think that you should not make investigatory stops at all unless you have a safety reason to make that stop. And in Fayetteville, they pulled back from making these sorts of stops, and they saw increases in relationships between law enforcement officers and the community and no difference in crime. So I don't think that there's a reason to make these stops, and they should stop. Until police officers can show us that they can make stops without bias, without racial bias, which no police, I will go out on a limb and say no police anywhere can, systematically, right, across police departments, then, you know, they don't need to be making investigatory stops, only for safety reasons.
I am team reallocate funds because I think that's what the defund police, when you really look at it, that's what they're seeking. And like Professor Bell stated, you don't need officers to respond to everything that they do. So 100% social workers need to be employed more. And I think that that's social workers, not that are employees of Louisville Metro Police Department, because you want some independence there. You want them to be able to do their job effectively as a social service clinician and not be persuaded by the officers who are with them. Now, do I think that officers should be, if it's a dangerous situation, yes, you should maybe have officers dispatched with them, because I wouldn't want social workers to be put in any volatile situations that they're not equipped to deal with either. So police officers right now are being sent to do things that they aren't equipped to do. They're not mental health professionals. So I am in favor of reallocating funds. I do think that, you know, and I speak more so to Louisville because that's where I am. I don't do a lot of research outside of Kentucky. Officers do deserve to be paid more. good officers. I don't think it's a matter. So, but I don't like that so many of the funds that police departments get. Louisville has a Louisville Metro Police has a $200 million police budget. So much of it is spent on militarization of the police, SWAT vehicles, the riot gear that they're getting, that they've been having. This is the first year that we've had, the amount of protests that we have. And a lot of times they show up in the riot gear and it's not necessary either. So we see the escalation, police officers escalating the level of protests. A lot of the protests here have been peaceful. And so that's where the money is going. So can we use that on salaries, again, to divert towards social service, clinicians to be used? I think that once we get there, the thing that we talk about police reform, we can issue all the police reform in the world, but we really do have to it's reform, but also ridding the mentality, the thin blue line. There's a mental component and a culture, police culture, that we really have to talk about if we're going to move past. And because reform is great and we need it, that we negotiated reform, hopefully, so to prevent what happened to Breonna from happening to anyone in the future. But again, when I see interviews like that of Sergeant Mattingly, and that he goes to say, yes, what happened to George Floyd was terrible, but then later he goes, oh, well, he died of a drug overdose and he wasn't a model citizen. We got to get rid of that mindset from police departments. And he's a sergeant, so he was a commanding officer. He's training people. All the reform in the world, like I always say, if you have some type of exception, police officers are equipped for finding how to make whatever they do go into that exception. So yes, reallocating funds. I hate the word defund. That's why I won't use it. But reallocate the funds to where they can best be used. But you also have to change the mindset.
I'll jump in here and say, I agree with saying that, in the meantime, we should have some reform. But I think, as Professor Bell pointed out, decades have taught us that little reforms to the existing police institution doesn't go very far, right? We could reallocate funds so that we're not spending so much on policing, but we're spending money on other institutions like mental health services and drug rehabilitation. We can do that. But as long as the institution of policing exists in its current form, we're going to continue to see the issues that we have faced since the beginning of policing. And so, most of my work is really in sentencing. And so I'm a sentencing scholar. And in the work that I do on sentencing, I'm always starting from the back end, which is, what are our goals, right? What do you want to accomplish? So in sentencing, if you're trying to say you reduce crime or deter criminal behavior, you say, okay, if that's my actual goal, am I using the tools that actually get me there? And when it comes to sentencing and incarceration, the answer is almost always no, right? To lock folks up, almost always not actually working. Because Ms. Marshall, part of your question was also about incarceration in prisons. So it goes there too, but we can say the same thing about policing. What do we have police for? Like, what are our goals? So it feels scary to say defund the police. It feels scary to say abolish police, right? Because you're like, well, what else will we do? Well, that's for us to decide. Like, what are we trying to protect ourselves from? If you feel like I need someone to call if I'm in imminent violent danger, we could have a group that you call when you're in imminent violent danger, right? We could limit it to that and not have, sort of this bigger structure of police that goes into all these other things, right? If you're saying in my neighborhood, I think that there is an issue with buying and selling narcotics. And some of this is getting into sentencing and decriminalizing narcotics as well, which I think has to be, a piece of all of this. But, if you're saying that's an issue because it's somehow damaging your community, is it leading to violence? Is it leading to homelessness? Is it leading to, what is it leading to? And what are you actually trying to fix there? Because we can have other professionals who come into play to deal with those issues. right? And so we've made everything about being a crime, which then we've said, well, that means we have to have police to deal with it. And I just think that we can be more creative than that. If we think about what we actually feel like we need in our everyday lives. And so, you know, I don't know how we get there because there's so many things in the way. You know, you have police unions, you have a lot of people who, when you think about like the prison industrial complex, you have a lot of people with money stakes in that. I don't know exactly how we get there, but I think that we should be brave enough to talk about it this way and to push ourselves to really think about what are we trying to accomplish? What do we think we need? And to start saying, so you know what, we don't need that. We can, you know, we can stop that. We don't need that. And then maybe bit by bit, we sort of get ourselves to a better place.
So in terms of what we don't need, one of those things might be the prison system, which we could talk about in another conference, and we can even talk about it a little bit today if you would like to. But back to the question of defunding the police, when I hear the term defunding the police, because it appears in various forms, what I hear kind of as an underlying theme is reducing the contact that the community has with the police, kind of as a basic theme, which I think is a very good thing for all of the reasons that our panelists have given it. There are some services that require that police do not have to perform. They don't have to perform. There's no need for them to come in with a gun to perform those services. We can perhaps have other agencies, other groups perform those for us. But, you know, kind of on a different scale, there is, and I write about this a little bit, there are some criminal justice theories that are steeped kind of in retributivist approaches, which say things like the system, the criminal justice system cannot work unless the people are convinced of its efficacy. We have to believe, right, that it works for it to work. And as soon as we stop believing that it works, then it loses its value. People stop adhering to the law. Folks don't pay attention. They don't believe the process is fair. They don't believe the substance of it is fair, and they stop acting accordingly. And I think that the more we have these types of encounters, because even now, while Professor Jefferson Exum showed us some of those stats about how people feel about encounters with the police, those stats are changing since the summer, and she acknowledged this since the summer, this summer of 2020. Those stats are changing. Even people who are not folks of color starting to think, wait a minute, this doesn't seem exactly right. And so the more we go down that road of people not having confidence in the system, the more the system begins to lose its value. And I think that we should care about that. And I think that that's a reason to go in and consider a radical change. And I know people don't like the word defund because it sounds somewhat radical. It sounds like perhaps anti-police. It's not that. It's more like it's pro-community. It's pro-democracy. It's pro-fair justice. And so those are kind of my views on that.
Thank you. So we're going to kind of shift gear here, and I'm going to ask, are police shooting cases on the rise, or is it a thing of where there's heightened awareness of these incidents? There's just your thoughts on that.
I'll say I don't think we know. Because on the rise, I mean, you know, we have to think about what time frame are we talking about, and we don't have any centralized requirement for keeping track of police shootings. And you know, these are some of the things that have been called for really since you know, several years ago. We can go back to like the Michael Brown case. We can go back even further than that. So, and especially if we're talking about over really our American history. We don't really have those numbers, right? But definitely what we have is more of an awareness through social media, through just the way that we connect nowadays. And I think this ties into Professor Jefferson Bullock's trauma point, right? Is that we are seeing this over and over. And so I almost want to say, I mean, this is going to, maybe I should be careful about how I say it, but I almost want to say it doesn't matter if they're on the rise. Now, I mean, it matters for individuals' lives. Of course, we don't want police killings to increase, but they have been prevalent throughout American history. So we are already at a point where they're more than what's acceptable, right? And so, so I think that you know, we should be gathering this data. We should know. I'm all for transparency. For again, it goes back to thinking about goals. You know, we have to have our data, but I think, you know, wherever we are with police killings, it's too much, and the fact that it is in our faces now. it's good in the sense that it is bringing more multicultural awareness, I'd say, to what Black people have known, for their whole lives. But it also has that downside of re-traumatizing us without moves forward. And I think that's really one of the most painful parts of Breonna Taylor's case, is that there's so many of us who saw ourselves and thought like, wow, like at the end of the day, the one charge is going to be not even having to do anything with her life, to be like, wow, you just didn't care at all, right? The system doesn't care at all about me. I think that, it's that re-traumatization. And so, so I know that doesn't really answer your question, but it's the point I wanted to make, which is, maybe they're on the rise, maybe they're on the decline, right? But they're too much. And we need to do something. If we, for all of those who say Black Lives Matter, this is the place to show it, right? Show and prove right now, with doing things that might seem uncomfortable, that might seem like they're pushing you out of what you think, you would have ever been okay with. But ask yourselves, why are you okay with how it's going right now, right? And if you're not, then things have to change.
And I would agree with Professor Jefferson Exum. We don't know if they're on the rise or not. We know we have so much more access to it, whether it's through social media, the body camera, not even body camera, but cell phones, bystanders getting video footage. And I think that's one of the things that as we move forward, and that's probably later, but I know we're getting towards the end, is we really do have to push for it to be mandatory for officers. Yes, we want less interaction with the community, but when you are interacting with the community, it needs to be mandatory that you activate your body camera so that we know exactly what's going on. It's not a he said, she said. One thing I do think as we get further in what we're seeing now is, at one point, people just defaultly believed everything the police officers said. Now with so much technology and us being able to see the interactions, officers don't have that benefit of the doubt as much as they did before now. So I think it needs to be mandatory that you have on not just have it on, but activate your body camera, because they were on, but they don't activate it. So activate it. And if you don't activate it, there needs to be some significant penalties. And that's where, it's come up a number of times. We have to really limit the amount of power that police unions have, that these contracts prevent, and state law prevent officers from being held accountable. Because so as long as I talked about the mindset, the culture, as long as they continue, their behavior goes unchecked because they know, oh, well, nothing's going to happen. I may be suspended a day without pay, or 5 days, worse. They keep their jobs. They get to go back out there. They're not going to be criminally charged. What's to stop them from engaging in the same behavior? So.
You know what, too? I think that's right. We don't know if they're on the rise. But when we talk about police culture, I'm not so sure that we all really know what that is. I'm not sure that we do. We know it has to change. We know that they're taught to, in some instances, to protect their lives over others who might be armed, or who they think might be armed. But I think part of our problem is this secrecy. We don't know what that, it's almost an indoctrination. We don't know what that looks like. We don't know what they're taught, exactly how they're taught to behave in the streets. And I think that's something we need to spend a little bit more time investigating, so that we can work to dismantle that as well. I'm not so sure that we really understand when we, and that's not, I mean, I don't understand either. When we really say we got to change the culture, I'm not sure we really have the inside information as to what that culture is. And I've seen many a person go into the police, go to become a police officer and radically change their views on even kind of public safety and types of people. And I wonder, what were you taught? What precisely did they tell you in the police academy such that you came out so differently?
One of the things that's been written about police culture that hasn't always been the case, that is relatively recent, is that police are taught to be afraid of people. There's a lot of fear that police officers are trained, that is trained into police. They're shown videos, often in the academy, of rare instances of law enforcement officers being ambushed when they stop someone, you know, for a traffic infraction, some sort of traffic infraction, and they're told, listen, you know, you need to go home at the end of the day. So you need to be ready for anything to happen whenever you stop someone. This is often called the warrior cop mindset. And it is an important part of the ways in which law enforcement officers are trained. And it really exacerbates the relationship between law enforcement officers and citizens if, when I'm stopped because I have a taillight out, he thinks there's a possibility I might pull a gun on him. When you are stopped, and this is not how policing used to be. Studies of police in the 1960s show that law enforcement officers paid a much closer attention to realistically what was happening in a particular situation. And this is something that's happened over the last 20 years.
Can I add just like an anecdote to go with that? So this again is back in 2014, just after Michael Brown was killed, and there was a lot of discussion then, just like we're having now, about these issues. And I was invited to speak to a group that involved police officers. And so I was on a panel with police officers. There were police officers in the audience as well. And one of my co-panelists was an officer who was really hailed as being a huge part of the community. The community loved her. She really got to know people. She was, all the things that we talk about when we say like, oh, we want the officers who are like invested in the community, know folks that are community police, that sort of thing. She was that. And she was trying to explain to me sort of her point of view on how, sometimes, how we just have to understand the stress on police officers. And she said something very similar to what Professor Bell was saying. She said, when I get a call that says, something is amiss, or when I'm stopping someone and going up to that car, I don't know what I'm going to walk up to, right? I don't know if the person, when I walk up to the car, is going to see me and just shoot. I don't know if that person is going to, try to fight me. I don't know what's going to happen. And so I have to be on guard. And she said, so my adrenaline is going. So you just have to understand, officers, that's what we're feeling. And she was saying that to make me sort of see her point of view. But what really happened is that made me more terrified, because I was like, what if it's me who's in the car? It's my husband, it's my nephew, it's my son, right? Who doesn't know that this officer now is coming up with this heightened sense of, I'm just fearful and I don't know what you're gonna do. Who is, they're the ones who have all the power, right? They're the ones who have all the decision-making power there. And so the individual who's coming up, who's now gonna be on the receiving end of that, any little thing that they do, right, could possibly be the wrong thing, be interpreted the wrong way. And I was like, well, at some point we have to say, the professional side of this has to be dealing with these issues differently. It can't be the lay person who has to act a certain way to make sure that they don't, accidentally frighten the trained police officer. And I just, that stuck with me. And it really goes with what Professor Bell was saying, that it just, we have to kind of rethink our expectations and our the standard that we hold police officers to. And I do think that comes, if we're going to keep going down this policing route, it also comes with supporting police officers and being able to do that. Why don't you have proper backup then? Why don't you have other ways before you engage with someone? All that sort of stuff has to be a piece of it if we keep policing this way. But that just really stuck with me. I thought it was a pertinent point here.
Thank you for that. So I'm going to ask two more questions, and then we're going to try to get a few audience questions in. So this question is, should we demand more from our policymakers to eradicate the issues seen within the criminal justice system? And then what would those demands look like, and how should people go about making them?
I think we definitely have to demand more of our policymakers. And when I say policymakers, I know we talked just last night, our Metro Council voted to limit or the times that Louisville Metro Police can engage in use of force. And they gave them mandatory guidelines, and officers weren't happy about it. It's like, you're legislating what we need to put in policy. Policy should be flexible. I'm all about legislating, like make it law. And so I think that, so when I say our policymakers, I say our lawmakers. And I think you have to start with some of the accountability measures, being able to hold officers accountable for bad behavior. I could go on and on about it, but I'm not. I'm going to let my co-panelists join in. But yes, and I would focus on accountability and measures.
Part of the difficulties is getting lawmakers or elected officials to stick to what they initially say they want in a measure, because lawmakers receive lots of pressure from unions. I could tell you tons of pieces of sort of changes to force requirement. In Minneapolis, for instance, there were proposals to change their use of force more than a year ago, right? The way that law enforcement officers could use force. And the unions went after lawmakers, and those changes didn't end up happening. So if we put pressure on legislators, then we have to put a lot of pressure on them and remind them continually, yeah, we're still watching you. Yeah, this is what we want to see happen. And we will vote you out of office. We will really penalize you if you don't do what you said you're going to do, because a lot of times things get lost because of pressure, particularly from unions.
And that's why you have to vote too, because there's more people who are at least in metropolitan cities, there are more people who are pro-reform than not, but they have to see those people that are out there protesting. Politicians, elected leaders have to see those register to votes. We outnumber those in the police union.
Yeah, and I echo all of that. I think legislators will only act if they feel that there's public pressure to do so. So a lot of that responsibility is on us. It comes with voting, but it also comes with the kind of conversations that we have with lawmakers, with candidates, right? Where it has to be a big enough issue such that it makes sense for them politically to actually respond. And that requires us educating ourselves and organizing ourselves around these issues, right? So that's a piece of it. I agree that accountability measures are hugely important. Engaging community voices, this comes from my point of view that we ought to be starting with what are our goals and needs. And so I think with kind of our institutional policing structure, it's been one that tells communities what they need. That, here's how we're going to come in and do things. This is the order that we're going to come in and sort of, impose here. But it doesn't have to be that way, right? You can have community voices about what they need, how they would like to have support of law enforcement, where they don't want and need support of law enforcement, right? We can make more room for that. And so I think the lawmaking is a part of it. But if there's not an openness to really thinking about what the goals are and what the community needs are, then we'll find ourselves in these same places.
I used to be a lawmaker in my former life. Before I started doing this work, I was a state rep in Louisiana. I represented parts of uptown New Orleans and parts of Central City, for those of you who are familiar with that area. And what everybody's saying is right. It's very difficult for an elected official to ignore something that's so in their face. So organizing matters. At the same time, I can say this because I was one. Elected officials are always concerned about what moves will get them reelected. So while people's heart may be in one place, their mind is also thinking, can I afford to do this? Can I Is it what my constituency wants? If I do it, will I be reelected or will I lose my seat? Because once you have those seats, it hurts to give that kind of power up, and that's just the truth. And so I think you have to start with those who are, in your respective areas. Find the strong ones. There are many who you've elected who are strong and courageous. Find them and encourage them to be the ones, to be the champions, to kind of lead the cause. And then they can do whatever dealing is required, whatever horse trading that politicians do to get their measures passed in the legislative halls. But that's kind of how it works, because everybody who they work with, who represent other constituencies, is not going to see things the way that perhaps they would. But there are always ways where they can work with people, and you give something, I give. That's just kind of how it works in terms of trading votes. But I do want to agree. So that's just kind of from a practical point of view. I do want to agree, though, with Professor Jefferson Exum. I think she talked too just about kind of the way we challenge the system and when we think about it. And I think those of us who modestly call ourselves thought leaders, who we are scholars, people who like to sit around and write about the changes. And I know a lot of us also do advocacy too. Most of us in this room do. We don't just write, we get out and work too. But it's time to really do some very serious organizing and help our community folks and give them some of the ideas that they may be able to take and run with. Professor Jefferson Exum and I have a very different, together, we have kind of different approaches. And she talked about some, about how we even view policing perhaps as punishment, something she alluded to earlier in her talk. That came from her, and we're together talking about kind of how that works with defunding the police. And I think it's those types of just radically different ideas, radically different views that those of us who are scholars need to work with community organizers on to make sure that these various changes are implemented and that they have the right type of foundation that they need to be successful.
So going off of that and wrapping everything up, what role can law students, undergraduate students, or just the public at large play in ameliorating the problems of race and policing?
Well, at law schools across the country, I think, not everyone, but many, there are movements to teach law students to be anti-racist. I know at our law school, we're maybe taking some baby steps, we're trying. And I think that many other law schools are as well. So those students who would be inclined to listen need to do that work. I always tell my students, you don't have to be the one to go out and with a picket sign and go to every protest, but you certainly do have a responsibility to change the space that you occupy. That's what being anti-racist requires. It doesn't mean that you just have an empathetic heart towards people of color. It doesn't mean that you have a listening ear, a sympathetic ear. It doesn't mean you cry with us when we cry when our babies are shot in the street. It means you do something about it. And so I think that there are lots of opportunities for students to get involved in advocacy. Many law schools have those different vehicles, those different tools for students to use. They ought to use them. They ought to use those, use the tools that are available to them now and go out and make a difference in terms of voting and perhaps organizing, but also just advocacy. There's lots of opportunities for students in the law school space.
And I also think that, again, thinking about community voices, I think we always have to be cognizant of those who have marginalized voices, who don't have platforms for speaking and moving things along, but who are very much impacted by policing and by legislative decisions. And so all of us who are legal professionals, law students who have access to institutional resources, we should also make sure that we're using our time and our voices to amplify the voices of those who don't have that sort of stage and platform. And this requires making space for them. Law students can do this. They can have forum with the community to allow people to get up and speak, and you can have an education component where you are giving people access to the law that you're learning about, right? That they don't have access to. It really is a privilege to have a legal education and to have those sort of tools that that a lot of people will never be able to access through no real faults of their own, just due to the circumstances of life, right? But who are people who are very much affected by all of this and have every right to have a voice in the process. And so I hope in whatever ways we decide to use our time and attention and efforts, that we always think about those folks who need their voice amplified and how we can be helping to do that.
2 suggestions. First, do some pro bono work in the criminal justice system. You can do it irrespective of your area of practice. Second, tell people who don't know about the Fourth Amendment what it really says. There is lots of education that you can do. I have colleagues, right? Colleagues in the greater university who don't understand that an officer can, when he stops you legally, can automatically order you out of the car. And I have seen terrible videos involving individuals who didn't understand that. So spread the word about the power of the police and what they can do with you, do to you. And also, reach out and try to help to the extent that you can.
I would echo all of the professors in this is figure out, one, you don't have to be on the front lines. I've been to a number of protests. One thing that I see, there's a hunger for people to really want to get involved, really want to get engaged, but not really being able to strategize, as Professor Exum has stated, in what are our goals, what do we really want, and then figuring out how do we get there. And I think that law students having that legal background, young lawyers, I always even say lawyers who aren't in the space, corporate attorneys, like, one thing we can do is read laws. We know we're trained to look for loopholes in laws, right? So how do we close up some of the loopholes that are allowing people to allowing officers to get away with certain behaviors? So donate your talents doing that. I know we've had several law students helping us with drafting legislation, because we're presenting some stuff to Frankfurt, in the regular session in January. But so it's just figure out how you want to be involved. It does not have to be out there protesting. I know I got an email from a law student saying, I really want to be out there, but with school and this first. So law students, the first thing you can do is make sure your grades are where they need to be. Do your schoolwork. Law school is first. Help out when you can. So I want you on this side, and the professors want you on, we want you on this side. So studies first, and then donate your talents when you can.
Well, with that, we have reached the conclusion of our program. I would ask the audience to give a big virtual round of applause to our esteemed panel. Thank you all so much for all of the insights you shared. It was truly an honor to facilitate a panel with such brilliant women. On behalf of the University of Kentucky, J. Rosenberg College of Law, I want to thank the audience for actively engaging in the Breonna Taylor Symposium, and all of our wonderful panelists for sharing their time and expertise. Thank you, Dean Mary Davis and Dean Danny Murphy, for giving us the freedom to honor Ms. Breonna Taylor and facilitate these conversations in a way we felt most fitting. Thank you to Angelica Precopa, Shante Hopkins, Alyssa Thornton, Derek Hill, Nicholas McKinley, Franklin Johnson, and Lisa Burnell for your continued support throughout this program. And thank you to Professor Blanche Cook for sharing and executing your vision of honoring Ms. Taylor. This was a wonderful event, and a lot of enlightening information was shared. Again, on behalf of the University of Kentucky J. Rosenberg College of Law, we thank you for all of your participation in the Say Her Name Breonna Taylor Symposium. Our hope is that the conversation does not stop here. Every one of us must continue to speak up, speak out, and demand change. Thank you.